Yesterday, I ended the session. I forgot to give you questions. You forgot to tell me also that, ma'am, please give questions. Huh? Just close those windows, no, so at least it will get a little cooler in the classroom. Please close the windows, no, it will get a little cooler. Okay, tell me, did you revise whatever we did yesterday? Did you revise whatever we did yesterday? Do you have any doubts in whatever we discussed yesterday? No doubts. How many of you did not even go back home and open? Let's be honest, how many of you did not even open your books? I was so freaking tired. It was like, I don't know about you guys. Huh? What? Okay, so we had done till discharge of the contract, that is discharge by breach. Just shut the door, whoever enters. Thank you so much. Keep doing that every time that anyone enters. So, we are going to start with remedies for breach. Yesterday, we had discussed what was breach. What was breach? Non fulfillment of the terms of the contract. If it is before the due date, it is what? Anticipatory breach. If it is after the due date, it is what? Sorry, if it is on the due date, it is what? Actual. Now, if there is a breach, can I say the aggrieved party will enjoy certain benefits? Yes or no? The aggrieved party will have certain rights. Yes or no? So I repeat again, if there is a breach, the aggrieved party will have certain rights. So what we are going to discuss here is what are the remedies in case of breach. Where say if I broadly say, we can broadly classify the remedies under what? Two heads. What are the two heads? One is the monetary rights and the other is what? The other rights. Monetary rights or damages, and these are what? These are the other rights. Now, what is damages? Damages means anything which is in the form of what? Money. There is a contract, there is a breach. Tell me, if in a contract there is a breach, my position goes down or it goes up? Let's say there is a contract and this contract is breached. My question is that if a contract is breached, the position goes up or it goes down? The position goes up or it goes down? It goes down. So why are damages given? To cover up this or to bring you to a higher position? To cover up this. So always remember, damages are only given for what you have suffered. You don't get damages for anything other than what you have suffered. So please remember, damages are not given to make profit. They are given to make good the loss suffered. Right? They are given to make good the loss suffered. Now, when we talk about damages, there are four rules rather, which were laid down in the case of Hadley versus Baxendale. What were the first four rules? The first rule said that any damage which arose naturally can be claimed as a right. We call them as what? Ordinary damage. The fact that there was a contract and the fact that there was a breach gives me a right to claim the damage. Irrespective of whether I told you I will claim the damage or not, we made a contract and this contract was breached. The fact that this contract was breached gives me a right to claim these damages, and we call this as what? Ordinary damage. Generally, ordinary damage is calculated either market price less contract price or contract price less market price. However, if it is not quantifiable, if the damages are not quantifiable, then in that case, damages are given in what form? It is reasonable damage. Then moving on to the next one. What is the second one? Special damage. It's a special situation. So obviously, it is not your inherent right. Ordinary damage is my inherent right. I have a right to claim it. Special damage is not my inherent right. I can claim the special damage only when I have given what? A notice of the special laws. When I say notice of the special laws, what does it mean? I tell that there is a special situation and I will suffer this damage and I will claim it from you. Or is it sufficient if I say that there is a special situation? No, it is sufficient if I say there is a special situation. Even if I don't say that I will claim this damage from you, the fact that I gave you notice of the special situation gives me a right to claim these damages, right? So, special damages cannot be claimed as a right, but they can be claimed when the notice has been given to the other party. What is the next one? Nominal damage. Sometimes it may happen. Please understand the concept of damage is to make good the loss suffered. The concept of damage is not to make profit. Sometimes it may happen that there is a breach, but there is no damage on account of breach. So when there is no damage, why should you get a damage at all? But Contract Act says that if there is a breach, damage will be given. So just to respect the Contract Act, we give a damage which could be as less as what? Now don't laugh, hey, 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 1 rupee. I'm not saying 1 rupee. I'm saying it could be as less as 1 rupee. And the next one, vindictive or exemplary damages. These damages are punitive. When I say punitive, punitive means what? Punishable, right? When we say punitive, punitive means what? Punishable. They are what? Punishable. When I say punishable, it means what? That I can take the other person to prison also. And because they are punishable, they are not awarded in every situation. They are only awarded in what? Two situations. What are the two situations? The first one, wrongful what? Dishonor of a. What do I mean by wrongful dishonor? A customer has balance in his account, but still his check has been what? Dishonored. A customer has balance in his account, but still his check is what? Dishonored. And the second one is breach of contract of marriage. So you promise to marry someone, the person accepts it, and later she is waiting that meri barat aayegi and I will get married, but no barat. Why? Because you ran away. Right? So can we say it causes loss to her sentiments? Yes, so that she can claim. Wrongful dishonor of customer's check is also claim for reputation, and the breach of contract of marriage is also what? Claim for reputation. Can I say lower the amount of the check, higher the compensation claim? Can I say lower the amount of the check, higher the compensation claim? Let's say Mukesh Ambani issues two checks, 10,000, 10 crores, both lapse. Which causes him more loss of reputation? 10 crores maybe. I am richer than Mukesh Ambani. My bank balance has more than 10,000. Good, good. I am richer. Which causes more loss to his reputation. So lower the amount of the check, higher the compensation claim. I hope it's clear. Moving on to the next one. Penalty and liquidated damages. These damages are actually in the form of damages already mentioned in the contract. Now, just because I have said mentioned in the contract and special damage has to be mentioned, it's not a special damage. It is ordinary damage only. But what do we do here is, here we go one step ahead and we actually mention a certain amount which can be claimed as damage. And when we mention this certain amount that can be claimed as damage, this amount becomes the ceiling limit. That means I can claim anything within this, but never above this. Now, let's say the amount mentioned was 5,000. So, this becomes what? This is damages already mentioned. This is not a damage, it is ordinary damage only. But what we have done is we have gone one step ahead here And we have mentioned the amount that can be claimed as damage if there is a breach. When we talk about damages, this 5,000, let's say the amount suffered is 4,500. How much will you get? How much will you get? 5,000 or 4,500? Are you sure? Because damages are never given to make profit. If let's say you suffer 6,000, what then? Because this becomes the ceiling limit. Now, this damages already mentioned can be in the form of a penalty or a liquidated damage. When I say penalty, penalty means what? Penalty means to penalize someone. And when I am going to penalize you, I'm not going to be very soft with you. I'm going to be very harsh with you. So I mention a very high amount as damage. It is nowhere near the actual damage suffered. But when I use the word liquidated, the word liquidated means what? To liquidate means to convert in terms of money, right? Liquidate means what? To convert in terms of money. So when we say liquidated damage means what? The parties try to calculate or the parties try to figure out the actual damage that they may suffer. Cannot be exactly the same, but definitely something which is very near to the actual damage suffered. Let's say, let's say I ask you to repair my flat and the work should be done within 2 months. And if you take more than 2 months, I will claim from you the rent that I would have earned, or I would claim 3 times the rent from you. What is what? If tomorrow there is a law, if there is a breach, you don't repair, what is the maximum damage that I will suffer? What is the maximum damage that I will suffer? The rent. So what is rent? Liquidated damage. But can I say 3 times the rent is something which is very high, nowhere near to the real damage? So this is what? Penalty. Is it clear to everyone? Are you sure? Yes. So this is what? This is penalty. Though Indian law does not give any bifurcation between penalty and liquidated damage, this clarification or bifurcation is actually given under the English law. But whether it is liquidated damage or whether it is penalty, what can you claim? You can only claim what you have suffered. You can never claim anything more, right? So, one more thing, but if it is a government contract, okay, let's say government gave you a tender to build a particular road or maybe to construct a flyover, and the work was supposed to be completed within 6 months, and the government says that after 6 months, every day you take extra 5 lakh for every day. This is penalty or liquidated damage? Penalty. 5 lakh कभी भी damage नहीं होता है. But you, because it's generally what do you give? Whatever you have suffered. But if it is a contract with the government, you have to give the whole of the 5 lakh. In case of government contract, the penalty is what? Payable. Otherwise, you just give what you have suffered. But in case of government contract, the penalty is what? Payable. I hope it's clear to everyone. Yes, can I move forward to the next one? Now, these other rights, please remember they are available apart from monetary rights. With these rights also, you can claim what? You can claim the monetary right. That is, you can claim the damages. What is rescission? Yesterday we had done rescission. What was that? Cancellation of the contract. Rescission is a little different. Okay. Please tell me, how is rescission different? A is ready to perform, B refuses to accept. Should A sit and cry? What do I do? Should he do this? Nahi re Baba, go and file a case against B. Yes or no? For what? Sue B to cancel the contract. This is known as what? Rescission. How does this differ from yesterday's case? Uh-huh. Yes. That was done by the mutual consent of both the parties. Here the contract is cancelled by what? Mutual consent of both the parties. But here we are talking about remedies for breach. So here the contract is cancelled because one party has breached. Can A also claim the damages? Yes. A can also claim the damages, right? Whoever enters the room last, please kindly shut the door. Quantum Marriott. What do we mean by quantum Marriott? Quantum means quantity, Marriott means earned or merited. So, what is quantum Marriott? As much as is earned or as much as is merited. You had to deliver me 100 kgs of goods, but you only delivered me 20 kgs. Can I refuse? Can I refuse? Yes. But who refuses? I accept it. Later I say, you were supposed to give me how much? 100. How much you gave? 20. I will not pay. Can I refuse to pay? Huh? I have to pay for the 20 kgs. This is what? Quantum Marriott. Uh-huh. If he has accepted, he cannot return. He could have rejected when the goods were sent. He accepted, now he cannot reject the goods. Okay? Quantum Marriott, as much as is earned or as much as is merited. If a contract is separable, can I separate 120 kgs? Yes. And a part has been performed. Payment shall be made for the part performed. Actually, let's take another case. Let's say an author was asked to write a book in 6 volumes. Okay. But after 4 volumes, the author is dead. Okay. So many people die in our situation. मेरे को तो लगता है मेरे को गंगा नहा लेना चाहिए every time I finish a batch. Seriously. Ouch. The author was asked to write a book in 6 volumes. After he had written this, whenever the person is lying, no, he's dead. Like hands up, matlab dead. Okay. So after writing 4 volumes, the author is what? Swaha. Now the legal heirs of the author, they claim the price for the what? Tell me, can they claim the price for the 4 volumes? Hmm? Can they claim the price for the 4 volumes? How many of you say yes? How many of you say no? Why no? So artistic का पैसा नहीं होता है क्या? हाँ, artistic मतलब I have written 4 volumes. Pay me for the 4 volumes. Please understand, these were not 6 separate volumes. This was a single book in what? 6 volumes. These were not separate 6 volumes. This was a single book in what? 6 volumes. He had only written what? 4 volumes. Can you publish the 4 volumes? No, it's incomplete. Can the legal heirs claim the money? No. When the contract is not separable and a part has been performed, no payment shall be made for the part performed. Right? But sometimes just because it's the last work of the artist, can we say it becomes a bestseller also? So the publisher was totally under this belief that because it's the last book of the published author, it's going to sell out like hot fire. So, like, it was hot cake. Sorry, what is that? I said something wrong. It will sell off like hot cake, right? That is what the phrase is, right? Sell off like hot cake. That's what the phrase is, right? I said hot fire. That was wrong. Anyway, so they decided to publish. Now, if the publisher decides to publish the 4 volumes, is he liable to pay for that 4 volumes or not? Is he liable to pay? Yes. Then he has to pay for the 4 volumes. Is it clear to everyone? Are you sure? Yes. Shall I next pay? Yes. Ajay, tell me one more thing here. Can the publisher claim damages for 2 volumes? I told you these rights were available apart from monetary rights. Can he claim damages? How many of you say yes, can claim damages for 2 volumes? Come on, no one. How many of you say, huh? He can claim. How many of you say cannot claim damages for the 4 volumes? And बाकी जो क्या हुआ संकल्प तो ऐसे सोच रहे हैं क्या करूं हाँ बाकी whoever is not answering क्या करोगे मैम आपकी आत्मा को भेज देना एग्जामिनेशन हॉल में it will take a round huh? What can you claim the damages or not? Yeah, exactly हाँ correct तब फिर हाँ आपका नाम बताओ क्या है प्रियंका is literally ready to fight with me. 2 वॉल्यूम के लिए तो स्पेंड करना पड़ेगा ना हाँ so cannot claim because this is, can I say, supervening impossibility, and supervening impossibility, this is, Are bhai, he did not refuse to write. He's dead, not in anyone's hand. If he refuses, that's a breach. But if he is dead, is it a breach? No. So this is what? Supervening impossibility. And supervening impossibility में no damages. No, 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 no. They're not liable. Legal एज कहाँ से वो मैंने थोड़ी ना right death है ना, death is beyond anyone's control. ठीक है, चलो the next one, specific performance. What is specific performance? Specific performance is basically the person has to perform. I sue you to perform. Acha, tell me, the shopkeeper agrees to sell you a packet of bread. Okay? You paid him advance also. The next day you go, uncle, packet of bread. He says, sorry, beta, I cannot sell you. I will sue you. I learnt in my law class, I can sue you. I am going to sue you for specific performance. Tell me one thing, would you actually go and sue him for that packet of bread? क्यों नहीं? Breach तो है ही ना? Exactly. I will better go and buy another packet of bread for that 30 rupees. I'll get 30 years of harassment. Who wants that, right? So I will go to the other shop. But tell me, if this seller tells you that I have a pen which was used by the king of the Ming dynasty, it's a 15,000-year-old pen used by the king of the Ming dynasty. That is some Chinese dynasty. There was a time when I was crazy about Chinese shows. Okay, so Ming dynasty. So tell me, later he refuses to sell. Will you take damages or will you sue him for that pen? You will take damages. You Jodha Akbar, you remember the case of Jodha Akbar? Huh? Jodha will sue for damage, take the damages or sue for the dress? Huh? Love was more important. Yes or no? Huh? This pen is more important or damages is more important? Why? Why is pen more important? Why was bread not important? Why is the pen so important? Bread I get in every other shop. This pen also I get in every shop. But 15,000-year-old pen used by the king of the Ming dynasty is definitely something that I don't get. So in that case, will I take damages or will I sue the party to perform the contract? I will sue the party to perform the contract. This is what? Specific performance. Please understand, specific performance is not for every case. This is only for two cases. The first one is what? The goods have no substitute. Right? The goods have what? No substitute. And the second one is when goods have no substitute basically happens when? In case of antique goods. Right? Goods have no substitute happens generally in which case? When the goods are antique goods. Or damages are not an adequate relief. What do I mean by damages are not an adequate relief? Damages cannot be compensated for non-performance. This generally happens in case of immovable property. Let's say the owner agrees to sell this building to me. Later he refuses to sell. Can I get the same building, same location anywhere else? No. So will I take the damages or will I sue him to perform? Car, I can get any other car which is the same car, but building नहीं है ऐसा थोड़ी ना कि इधर उधर लटका दिया. So there I will sue for what? Performance of the contract. Is it clear to everyone? Yes. The last one, injunction. Always remember, injunction relates to negative act. I already told you yesterday. I'm repeating it again. This is a revision. Obviously, I cannot do it at the same pace. If any topic is a doubt, please ask me again. I'll explain it. Okay? Injunction generally relates to what? Negative act. Can we have a contracts where there is a negative clause? You cannot do this. Yes? Can Yashas have a contract with his teachers that till the time you're teaching at Yashas, you cannot teach anywhere else? Yes? Let's say one of the teachers starts teaching somewhere else. Can we say he has breached that negative term? Yes? Yashas will bring what? Injunction order. That is, you were not supposed to do, you do. You did, sorry. We stop you from doing it. Can Yashas also claim damages from the teacher? Yes. So these are the other remedies. I hope it's clear. Any doubt in any of it? Otherwise, we'll move forward. Can I move forward? Yes. Okay. I just want to discuss one situation with you. X agreed to sell bottles. Okay. Bottles of water. Many of you might have read this question. Water bottles at rupees 5 per bottle. Okay? And for this, he made a contract with Z that he will buy the bottles from Z at 4 point what? 50. X agrees to sell bottles to Y at 5 rupees, and for this he makes a contract with Z to buy the bottles at how much? 4.50. Now Z refuses to sell, and when Z refuses to sell, the market price is now how much? 5.5. Instead of 5.2. Sorry. Okay. How much damages can X claim? Huh? 0.25. I repeat the case again for those who did not understand it. X made a contract to sell bottles of water to Y at rupees 5 per bottle. And to sell this bottle, he made a contract with Z. He needs to have those bottles to sell. So he makes a contract with Z to buy bottles from Z at 4.50. Later, Z refuses to sell and the market price was 5.25. So, how much damages can we claim? 0.75, 0.50, 0.1, oh sorry, 1.25 and nothing at all. How many of you say 0.75? 0.75. How many of you say 0.50? Okay. Actually, anyone saying 1.25? नहीं मतलब कुछ भी हो तो कुछ भी सकता है ना, right? When I gave a option in one of the quizzes, why should I bother? I'll go to Goa for a vacation. People actually opted for that answer also. So कुछ भी हो सकता है, right? So are you sure it's not? Pakka. It is 0.75. The contract price was 4.50. The market price was 5.25. That is damage. I am just rephrasing this a little bit. When X makes a contract with Z to buy the bottles at 4.50, I can smell tobacco very much in the room. Is it just me who getting that smell or it's there? My nose is a little too sharp also. So anyway, listen all of you. So when he makes a contract with this guy, Z, to buy bottles from Z at 4.50, he tells him that, see, I am going to sell these bottles to Y at 5.00. Now, how much damage can we claim? I repeat again, when he makes a contract with Z, he tells Z that, see, I'm going to buy these bottles from you at 4.50 and I'm going to sell these bottles to Y at 5 rupees. Now, how much damage can he claim? Huh? 1.25, 0.75, 0.50. How many of you 0.75? How many of you 0.50? Everyone, 1.25? It will be 0.50. Why? Because now he has mentioned it that I am selling. So the damage actually suffered is how much? 0.50. Is it clear, all of you? Yes. Can we move to the next one? Do you have any doubts in any of this? Do you have any doubts in any of this? Any doubt? No? Can I move forward? Yes. The next one, the last unit, contingent contract. So what is basically contingent? Basically is what? May or may not. So A says to B, I will sell you my land if I inherit it from my father. Right? A says to B, I'll give you rupees 5 lakh if your house is burned by fire. A says to B, I will give you rupees 100 if the ship does not come to the port. Is this wager? Is this wager? Okay, I'll just give you another example. A says to B, I'll give you rupees 100 if it rains. Is this wager? Huh? No. How many of you say it's a wager? It's a wager. How many of you say it's not a wager? Okay, why is it not a wager? In wager, it has to be both sided. A says to B, I'll give you rupees 100 if it rains, and you give me rupees 100 if it does. When it is like this, then it is a wager. Right? But here it is what? A single-sided contract. And when it is single-sided, it is what? Contingent. Right? It is what? Contingent. A contingent contract is a contract to do or not to do something. When they say to give money or money's worth, it's wager. When they say to do or not to do something, it is what? Contingent. The definition of wager says give money or money's worth. The definition of contingent says to do or not to do something. Now, contingent contract, by the way, these contracts are valid or void. Always remember contingent contracts are what? Valid. So, first of all, contingent contract dependent on the happening. So, characteristics, if I say, it is always dependent on an event which may or may not happen. Right? So, the first characteristics of a contingent contract, it's not here, so I'm just writing it here. It is always what? Dependent on an event which may or may not happen. The event must always be a, what is a collateral event? Should not form a, huh? Okay, it should not form a part of the reciprocal promises. So when I say A says to B, I will give you rupees 1 lakh if you marry C. And A says to B, I'll give you rupees 1 lakh if I am able to marry C, which is contingent and which is not. A says to B, I'll give you rupees 1 lakh if you marry C. Second case, A says to B, I'll give you rupees 1 lakh if I am able to marry C. Bono, which is contingent? How many of you say first one is contingent? First one. How many of you say second one is contingent? How many of you say both of them are contingent? Both of them are contingent. First of all, the first case, I will give you money when you do something. This is what? Reciprocal. I will do something when you do something. This is what? Reciprocal. I will give you money when you get married. So the event marriage is coming from you. So this is what? Reciprocal. Second, I will give you money if I am able to marry C. The contract is dependent on marriage, but is the marriage coming from the other party? No. So when it is not coming from the other party, it is not reciprocal. It is what? Collateral. And when it is collateral, it is what? Contingent. Right? So collateral, the event must always be a collateral event. What is collateral event? Should not be a part of not a part of reciprocal promises. Right? Not a part of reciprocal promises. Acha, let's talk about, and last, Acha, tell me, A says to B, deliver the goods to me, I will pay you if I wish to. Okay? On the day of the payment, he's like, ayo, no feeling illa, no feeling to pay. Contingent contract. Is this contingent contract? No. Your feelings are not contingent contract. If I am able to go to Kolkata in the coming week, I'm from Kolkata basically, so I just come here for my classes. So, if I am able to go to Kolkata in the coming week, I will give you 1 crore. Is this contingent? Listen carefully to each word. If I am able to go to Kolkata in the coming week, I will give you 1 crore. Is this contingent contract? Yes, yes. If I feel like going to Kolkata in the coming week, I'll give you. Is it contingent? No, my feelings are not contingent. Acha, tell me. I will give you 1 lakh rupees if you construct the swimming pool within 6 months. Is this contingent? I will give you 1 lakh if you construct the swimming pool within 6 months. Is this contingent? No. I will give you 1 lakh if I am able to construct the swimming pool within 6 months. Is this contingent? Yes. In the first case, it was reciprocal. I will give you money when you do something. So, the last one, it is never dependent on the will of the promiser. It is never dependent on the will of the what? Promiser. So, coming to what contingent contract dependent on the happening of an event. A says to B, I will sell you my land if I inherit it from my father. The contract is what? A would sell his land to B, but it depends on what? If he inherits it from his father. Let's say he inherits, what happens? What happens? He must sell or he may not sell. He must sell. Must sell or may sell. He must sell. So the contract is valid when the event happens. Let's say he does not inherit. Now what? He does not inherit. Now what? Can he sell? Arey, I did not inherit. How can I sell? It is what? Void. When the event is it void contract or is it void agreement? Is it void agreement or is it void contract? It's void contract. It is contingent contracts are valid. And if the event happens or does not happen, it becomes void contract. If you remember yesterday, I told you a contract is void only in two cases: supervening impossibility, contingent contract, right? Then, dependent on the non happening of an event, A says to B, I'll give you rupees 100 if the ship does not come to the port. Let's say the ship comes to the port. What will happen? Huh? Should I pay you? I will pay you 100 rupees if the ship does not come to the port. The ship sinks. Should I pay you? Yes. Because when the ship sinks, the ship does not come to the port. Relate to it, please. Let's say this ship sinks. Now, when the ship sinks, will it come to the port? No. So I have to pay or not? Yes. It is valid when the event does not happen. But it sinks, no, ma'am. It happens. The question was not if it sinks, I'll give you money. The question is if it does not come. If it sinks, the consequence is it does not come. If the ship comes to the port, am I supposed to pay you? No. So it is void when the event happens, or there is a possibility, or does not become impossible. Right? I have no place to write. Or does not become impossible. Now, can it depend on a third party? Yes. A says to B, I will give you rupees 1 lakh if I am able to marry C. If C marries A, what happens? If C marries A, what happens? Yes, it's valid. If C marries D, huh? Boy. People ask me, ma'am, what if C marries B? I don't know what. Now, acha, it can happen, no, that D may die and C may go and marry A. Huh, कुछ भी, मतलब कुछ भी. So, the contract is valid if the third party acts accordingly. Is it clear to all of you? And last, contingent contract dependent on impossible events. It is impossible. It is obviously always. The rest all are what? Valid. But this is what? Void ab initio. A says to B, I will give you half the treasures I discover by magic. Wish it was a Harry Potter movie. Chalo, anyway, can we move forward? Yes, quasi contract. What exactly is a quasi contract? Remember implied contract? Yes. There is no contract between the parties. No contract between the parties, but it is what? Imposed by law. It is what? Imposed by law. Goods delivered by mistake or under coercion. A has to deliver goods to B. Can we say there is a contract between A and B? Yes. By mistake, the goods are delivered to C. Can C keep the goods? Ma'am, वैसे India में ना I will deny. I will in fact deny that I received the goods and I will keep the goods. But can C keep the goods? No. No. C cannot. C must what? Return the goods. Let's say by fault, by mistake, he thought the goods were his and he used it. Then what? He must pay the reason, not damages. The whole price, not just damages, the whole price. So, is there a contract between A and C? No. But the contract is created by law. Right? Contract is created by law. Yeah, sure. So, under coercion, how does it happen? Let's say, Munna Bhai. So, this is the example actually I give in the class. So, I'll just take that example. He's a Bhai, okay? So, this Munna Bhai, he wanted your Shashank, right? Shashank here has a bike. And since Munna Bhai saw this bike, Munna Bhai fell in love with this bike. Okay? But he wanted to get, he did not want to pay the whole price of the bike, but he wanted the bike. Right? So Now he was like, I will go and tell Shashank, if you don't sell me your bike for 2000, I will kill you. What will Shashank think? यही दोस्ती यही प्यार बीच में आ गई बाइक की दीवार. I cannot do this. So every bhai has a right hand man. And our bhai, Munna bhai's right hand man was who? Circuit. So he sends this circuit to Shashank to tell him that if you don't sell your bike, I will what? I will kill you. So this guy was also carrying a gun. Okay, don't, it's not a boomerang. He was also carrying a gun and he was like, I will kill you if you don't sell me your bike. Now you have to tell me who is the contract between. Who is the contract between? No, Circuit and Shashank. The contract is between what? Between whom? Sorry, Circuit and Shashank. Because Circuit goes and tells him that if you don't sell me your bike for 2000, I will kill you. The contract is between whom? Circuit and Shashank. This is coercion. In coercion, what happens? The contract is what? The contract is voidable. At whose option? S's option. Now let's say Shashank cancels the contract. So when Shashank cancels the contract, tell me, when Shashank cancels the contract, tell me, can he go and get the bike back from Munna Bhai? Yes. Is there any contract between him and Munna Bhai? No. The contract is between whom? Circuit and Shashank. But can he go and get the bike back from Munna Bhai? Yes. This is on the grounds of quasi contract. And why is it only in the case of coercion and no other case? Because it is only in the case of coercion, if you remember, that the force can be by or on a third party. Right? Necessaries supplied to a minor or to a lunatic's family. Let's say M is a minor and you supply him with necessaries. You remember yesterday only we talked about it. Huh? Yes, I'm going to discuss that question. That's a little confusing also. Is there any contract between you and the minor? No, because a minor cannot make a contract. But there is a quasi contract according to which you will be what? Reimbursed. According to which you will be what? Reimbursed. Payment made for a third party. Let's say A sold his land to B, and on this land the government taxes are due. If the government taxes are due, the government will what? Seize off the land. And if the land is seized, whose land will go? B's land. So to protect his interest, this is very important. Why is B paying? To protect his interest. B pays off the government. Who was supposed to pay? Who pays? Can you recover it from A? Is there any contract between them? No. But there is a quasi contract. When a person makes the payment on behalf of another to protect his interest, he can recover the money back from the other person. Work done non-gratuitously. Signal pay, your car stops. This kid, he comes and starts cleaning your car. You tell him, hey, bhai, don't do, leave. He still cleans. Are you liable to pay? No. Right now, don't try Johnny LLB. I'll wipe his face. Now he comes, he starts cleaning your car. You're like, hey, clean that, clean, clean. You good. Clean. Bhaiya, money for what? Bhaiya, I cleaned the car. I never asked. You only came and cleaned, no. But bhaiya, I cleaned, no. Give me money. I asked you. Are you liable to pay or not? Yes. When a person does any work for you, not intending to do it gratuitously. Not intending to do it gratuitously means he is doing it for you, intending to be paid for it. And you enjoy the benefit. You have to what? Pay him. Abhi wo to bolega, bhaiya pay me 1 lakh rupees. Are you liable to pay 1 lakh? Obviously no. But whatever is reasonable, you are liable to pay. The last one, finder of the goods. There is a quasi contract between owner and the finder, that the finder must trace the owner and return the goods back to him. Finder is actually known as the bailee of the. Can the finder sell the goods? What are the? Acha, tell me, what are the rights of the finder? Rights, not duties. Duties नहीं पूछा, right? Okay. His rights is to claim expenses. If you have announced a reward, acha chalo, your mobile was found by someone. You find him, you go to him, you're like, my mobile, yes, bhaiya, first give me 10,000, then I will give. Can he do that? No. But if you have announced a reward, can he claim that reward? Yes. Claim reward, if any. Can he also sell the goods? Yes. Can he also sell the goods? Yes. If the goods are perishable or if the owner is not found or, now listen carefully. The value of the goods was 1,000 rupees. I spent 100 rupees on the goods. I found him. I told him, give me 100. He says, I won't. Can I sell the goods? No. No. I spent 500. He did not pay me. Can I sell the goods? No. I spent 800. Yes. Ma'am, what did you spend on? Trying to find him, trying to keep the goods. I spent 800 on him. On trying to trace him, trying to take care of the goods. He was found. I tell him, give me money. He says, I won't give. Can I sell the goods? Yes. Yes. If the owner is found, but he refuses to give the lawful charges. What is lawful charges? Whatever I spent trying to search for him or take care of the goods. And lawful charges are 2/3 or more of the value of the goods. So only if your lawful charges are 2/3 or more of the value of the goods, then you can sell the goods. Is it clear to everyone? The last one, right of ownership against the whole world except the owner. Means what? If the owner is found, you have to give the goods to him. You are not the owner. But other than the owner, no one else can claim the goods back from. Is it clear to everyone? Are you sure? Yes? With this, we are done with the Indian Contract Act. Do you have any doubts in this? Huh? I was so tired, I could not make any. Huh? Okay, just give me 2 minutes. Okay, I want you to answer this question. This was asked in the previous term. I want you to read this question. It was a 6 marks question and it was asked in the previous exam, that is December. Okay, you are supposed to answer. You can have a good time. You will be the one, the guy sitting behind the blue shirt. Yes, yes, you. Yes, yes, absolutely. What's your name? Huh? Prabhanjal, right? You will answer this question. Okay? I'll give you the mic also so that everyone can hear you. Prabhanjal, if he needs time, we will wait. Because he's supposed to answer this question for all of us. I know. Should I scroll down, up? Now can I scroll up? Yes, Pramanjal, what is the first answer? Okay. What is the second answer? Oh, sorry. Yes, yes, yes. I'm so sorry. What about the last one? No. Okay. How many of you have got the first answer as yes, he can file a case against him? Oh, wow. Only you. Okay. The three of you. Okay, four. Why yes? That is necessaries. Okay. How many of you know? How many of you? I am just waiting for you to answer. I will also then understand and I will have an answer. Huh? Mr. Y, aged 21 years, lost his. So please, this is not minor or anything. This guy is a what? Major. Lost his mental balance after the death of his parents in an accident. He was left with his grandmother, aged 85 years, incapable of walking and dependent upon him. Mr. M, their neighbor, out of pity, started supplying food and other necessaries to both of them. मेरे को तो ये समझ में नहीं आया. When he started supplying out of pity, then why did he even claim the money later? Where did that pity go when he wanted to claim the money? Like seriously. Out of pity, started supplying food and other necessaries to both of them. Mr. Y and his grandmother used to live in the house built by his parents. Mr. M also provided grandmother some financial assistance for her emergency medical treatment. After supplying necessaries to Mr. Y for 4 years, Mr. M approached the former asking him to pay back 15 lakh inclusive of 7 lakh incurred for the medical treatment of the lady. Mr. Y pleaded that he has got his parents' jewelry to sell to a maximum value of 4 lakh, which may be adjusted against the dues. Mr. M refused and threatened Mr. Y legal suit. Tell me, can he sue? First of all, did Mr. Y ask the neighbor to supply the necessaries? No. But when he gave, the accepted it or not. So it is what? Quasi contract. It is what? Quasi contract. Claim for necessaries supplied to a minor or to a lunatic's family. As per the provisions of the Indian, so this how these answers are written. They are the answers are written in three paragraphs. Where first, in the first paragraph, you just quote the relevant provision. You don't talk about the case, only the relevant provision. As per the provisions of the Indian Contract Act, and whatever is relevant for this case, you just write that down. In the second paragraph, you describe the case. Third paragraph, you give the conclusion. So, here, whenever a person supplies necessaries to a minor or to a lunatic's family, as between the supplier and the lunatic, there is no contract. But there is a quasi contract according to which the supplier will be reimbursed from where? From their property. So, does M have a right to file a case against Y or not? Does M, all of you now tell me, does M have a right to file a case against Y or not? Yes, he was a lunatic and M supplied necessaries to his grandmother and to him. So can he claim the reimbursement of the necessaries? Yes. From where? From their property. So, will Mr. M succeed in filing the case? Yes or no? Yes. Yes, he will succeed. Then tell me, what is the maximum amount that can be recovered? 4 lakh was the jewelry. But if you notice, they had a house which they were living in, which was built by his parents. So, assuming that the property was inherited by Mr. Y, that is also his property. So, it can be recovered from the sale of jewelry, that is 4 lakh, and the remaining from the sale of the property. Huh? Huh? Huh, so we'll just write from the sale of property. We cannot state the figure then. State the provisions. Shall the provisions also apply to medical treatment? Yes. Necessaries includes the medical treatment. And when it comes to lunatic, it is what? If you see the point also, claim for necessaries supplied to a minor or to a what? Lunatic's family. Right? So, supplying necessaries to the family of the lunatic. So, the grandmother's expenses was also what? Necessary. So, are you liable for that also? Yes. Is it clear to everyone? Actually, if you see, the questions are not tricky, but it's phrased in such a way that we kind of lose track of it. So, I hope it's clear. I hope everything. Ajay, you wanted me to explain champerty and maintenance. Let's say A says to B, I will give you 5,000 if you sue C. Okay. Why is A asking B to sue C? For no reason. Just Chumma, he wants to trouble him, right? This is maintenance or champerty. This is maintenance, right? B is helping A to sue C, but A is not sharing the result of the litigation. Is A getting anything out of the case? No. He just wants to annoy C. For that, he is giving money to B to file a case against C. But when B files a case against C, whatever the reason he files the case, whatever he gets, is A going to share anything out of it? No. So this is what? Maintenance. A says to B, let's sue C and prove that the land he has belongs to us. And once we get the land, we will share it what? Equally. So A and B are together suing C, right? So A is helping, B is helping A to sue C. And they are going to file the case for what? For the land. And they are going to share it what? Equally. This is what? Champerty. It's valid or it's void? It's valid or it's void. First case, why do you want to sue C? No reason, just like that. And if you file a case against a person just like that, it is obviously void. Second case, the land belongs to us. We will prove that. That means the land actually belongs to you, or you'll just go and prove. We'll just go and prove. So this is obviously unlawful. So it is what? Anything else? Acha, tell me, if A had actually given a loan to C, loan of 10 lakh, B says, don't worry, I will help you recover the money. Once you get the money, give me 1/10 of it. This is champerty or maintenance? Champerty. This is valid or void? Why is it valid? Because the object is lawful. Because C had actually taken the money from A. Whereas in these two cases, it was by unlawful means. Here it was what? Good faith. Because B is helping A to recover the money and he's sharing it out of. The money you recover, give me 1/10 of it. So it is what? Champerty. If he would not have taken the money, it would have been maintenance. Okay, ready for a quiz? चलो जल्दी से निकालो. All of you have joined. Give right answers. मतलब I just taught you that vindictive or exemplary damages are awarded in which cases? First, wrongful dishonor of customer's check and breach of contract of marriage. पूरा पढ़ो. Who gave wrong answers? Who gave A, B, D, E? I want to see those A, B, D, E. Who gave those A, B, D? Huh? Who gave the right answer? बाकी सब क्या कर क्या रहे हो? What are you trying to do? थोड़ा happy. Oh my God, 90 people right. Very good, very good. Keep it up, guys. I'll start. Out of natural causes, man-made causes. ये ना OMG याद आता है natural causes सुनने से. Quasi contract arises out of no contracts, obligations without contract. Very happy you are. How many right you gave? Still, my heart is feeling a little happy. You found the notes for all the chapters. हाँ हाँ वही good happy. और बाकी ये जो कितना कितना है 6 and 8 what are you doing huh? It's 4 whatever. What are you guys doing? How many of you got this right? Okay. Mitigate means to lessen. When can you lessen your damage? When you can claim them. When can you claim them? Both anticipatory and actual. Previous question was also same. Almost same question. A contingent contract dependent on the non-happening of an event becomes void when the event does not happen or, becomes void when such event happens or does not become impossible. Or does not become impossible. पढ़ाते वक्त also I said, I am not, there is no space to write. Huh? More interested in the result. Wrong answer देखे भी result. Who is Vignesh? चलो अभी चले next chapter में. Um, for what? Break for what? Oh no, you are relaxing only. Relaxation. Why put relaxation? Okay, so I was thinking after this we will do partnership companies, LLP, sale of goods, or what should we do? Tell me. Huh? Which order? You want in that? Why? Oh, which order? Why? Yeah, you got me even more confused now. Who says let me? Who says that I should do it as per the order of ICI? That is next chapter should be sale of goods act. Chalo, who will count? Who will count? Chalo, make now stand up. No cheating, no two hands. I can see it. Thirty-eight. How many of you say I start with partnership? Ayo. How many of you say I should start with companies? Oh my God. आप सभी में वोट कर रहे हो यार हाँ अच्छा पार्टनरशिप का वोट काउंट वाइज कंपनी से कर रहे हो अच्छा हाँ वोटिंग करने के बाद आई कैन नॉट डिनाई कितना अरे हाउ मेनी कंपनीज रेज योर हैंड नहीं आई हैव टू बी जस्ट एंड फेयर नो चीटिंग नो वन कैन रेज टू हैंड्स so what we will do I'll first start with companies act then I'll go to sale of goods Act instead of partnership okay how many of you love companies act how many of you don't like companies act why no why no but we can like and not like why you don't like huh it's the easiest of all no it's conceptual if you remember it conceptually I gave you so many conceptual examples if you remember it conceptually it's concepts only huh 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 ultra wise and all that now where do I look for companies act document I don't know the way you have been. Half of the class is saying you don't like companies that too much. It's just mugging up. It's more of conceptual actually. If you remember the concepts, you can easily do it. From this is again a 13 marks chapter. You already know that. And yes, please kindly keep your phone control. Quiz is done. Quiz is done. Phone अंदर रख लो. Phone अंदर रख लो. If I take the phone, today is the last class. You won't come tomorrow. I won't give again. Pretty attention point. So, Companies Act 2013 talks about companies. What exactly is a company? As defined under clause 20. What is company? Company, according to section clause 20, means what? A company incorporated under this act or any other previous law. So when I say any other previous company law, let's say a company was incorporated on let's say a company was incorporated on 2nd May 1975 under the Companies Act 1956. Is it considered as a company? Are you sure? Yes, it is also considered as a company. Now, so under any other previous law, so when we say previous company law, we are talking about 1956 or before that we had the law of 1913. What are the characteristics of a company? Separate legal entity. In fact, all characteristics of the company separate legal entity. What is separate legal entity? Company and members are different. Right. Company is not responsible for the members. Members are not responsible for the company. Company and members are different. This was laid down in the case of Solomon versus Solomon and Company Limited. And what was the second case? Lee versus Lee Air Farming Limited. Then tell me the next one. Perpetual succession. Members may come, members may go. कंपनी चलती ही जाएगी बैटरी है भाई डिपो बैटरी चलती ही जाएगी basically death of the member does not result in the death of the company and there was this one case where 5 members of a private company where वो बहुत सारा met with an accident actual case was There were five members in a private company. They had called a meeting. World War II was going on. This place was hit by hydrogen bomb. All the five saw her. The quote words were, even a hydrogen bomb cannot kill a company. So company is formed by a legal process called incorporation. It can only die by a legal process of winding up. Tell me next one. Common seal. By the way, earlier it was mandatory. Now, seal matlab wo rubber stamp wala seal nahi hoता company में. There is a proper seal, metallic seal. But after 2015 Amendment Act, the concept of seal has now been removed. Now it's not mandatory for a company to have a common seal. If they have, it may not have. If the company has a common seal, it will use that. If the company does not have a common seal, then in that case, the document shall be signed by two directors and one secretary of the company. Tell me what else? What question is the question we just discussed? Limited. The liability of the member is only limited. Though we have the concept of unlimited liability company, but most of the company is actually what? Limited liability. The liability of the member is limited to the unpaid value of the shares held by them. Next, follow. Jaldi se. Uh-huh. Sorry? Huh. Anything else? Uh-huh. Can sue and be sued. If a company wants to sue a third party or a third party wants to sue the company, they don't need the name of the members to file the case. The case can be filed in the name of the company itself. Right? The case can be filed in the name of the company itself. That means the company has the right to sue and be sued in its own name. Then, follow transferability of the shares. This is not a regular class, it's a revision class you come here for, right? And you are very serious about your career, that is why you have come, right? So repeat, tell us the point rather than, having a, so it's very good to laugh, but let's keep it, for some other thing. Okay? So tell me, what's the next one? Transferability of shares. Shares are freely transferable in company. Though private company can actually have some restriction. In case of public company, it is freely transferable. Anything else? Separate property. Property of the company does not belong to the member. And there was this case, Makora versus New Assurance Limited, where he had started a timber furniture company. And because timber is very prone to damage, they took an insurance in the name. They decided to take insurance. M took the insurance in his own name. The insurance company refused to pay the money on the grounds that since the property belonged to who? Since the property belonged to company, how could he take the? If you want this document, I'll give you the link. You can actually go there and get the documents. Don't worry about that. All these documents, the scanners, questions, everything is there. So, I'm sorry. What was I talking about? Huh? So he took the insurance in his own name. So the timber was burned down, and when the timber was burned down, the damages were claimed. So in that case, when the damages were sorry, the insurance company was asked for paying the money, the insurance money. The insurance company refused to pay, saying that since the property belonged to the company, the rightful person to take the insurance was the company. Even Insurance Act says that only the person who has a right in that property can take insurance. Property did not belong to M. So what was M's right to take the insurance? So the insurance company refused to pay the money. Did I miss out anything or we have done separate management? Company is not managed by the what? Shareholders. It is managed by whom? By the board of. Why? Because so many members are there. Too many cooks spoil the broth. Right? Right? It will not be managed. It will be mismanaged. So rather, let's just. But then, ma'am, what is the point of me being a member? The point is that the right to appoint the directors lies in your hand. So who can be the director? It is up to you to appoint them as a member. Types of company is a very important section. In fact, Companies Act again is something which is very important. Every part is important. Like partnership, literally, I'll tell you, from every topic there is a question. Either in the mock test or in the RTP or in the previous year questions, if you see every topic there is a question. Similarly, when I say types of company, obviously they cannot ask you from all the types of company. But basically, if I divide, the first part is what? Lifting of corporate wealth, and then we have the doctrine, and then we have types of companies. Basically, these three things. Incorporation is there. You will see there is always a question from doctrines, any one of them. Many a times you will see there is a question from lifting of corporate wealth, and obviously there is always at least two questions from types of companies. Okay. Now, can they also ask you question like What are the different companies on the basis of control? Explain. Yes. So you need to know the subheads also, right? You need to know the subheads of the companies also. So the first, moving on to the types of company. Actually, before I go into this, tell me one thing. Can I say whatever the company, holding, subsidiary, government, foreign, associate, Section 8, non-profit, small company, every company, can we say every company is either a private company or a public company? Yes or no? Every company is either private company or a whatever type of company you are holding, subsidiary, foreign, government, associate, whatever. At the end, you are either a private or a public company. So every company is either a private company or it is either or a public company. And when we say private or public, they may either be what? Limited by shares, or they may be guarantee, or they may be unlimited liability company, right? So this is the broad. Every company will either be one of this. Now, what are the different classifications of company? This is on the basis of what? And on the basis of liability, the companies may be what? Limited and unlimited. Limited can be limited by shares, limited by guarantee. Limited by shares defined under clause 22. I am not talking about the clauses, it's okay if you don't remember. I don't want to flaunt that I remember all the clauses. So I don't want to do that. So what exactly is a company limited by shares? Members are only liable to pay the unpaid value of the shares held by them. So every share has a value, 10 rupees, 100 rupees, whatever. Whatever, if I have paid the whole amount, I have zero liability. But if I have paid a part of the amount, whatever part is left, I am liable to pay only that. And when am I liable to pay only that? When the company makes a call. When can the company make a call? Either during the course of business or during winding up. So, what I share that when the liability of the member is limited by the memorandum to the unpaid value of the shares held by them. Okay? What is limited by? See, I again repeat, I cannot go too much in details. If you have any doubt in any of it, you ask me, I'll explain it. What is limited by guarantee? Here, basically, the members give a certain amount. That tomorrow, if the company goes into winding up, this is the amount I will contribute. I say I will give 5 lakh, he says he'll give 5 lakh, she says 7 lakh, she's foolish, she says 10 lakh. So, we will give. Tomorrow, if the company goes into winding up, we both will contribute 5, she will contribute 7, she will contribute 10. Right? This is limited by guarantee. The amount a member undertakes by its memorandum to contribute to the assets of the company in the event of its being wound up. I'm not going into explaining each of the words because that's done in the regular class. Don't want to waste my time. Anything you don't understand, feel free to ask me. So, what is the difference between limited by shares and limited by guarantee? अच्छा, एक चीज और. Limited by guarantee may be with share capital or without share capital. If it is with share capital, can I say double liability? Yes. How double liability? I'm liable for the unpaid value of the share as well as the guarantee amount. And can we say it arises twice? Because when it is unpaid value of the share, it arises during the course of business or during winding up. If it is guarantee, it arises only during winding up. When it is without share capital, can we say single liability? Yes. How? Only for the guarantee amount, and it only arises during winding up. So what's the dissimilarity? What's the difference between these two companies? What is the difference between these two companies? Tell me. Uh-huh. Okay. In case of limited by shares, the money can be called up either during the course of business or during winding up, but guarantee only during winding up. Limited by shares always will have a share capital because it's limited by shares. But limited by guarantee may or may not have a share capital. What is the similarity? What is the liability? The similarity, sorry. First of all, they both are, huh? Yes, exactly. All the features of a company. They both are company. So whatever features, both have limited liability, perpetual succession, separate legal entity, right? All the features of a company are the features because they are obviously what? Company. What is harm? No, even in guarantee also you cannot. Whatever amount you have promised, that's it. Limited liability, that only I told, no? Limited liability is that only. What is unlimited liability company? There is no limit on the liability of the member. But generally, once company is incorporated, they generally incorporate it as what? Limited liability. Can I move to the next one? Yes. The next classification is on the basis of number of what? Members. Private, public, OPC. Can I say OPC is a private company? Yes. OPC is a private company with only one member. Okay. OPC section 2 clause 62 defines the term OPC, which says that it has only one member, one person as a member. This is the best definition. Like I told once I asked the person why you doing CA, right? Same kind of definition. So he stands up and he says, because I want to become a chartered accountant. I was like, oh, oh, I felt like Buddha actually. So anyway, the rules of, however, section 2 clause 62 just gives us the definition, does not tell us anything about what exactly is OPC, who can be member of OPC or anything. All that is given where? Companies Incorporation Rules 2014. Remember yesterday I told you law comprises of act as well as rules. In fact, our Companies Act is 40% rules. What's the difference between act and rules? Act is passed by the parliament, rules is made by the government. Which is easier? Rules. Why? Because government notify karega khatam. Whereas parliament, the opposition is also there. Getting a consent is very difficult. Act tells us what the company will do. How they will do it generally is given where? In the rules. All the form numbers, the fines, fines, the fees, everything is given where? In the rules. Okay? Companies Incorporation Rules 2014 tells us the rules for OPC has undergone a tremendous amount of change in the previous years. So whatever is here and that is it. Please note, I've got messages from student. I wrote the old one because I saw it in your video. I was like, ये तो देखना चाहिए था date कब का है video का. और after the exam you are telling me before the exam ही पूछ लेते. So please be careful. This is what we are supposed to study. Whatever you find in any other book is no longer valid. It's amended, right? Who can become a member or nominee of an OPC? Huh? Only a natural person. Let's say artificial person can be a member of a company. Yes. Yes. X limited, Y limited can start XY private limited. But in case of an OPC, only a natural person. In case of a company, we can have artificial persons as members. That is how we have holding subsidiary companies actually, right? But in case of OPC, only a natural person who is an Indian citizen, whether resident in India or not. So residency is not important. That means even if you are a non-resident Indian, you are an Indian citizen but you are not resident, you can still. Section 8 and OPC is one of the hot favorites of the institute. Very favorite of the institute. But abhi small company में भी amendment hai, so that is also a little bit of important. Anyway, coming to this, only a natural person who is an Indian citizen, whether resident in India or not. That means what? You must be an Indian citizen. Even if you are an NRI, you can start an OPC in India. Can be a member or a nominee of OPC. Tell me, what is resident of India? Now you all should say, no, why should I only say, what is resident of India? Who has stayed in India for at least 120 days, not 182 days, okay, 120 days in the immediately preceding financial year. Please don't write year. Financial year and year is different. Don't by mistake also make these changes. It's written, they don't say previous. Generally, they use the word preceding in law. Preceding financial year. Now tell me, why do we write the name of the nominee? In case of death or incapacity of the member, the nominee will become the member of the what? will become the member of the company. All of you, कुछ तो बोलो. Yeah, मतलब ये सोच के आए हो कि I've had lunch, I can go and have a good sleep till 4:30. After 4:30, I'll wake up. 20 minutes was okay, different. That was different. Huh? That is why I got wrong answers. Now I wonder why. Huh? Now I know why. I was wondering why. So anyway, so why do I write them? Why do I name a nominee in the event of death or in capacity of the member? Who is member of the company? The nominee shall become the member of the company. Tell me, where do I write the name of the nominee? In the memorandum. In the memorandum, what do I get the consent from? What do I get from the nominee? Written consent. Who do I file this written consent with? Registrar. Who do I file this consent with? Registrar. Can the nominee withdraw his nomination? Yes. Can a member change his nomination? Yes. Then tell me, when we talk about OPC, how many companies can I be a member or nominee? I can be a member of one OPC and at the same time a nominee of one more OPC. That means one member, one nominee. Now, if in case because of this nomination I become member of two OPC, what will happen? Within 182 days. Okay? It is 182 days, not 180 days. It is 180 days. I'm so sorry, not 182 days. Within 180 days. It is not 182, it is 180. It is misprinted in the ICI book. It is not 182 days, it is 180. Within 180 days, what I should do? I must fulfill the requirement of the Act. Now tell me, what are the restrictions on OPC? What are the restrictions on OPC? Minor cannot be a member or a nominee. Then it cannot be, please understand, it is nothing but an upgraded version of sole proprietorship. So the motive is always what? Profit. So it can never be a non-profit company. Then no, it can. It can. Section 8. It cannot incorporate as or convert to a Section 8 company, but it does not restrict it from converting into a public or a private company. OPC can convert into a private or a public company. It cannot convert into an OPC. Cannot operate as an NBFC. That is, it cannot carry on the activities of a non-banking financial company. Cannot invest in the securities of any body corporate. Securities bola, not shares. Securities means both shares and debentures. Body corporate, just general, it includes a foreign company. Is it clear to everyone? Any doubt in any of the points of OPC? Can I move to the next one? Yes? Tell me, private company. What is a private company? Has a minimum paid up capital as may be prescribed. When I say prescribed, no, the word prescribed means prescribed by the central government. Central government has not prescribed anything as of now. Right? Central government has not prescribed anything as of now. And by its article, that means the articles of every private company will have these clauses. First, restricts the what? Transferable. I'm not saying you cannot transfer. You can transfer, but subject to certain conditions. Limits the number of members to how many? 200. So it is what? Minimum to maximum 200. It is what? Minimum to maximum 200. Now, while counting this 200, if my employees have shares, they will not be counted. Please understand, they are members. They have all the rights of the members. But while counting the limit of 200, we don't count the employees. The employees are not counted. Employees and ex-employees. Every ex-employee, no. Don't write in the exam ex-employee. It is wrong. Ex-employees who acquired the shares while in employment and continue to hold them even after the employment ceases. That means when I was an employee, I took the shares. I left the job, but I did not leave the shares, right? Then I will not be counted. But after I left the job, I took the shares. Will I be counted or not? Yes. So there is this one very interesting question, Jagannath Mills. It has something related to this only. So that question actually talks about leaving the shares after leaving the job and all that. Anyway, joint holders. So for practical question, this is very important in calculating. So it's not that they are not members, but to figure out 200, they are not counted. Then joint holders are counted as single members. Mr. Das, Mrs. Das, Master Das. Three. Okay? Mr. Das, Mrs. Das, how many? One. Mr. Das, Mrs. Das, and Master Das, how many? One or one and a half? A half okay? One. Is it clear to everyone? Prohibits. You cannot do. When I say restricts, you can do subject to conditions. But when I say prohibits, you cannot do. Prohibits invitation to the public to subscribe in the securities. That means you cannot invite the public to take up either your shares or your debentures. A private company has 150 members and a private company has 750 debenture holders. Can it have? A private company has 150 members and 750 debenture holders. Can it have? 150 members and 750 debenture holders. Can it have? No. Yes. How many of you say yes? Yes. How many of you say no? Why no? क्या ज्यादा है? ले रहा है मैंने दे दिया इसमें ज्यादा क्या है? The restriction is on numbers. The limit is on what? Members, not on debenture holders. You can have more than 200 debenture holders also. Yes, you cannot offer it to the public. Is it clear to everyone? Ma'am, how can I have 750 then? Through private allotment. I can make private allotments. I can make it private allotment is there, no? Private placement of shares, private placement of debentures. That I can do. But members cannot be more than 200. But debenture holders can also be more than 200. Okay? Private company, public company. Very funny definition it looks. But when it says which is not a private company, what it means is these three restrictions which are there in a private company, they are not there in a public company. Means shares are freely transferable. They can offer the securities to the public and the number of members is infinite. Now, ma'am, do we count employees? अरे भाई infinite है, count करो नहीं करो क्या फर्क पड़ता है? There is no need to count only because the number is unlimited, right? Has a minimum paid up capital as may be prescribed. I already told you. Before 2015, it was 1 lakh and 5 lakh for private and public company respectively. Since 2015 amendment, it is what? Removed. Now, nothing has been prescribed. Company which is a subsidiary of a company not being a private company shall be deemed to be a public company. What does this mean? Not being subsidiary of a company, not being a private company, can I say it's a public company? X limited, Y private limited. What is the difference between the two? Huh? X is a public company. X is the holding of Y private limited. So Y private limited is what? Subsidiary. Can I say Y private limited is a subsidiary of X limited? Can I say Y private limited is a subsidiary of a company which is a public company? Yes. Can I say Y private limited is a subsidiary of a company which is not a private company? Yes. That means, can we say it fulfills the subsidiary of a company not being a private company? So Y private limited is what? Deemed to be a public company. Oh, ma'am, that means now it can remove the words private from its name. What and no? In its articles, it is still what? A private company. In its articles, it is still a private company, but Companies Act will apply on it as if it is a public company. Like some provisions will apply to public companies only, it will apply to this company also. In its articles, it is still a private company, but Companies Act will apply on it as if it is a what? As if it is a public company. होता है ना, some provisions don't apply to a private company, some provisions don't apply to a public company. That way. Is it clear to everyone? Yes? Small company. Can I say small companies on the basis of size? And on the basis of size, we only have obviously one company, which is what? Small company. Can I say a small company is not a private public company? That means, can I say only a private company is a small company? Yes. What happens if you become a small company, Vesey? This is my office. Am I a small company? Are nahi re baba. Small? What happens if you become a small company? You enjoy certain privileges and exemptions. What happens? You enjoy certain what? Privileges and exemptions. That is it. Huh? Tell me more. There is no such requirement of minimum share capital. Exceeding limit is there, but there is no minimum requirement. Maximum is there. So when you become a small company, but the paid up capital is not a exemption you enjoy. Exemption is something else. Companies Act gives you certain exemptions. Like annual return has to be signed by a director and a company secretary. But if you are a small company, anyone can sign it. So like that, you enjoy privileges. When do you become a small company if you fulfill two conditions? First, your paid up capital does not exceed 50 lakh or such higher amount not exceeding 10 crores. And your turnover does not exceed how much? Your turnover does not exceed 2 crores. A turnover as per the PL of the immediately preceding financial year does not exceed how much? 2 crores. Or such higher amount as may be specified not exceeding 100 crores. Today it is what? 50 lakhs and 2 crores. But we give the power to the government that you can increase it. And using this power, last year budget, the government increased this from 50 lakhs to 2 crores, from 2 crores to 20 crores. But that they have just notified. The act has not been amended. So that is why in the act you cannot directly write paid up share capital 2 crores or 20 crores. Act the original definition will stay. It will just become as a what? Notification. However, last year September they again amended it. Yes. And now the figure is 4 crores and 40 crores. So if a company has a paid up capital not exceeding 4 crores and turnover as per the PL of the immediately preceding financial year not exceeding 40 crores, then the company is a small company. But please remember, you cannot write 4 crores here. You cannot write 40 crores here. Here it has to be 50 lakhs and 2 crores. You will add it as a what? Notification. Huh? Yeah, like this you will write. This is just a rule which has been issued. Clarifications are given. So this clarification was given. The act has not been amended. However, this clause shall not apply to holding and subsidiary company, Section 8 company, or a company governed by special act. That means even if they fulfill these criteria, they don't get the status of a small company. When I say no, don't get the status of a small company means what? They don't enjoy the privileges of a small company. Is it clear to everyone? Can we move to the next part? Yes. Let's take a. Huh? Yes, please. Huh? I cannot hear you. If you get a question, so let's say you get a question on small company. So which figure will you consider? You have to consider, huh? So let's say a company X Private Limited, let's say X Private Limited has paid up capital of 2 crores and turnover of 35 crores, and they tell you, is it a small company? Is it a small company? Huh? एक minute, you are not getting my point. I did not say that when I say it is not being changed, what did I say? The act has not been changed. But what was given here, please pay attention here. Please don't make a blunder in the exam. Listen carefully. Paid up capital not exceed 50 lakh. What is the proper definition? Or such higher amount as may be specified not exceeding 10 crores. The power has been given to the central government. Today the figure is 50 lakh, but if you want to increase it, you can increase it. Can you make it 2 crore? Yes. Can you make it 6 crores, 9 crores? Yes. Can you make it 10.5 crores? No. Maximum power is 10 crore. Using that power, the government, and here it was what? Not, and same thing, not exceeding 100 crores. Using that power, the government made a declaration that from now onwards, the figure of small company will be what? 4 crores and 40 crores. Now, when I said the act has not been amended, the act has given the power using which they have increased the slab. But the act is still not amended. But this notification works as an amendment for this definition. When I say act has not been amended, what I'm trying to say here, you cannot write 4 crore. But as of today, the figure is what? 4 and 40 crores. And how will you write it? You will write it as a footnote. Right? That it has, see what is written as per company specification of definition details, paid up capital and turnover shall not exceed 4 crores and 40 crores. So the act has given the power to the government that you can increase it. Using this power, from 50 lakh, the government increased it to 4 crore. But under section 285, it is written as what? 50 lakh. And this will be given as a note to your answer. Now is it clear? Now tell me, X Private Limited paid up capital is 2 crores and turnover is 35 crores. Is it a small company? Is it a small company? What is the figure? You take 50 lakhs or you take 4 crores? 4 crores. You take 2 crores or 40 crores? 40 crores. Does it fulfill the criteria? Is it clear? Please make a note. Please write the example if you are confused. So, is it a small company? Yes. But when you write the definition, in the definition, you will write 50 lakh only. You will clarify this as a note. हमारा break इसी में ही चला गया. Give me 2 minutes break. हाँ. Those who went outside right now, you will solve this question and give me the answer. No, because I've already discussed it with the others and it's an important thing that we need to discuss. Yes, those who were out, please keep your phones inside and give me the answer to this question. Huh? You were also out. You were seriously there. I saw you coming from there. Yeah. Huh? Acha? Tell me the answer. Actually, this is an amendment and everyone is getting confused with this amendment. That's the reason I'm asking you. Listen, X Private Limited has a paid up capital of 2 crores and turnover of 35 crores. Is it a small company? Monica, you all were out. You all were out. Please, this question is for you guys. We have already discussed it because I don't want you to make a blunder in the exam. That is why I'm asking you again and again. Is it a small company? Will you consider 50 lakh 2 crores or will you consider 4 crores and 40 crores? Huh? Because I said the act has not been amended. People thought what I'm trying to say is the figure is still 50 lakhs and 2 crores. No. See, the act says 50 lakh, but it can be increased to 10 crores. That means the act has given the power to the central government. If you want to increase beyond 50 lakh, you can do, but your maximum power is how much? 10 crore. Now, the amendment has not been made in the act, but the clarification has been given by the central government that now this 50 lakh is 4 crores and this 2 crores is 40 crores. But since the amendment, the respective amendment is not done in the act yet, that is why in the act you cannot write 50 lakh. You have to add it as a what? Footnote. But the figures to be considered is what? 4 crores and 40 crores. The figures considered is not 50 lakhs and 2 crores. No. The figure is what? 4 and 40 crores. So now tell me, is it a small company? How much is the paid up capital? 2 crores. Does it exceed 4 crores? No. Is it a small, is it fulfilling this condition? Yes. Turnover should not exceed how much? 40 crores. What is the turnover? 35. Is it fulfilling? Yes. Is it a small company? Yes. What I am trying to tell you is the figure has been amended from 50 lakh to 4 crores and 2 crores to 40 crores. But this has been given as a declaration by the government, a notification by the government. But this respective change is not yet done in the act because to change the act, I need to get the consent of the parliament. But the power is given to the central government and they have notified it. So because they have notified it and it is coming, it is an amendment, it is coming as a what? Footnote. But the figure to be considered is what? 4 crores and 40 crores. And what was last year? 2022. September 2022. The rule is 2014. This rule is 2014. The amendment, 8 minutes. Companies Incorporation Rule 2014, which talks about OPC. Last year, there was an amendment in the definition of resident. Will it change the year of the rule? No. The amendment, Companies Amendment Act 2017 was there. So will Companies 2013 Act become 2017? No. Is it clear to everyone? Can I move forward? Yes. Yes. Holding subsidiary and associates. Okay. This is on the basis of what? Control. This is on the basis of what? Control. You have holding subsidiary and what? Associate. Right? Holding subsidiary and associate. Can we move forward? Yes. Now, holding and subsidiary are relative terms. When I say relative, their relation is interrelated. As in, if I am your holding, you are my subsidiary. If I am your holding, you are my what? Subsidiary. And this is in fact relevant from the is there. You can see it from the definition of holding. A company is said to be the holding of another if such other is its what? Subsidiary. A company is said to be the holding of another if such other is its what? Subsidiary. So I don't under I one thing is clear that holding and subsidiary are interrelated. If I am your holding, you are my subsidiary. But what exactly is a subsidiary, a holding subsidiary? So let's get into the definition of subsidiary. Maybe that will help us to understand what is a what holding or subsidiary. A company is said to be the subsidiary of another if such other, that means the holding either controls the composition of the board of directors or so anyone is enough, or exercises or controls more than one half of the total voting power, either on its own or together with one or more of its subsidiaries. Controls the composition of the board of directors means what? The right to appoint or remove the majority of the directors. Let's say company has 10 directors and 8 can be appointed by another company. So this is what controls the composition. So what is controls the composition of the board of directors? The right to appoint or remove the majority of the directors, right? Or so either one condition is sufficient. Exercises or controls more than one half of the total voting power. It's not shares, it's voting powers. If it was shares, then equity and preference both are considered. But when we say voting power is only with what? Equity, not with preference. Holds more than one half of the total voting power, either on its own or together with one or more of its subsidiaries. What it means? Let's say X Limited is holding 52% in Y Limited. Can we say it is the holding? Can we say X Limited is holding 52% of the total voting power of Y Limited? Can we say it is a holding subsidiary? Who is holding? Who is subsidiary? Who is holding? Who is subsidiary? X is the holding, Y is the subsidiary. Right? X is the holding, Y is the subsidiary. Now let's say X Limited and Y Limited. Okay. 52% of what? Y Limited. Can we say X and Y are holding subsidiary? Yes. Now X Limited holds 32% in Z Limited and Y Limited holds 29% in Z Limited. Can I say X Limited is the holding of Z Limited? Yes. Alone it is not, but if we whatever belongs to my subsidiary belongs to me. So if I take that, how much is it? 32 plus 29. How much does it come to? 61%. So is it holding subsidiary? Yes. So either on its own or together with one or more of its subsidiaries. Is it clear to everyone? Yes. Now moving on to the next one. Acha, can we say like this? X Limited is the holding of Y Limited. Y Limited is the holding of Z Limited. Yes, so X Limited is the holding of Z Limited. Yes or no? What is associate company? What is associate company? जितना interest के साथ you are listening to, maybe now I feel everyone is like, when will we get a break? It's not even 2 hours since the class started. Huh? What please? Huh? What? No, I just gave you 5 minutes break. Huh? I just gave you, huh? No, break I'll give it 5:15, 5:20. I gave you 2 minutes, 5 minutes break just now. Huh? What? I gave you 5 minutes break just 10 minutes back. Yes or no? When? Okay, listen, listen, listen. जल्दी से इसको खत्म करते हैं. What is associate company? When one company has a significant influence over another. X Limited has significant influence over what? Y Limited. Y Limited becomes associate. Can I call X Limited holding? No. Holding is only for subsidiary. In relation to subsidiary, we have holding. For associate company, there is actually no name for X Limited. But in general parlance, we can call it as a parent company or we can call it as the investing company, but never the holding company. Holding is only for subsidiary. What is significant influence? You are holding at least 20% of the total voting power or what? 20% of the business decisions. Right? What is significant influence? At least 20%. Yes, but does not include a subsidiary, which is not a subsidiary. What does this mean? It means 20 to 50 is what? Associate. More than 50 is what? Subsidiary. Second? Done all of you? Can we move to the next one? Do you have any doubts in whatever we have done so far? Are you sure? Huh? Every topic you will tell me break. Huh? 5:15, 5:20. Once we are done with companies act, I'll give you a break. Once we are done, it's not too much is not left. 27 slides are there. We are already in the 13th one. Huh? After? Just give me a minute. Huh? For the no, I never said give me 5 minutes. I said give me a minute. I wanted to check something. Go to the next one. Yes. So can we please? So moving on to the next one, government and foreign company. What is a government company? In which not less than 51. Now please understand here. Here it is more than half. But here it is what? At least 51%. That means there is a difference of almost 0.09. Right? 0.09 ही तो होगा. हाँ. So please don't 0.99. Whatever. Don't get confused with it. If it is 50.5, can it be holding subsidiary? Yes. But if it is 50.5, can it be government? No. Here it is minimum what? 51%. Now the paid up share capital is held either by the central government or the state government or both of them. And if a company is a subsidiary of a government company, if a company is a subsidiary of a government company, that is also considered as a what? Government company. The next foreign company, what is foreign company? Incorporated outside India but has a place of business in India. Now, when I say place of business in India, it can be physical, it can be direct or through an agent. That is, we can directly open up an office or we can hire agent to sell our products or services, and it can be physical or online. Moving on to the next one, Section 8 company. Again, another very important one. So what exactly is a Section 8 company? First of all, these companies are not incorporated with the These companies are not incorporated with the motive to earn profits. So, what are the motive of these companies? To promote sports, science, arts, religion, charity, commerce, technology, environment, right? And they do not distribute dividends. So, what do they do with the profits that they earn? They reinvest the profits into the business to promote its object. I'm a Section 8 company. I'm a Section. Do you become a Section 8 company? No, you don't. You have to apply for a license to the central government. You have to apply to the central government to give you a license. And once this license is allotted, you become a Section 8 company. You need not use the word limited or private. So that is why you will never see them using the word limited or private limited after their name. And even a partnership firm can be a member of such company. If these companies, you know MOA and AOA, if a company wants to alter its MOA or AOA, can it do so? Yes. But in case of a Section 8 company, if they want to alter, they need the approval of the central government. Now, if the company, see the company, let's say company is not supposed to distribute dividend, the company distributes dividend. What will happen now? Huh? Okay. So when the company breaches its objects, or when the company does not fulfill the conditions subject to which the license is issued, or when the company acts against public interest, or when the company acts fraudulently, in any of these cases, the government may what? Revoke the license. Now, when the license is revoked, any one of the three can happen. First, the company may be ordered to convert into what? A private or a public company. Okay? Or the company may be ordered to amalgamate with another Section 8 company. Or the company may be ordered for winding up. Before you pass any order, the company must be given an opportunity of being heard. But you know what? Converting it into private or public company is not that grave. But if you order the company to wind up or amalgamate, that's a very grave decision that you take. So it can be done only in what? Only in the public interest. Is it clear to everyone? Yes. What is a dormant company? I want to start a project on a future date. I have incorporated the company today that on a future date I will what? Start it. So what I do is I apply to the to the ROC that please give me the status of a dormant company. I'm not going to operate as of now. I will do operations on a future date. So ROC will now issue a what? It will issue a certificate stating that this company is a dormant company. Tomorrow, if it wants to become an active company, it will again apply to the central government that please, I want to become an active company. Central government will issue a, central government means power is delegated to ROC. ROC will issue a certificate stating, a form stating that they are now active company. So dormant companies, basically they are not doing any business operations. These companies are formed either for a future project or to hold an asset or intellectual property. And they do not have any significant accounting transactions. What is significant accounting transactions? There are four transactions which are not considered as significant accounting transactions. Everything other than this is significant. What? Any expenses made for any fees paid to the ROC. You have to see, you are a company, irrespective of you do business or not, you have to pay some fees to the ROC. So any fees which is paid to the ROC, if because any act requires that the company should pay some fees under that act. So to fulfill the requirements of the act, the company is paying some fees. That is also not considered as what? Significant accounting transaction. Allotment of shares, it's not securities, it's allotment of shares to fulfill the requirements of the act. What is this? If you are a subscriber to the MOA, minimum one share you have to take. So the company is allotting you the shares because it's a requirement of the act. or any expenses made for maintenance of office and records. These are not considered as significant accounting transaction. Anything other than these four is what? Significant accounting transaction. What is an inactive company which has not been carrying its business operations, or since the past 2 years it did not have any significant accounting transactions? For the past 2 years, it did not have any significant accounting transactions. Or for the past 2 years, it has not filed its or annual returns or financial statement with ROC. Actually, what happens, no, every year after my meeting, I have to file a copy of my adopted financial statement and annual return with the ROC. If for 2 years you have not filed it, you become what? Inactive company, right? With this, we are done with companies, types of companies. Before I move forward, I am giving you 5 minutes, not a break. Check any point you have any doubts. We'll discuss it before we move forward. Okay? Yes. Corporate deal. The concept or lifting? I've not done that yet. Lifting, I've not done that yet. Just give me a minute. I was actually checking your doubt only. You had told me na 2021. That's wrong in the book. So if you will check RTP, no, in the RTP is very clearly written it's 2014. The rules don't change. The amendments and notifications happen. So with effect from what they have written, that is correct. But 2021 is not good. The rule is 2014. Yes. So when we amend, those amendments are added. Now, if the rule is made in 2021, then it's 2021. But this rule is made in 2014. It was amended. So that is not correct. So that only I was checking. Did I make a mistake? So I was like, let me clarify, huh? Okay. So just a second. Okay, you wanted me to explain associate company. What is associate company? अच्छा इसको जल्दी जल्दी खत्म करते हैं एक क्विज करते हैं and then let's go for a break. I think all of you want that. Come on, the rest of the chapters are super easy peasy. है ना? छोटे छोटे chapters. Now listen. Uh, what we were talking about, associate company. Shh. X Limited holds 22% of the total voting power of Y Limited. Can we say Y Limited is the associate company of X Limited? Why no? So if X Limited holds significant influence, just because someone else has asked the doubt and it is not your doubt, does not make you eligible to talk. Shanti, baat kitna? I really have a query. Like when I talk to my very good friends also, I get annoyed after 10 minutes of talking. Like seriously, after 10 minutes of I'm talking, I'm like my hands start aching. And I'm like, why the hell am I not able to drop this call? And I have nothing to say after 10 minutes. And literally after 15 minutes, this is the way I actually start. Don't have the patience. I don't have the topic. Patience to chhod do. I don't have any topic. How I get topics to talk throughout the day? How? No, seriously, how? What's it topic happen? Please give me. Skill I should learn. I got skills, huh? This guy, he knows. He can talk, talk, talk. Huh? One more. Maybe that is the age difference factor is there. That is why you people can talk for 8 hours. I cannot. Right? वो तो छोड़ो. 8 hours is okay. Where talk? No, you are sitting here in the class every day together and you still ask how? How? Huh? Because this is the only time you get to talk. I we should have categories also. Oh, now I have to categorize. Okay, this is supposed to be the class. Okay, I cook food wherever. How does it make a difference? No, seriously, this is something that I should learn from you. How after 4 hours of non-stop talking, also you have something to talk. Okay, I want now. I want everyone's attention here. So basically, significant influence means what? 20% of the total voting power or 20% of the business decisions. If one company is holding in another company, the other company becomes its associate company. Okay? Who is controlling X? So who will be associate Y? Listed company and unlisted company, right? Who asked me that? Yes. What do I mean by listed? Company whose securities are listed at any stock exchange. First of all, please understand it is not the company which is listed, the securities are listed. So every time I bring a public issue, anything important, please pay attention. Okay? So every time that I bring a public issue, my securities have to be listed. What is a listed company? The securities are listed at any recognized stock exchange. So my securities are listed. But then, ma'am, why do I call Reliance? Because I need to distinguish one security from the other. And how do I distinguish? By the name. So the securities of the company are listed at any recognized stock exchange. What is unlisted? Which is not recognized, which is not listed. There is no definition for unlisted. When we talk about listed companies, if a company is offering shares to the public, securities, sorry. So even if it is shares or debentures, if I'm offering it to the public under Section 40, the company must get its securities listed. Section 40 of the Companies Act, आपके syllabus में नहीं है, don't worry. Public financial institutions, they are either formed under some special act or at least 51% of the share capital is held by the by the government, central or state or both, right? So when we say government, what? So I said that only at least 51%. Yeah, it's the same thing. They are saying either it is formed under the special act of the parliament or at least 51% of the total shares is held by the government. Okay? Is it clear to everyone? Just because it's a government company and public financial institution are not the same. Not every company is a financial institution. So that part of the definition is same for both. Is it clear to all of you? Yes. Can I move forward to the next part? Now, incorporation of company as given under section what? Section 7. Section 7, incorporation of company. Now, when a company wants to be incorporated, whenever we talk about any forms, remember, forms are given under what rules? So we have to fill in Spice Plus. It was earlier Spice, now it is Spice Plus, which has been amended, simplified pro forma of incorporating companies electronically plus. So I can make 4 applications in Spice Plus. Application for name, application for incorporation, allotment of then appointment of directors. Then the company will have to, along with the Spice Plus, the company has to file these documents. The company has to file these documents. What are these documents? First, MOA and AOA. The first document that the company needs to file is what? MOA and AOA. Then what is the next document that the company needs to file? A declaration. What is this declaration? Now, whenever a company is incorporated, no, we have to hire a professional. This professional could be an advocate or a CA or a CS or a CMA in practice, so that he can guide us with the incorporation. Now, this person, the CA, CS or CMA or the advocate, whoever we have hired, this person and any one of our director or manager will give a declaration. What? That whatever was the requirement of the act for incorporation of company, we have fulfilled it. We have fulfilled all the requirements of the act for the incorporation of the company. This declaration they will give. Another declaration has to be given. This is given by every director and subscriber. Director, subscriber, promoter, you know the differences, right? No. Promoter, subscriber, you know the difference? Huh? Huh? Who is a subscriber? Who's a subscriber? Okay. Okay. The declaration has to be given by every director and subscriber here. So every director and subscriber will give a declaration. Here there are three declarations. First, while I had incorporated some other company, I had not committed any fraud. Right? While I had incorporated any other company, I had not committed any offense rather. What offense? Giving false information is an offense. Second, in the past 5 years, while I was managing some other company, in the past 5 years, while I was managing some other company, I have not committed any fraud or breach of duty. Not this company. This company, though, I will incorporate now. But while I was incorporating some other company, I have not committed any breach of trust or any fraud. And whatever information is given is true to my knowledge. Along with this, he will send address for correspondence. He will send details of subscribers. What details of subscribers? What details of subscribers? Name, surname, family name, address, occupation, photo ID. And if the subscriber is a body corporate, then SIN. He will also send details of directors. What details? Name, surname, family name, address, occupation, photo ID. Here we don't have a SIN. We have a DEL. Can my director be a director or partner in any other company or firm? Yes. Declaration of such interest. And also the consent of my director to act as a director. These have to be filed along with Spice Plus. If ROC is satisfied that I have fulfilled all the requirements, they will issue a certificate of incorporation and allot a SIN. Is it clear to everyone? What happens if you are incorporated? This is again important from exam point of view. They've never asked incorporation per question, but they have asked in questions on false information. What happens if the company is incorporated by giving false or incorrect information? Before incorporation, every person who had signed the document and knows about the fraud is liable under section 447. Section 447 is actually a section for fraud. You will not see, you don't need to study it here because it's not there in your syllabus, but the imprisonment can go up to 10 years also. Up to 10 years also. Minimum is 6 months, and if it is against public interest, minimum is 3 years. It can go up to 10 years also. Okay? Again, so I repeat again, if the company is formed by giving false information, there are two cases. We come to know that the information is false either before incorporation or after. If before incorporation, I come to know that the company was incorporated by giving false information, every person who signed the document and who knew about the false information is liable under section what? 447. After incorporation, now here there are two persons who will be fined. Persons who signed and also the company. Before incorporation, the company is not there. We cannot punish the company. After incorporation, the company is also there. No. So we can what? Punish the company. So after incorporation, every person who signed. Before incorporation, it was only the person who knows about it. After incorporation, every person who signed, irrespective of whether he knows or he does not know, every person who signed is responsible under section what? 447. And the tribunal can pass any of the orders against the company. What orders? Five orders are there. First, orders for the management of the company. As in, can pass an order that the existing management be removed, or we will appoint the management, or management will work as per our guidelines, whatever. Second, second can make the liability of the members unlimited. Again, strike off the name of the company, wind up the company. Or apart from this, we have given one open right to the tribunal. Apart from these four, if you want to pass any other orders, you can pass it. So any other order, it deems what? Fit. But before it passes any order, it must what? It must give the company a chance to speak and also take into consideration all the contracts which have already been entered. Is it clear to everyone? Are you sure? Okay. MOA, AOA, why will they change it? Huh, for what? MOA. Anyway, they, you see, anything that they deem fit. Anything. So if they feel that that needs to be changed, they can pass it. No, stop from the fraud. It's not necessary that MOA से ही fraud हो रहा है. ऐसा नहीं है ना जरूर. So that depends on the situation. So that it is open ended. कुछ भी pass कर सकते. चलो चले next topic पे. What are the cases where now the moment company is incorporated, no, a thin wheel comes between the company and the members. This is a wheel which I cannot see or touch, but it distinguishes the company from its members. That is, the company and the members are not the same. Company is not liable for the member, member is not liable for the company. But in some cases, this wheel is ignored. That is, the company and member are taken as one. That is, the member is taken liable for the act of the company. Okay? As such, under the Companies Act, we only have 2-3 sections where the wheel is lifted. But there are many judicial cases where the wheel has been what? Lifted. And on those grounds, we can say that in these cases, the wheel may be lifted. When I say the wheel is lifted, means what? The company and member is taken as one. For the first case, the name of the case was Sir Dinshaw Manikji Pettit. And there was also another case, Juggilal versus Income Tax Commissioner, where the reason you have formed the company was to avoid the payment of taxes. Where the reason you have formed a company was to avoid the payment of taxes. The court can ignore the wheel and consider the member and company as one. Second, where the company is a sham or fraud. There are two cases, Jones versus Lipman, and what was the second case? Guilford Motor Company versus Horn. Right? So in these cases, that means what? Where the motive to form a company was to do some fraud. You were directly not allowed to do something. So you formed a company so that through the company you could do it. This is what? The company is a sham or fraud, and the wheel was what? Lifted. The third one, where the company was formed to avoid welfare legislations. I can see you all are so like, oh my god, अब छोड़ दो यार आप मैम हमको है ना? So, not worry, another 20 minutes we will be done. So, and the Kannada ಗೊತ್ತಿಲ್ಲ. So, where the company, huh? Means you should teach me Kannada. I am teaching you law. You teach me Kannada. Not paying us, ma'am. This even I am not getting paid for these classes. Just doing some social service. Correct or not? So, Asha, tell me. Company, the company is formed for welfare legislations. So, where the company, motive, the name of the case was the workmen of Associate Rubber Industries Limited, Bhavnagar, versus the Associate Rubber Industries Limited, Bhavnagar. Where the only reason welfare legislations means there are some laws which are created to what? For the welfare of the society. There are some laws which are created for what? The welfare of the society. Where any contract is made which is where a company is made just to avoid these welfare measures, just to not pay for these welfare measures, the wheel will be lifted. And the last one, to determine the true character of the company, the name of the case was Daimler Company Limited versus Continental Tire and Rubber Company Limited. Here, what happened was the company was formed. Generally, the members do not define the company, irrespective of who the members are. If a company is incorporated in India, we'll call it an Indian company. But here, what happened was just to because there was a war going on between the two countries, just to determine whether the company was an enemy company or not, the wheel was lifted so that we could find out whether the what do you say whether the company is an enemy company or not. So here, even though the company had not done anything wrong, but just to determine whether the company is an enemy company or not, the wheel was what? Lifted. This is clear. You want any example? I can explain it to you. We'll take a break now. I think you will kill me if I don't give you a break now. Okay, so tell me, I know I went a little fast with all the types of companies without any, excuse that I did not. I know I did. So before I actually move to the next topic, tell me, do you have any doubts in any type of the company? Please, the purpose and the motive is that when you leave the class, you should be 100% clear. Any of the types of company you want me to explain with an example or anything, I'll do that. Huh? No one. No doubt. Uh-huh. Huh? Since they're confused. Huh? It does not have any minimum or maximum limit. Earlier it was there. It is amended now. Now we don't. In OPC, there were four amendments. First, it was you have studied earlier. Okay. I'll tell you the amendments. Please note it down. First, don't note it down. Please make the rectification. First, it was resident of India was mandatory. Now it is not mandatory. So he can be a resident or may not be a resident. Second amendment was earlier it was 182 days to be resident in India. Now it is 120 days. Okay? Third amendment was it cannot convert for up to 2 years into private or public. That's removed now. Now it can convert anytime. It cannot convert into a Section 8 company, but it can anything else? Anyone has any doubts? मुझे लग रहा है हाँ होना चाहिए. You people don't have doubts. Huh? I just what did I do? You people studied wherever you studied. Private doubt. My uncle, let it be. Girlfriend? No. You don't have or trying to make one? You don't have. So trying to make one. Huh? Huh? No, no. Acha. That is why using more than all of us. Huh? She told me she will leave. Okay. Bolo, any other doubt you have? Holding subsidiary associate is clear to everyone. Yes, holding subsidiary associate is clear to everyone. Yes. Government foreign to kuch hai nahi. Section 8 company is clear. Yes. Okay. Now moving on to the next one. Memorandum of association. What exactly is a memorandum of association? To be very honest, if I look at this definition also, the definition is definitely giving me some. Anyway, a memorandum means a memorandum as originally framed and altered from time to time. Right? Does not tell us anything about what a memorandum actually is. But yes, this definition has a meaning, but does not really define us what a memorandum is. But if I say it is the most important document of the company and tells us what the company can or cannot do. Section 4 of the Companies Act gives us all the clauses of memorandum. What are these clauses? Matlab they will actually come. Lock the door. So they will actually come. These people will come at 6 o'clock only, I think. Lock kar do door. Everyone will keep opening. Where were you since so much of time? Huh? You went to cool join. No, here nahi. Matlab it's half kilometers. You have to walk for 10 minutes. That's a bike. Tabhi. Tabhi. So tell me, extended break, preparing snacks. Acha. So the 6 clauses of memorandum is what? Name clause, object clause, capital clause, liability clause, association clause, and situation clause. Not exactly in that order. So the first clause is what? Name clause. The name of every company should end, please do not talk, with the words limited or private limited. In case of OPC, it is what? OPC. But a government company need not have the word limited or private limited after its name. Tell me, which other company need not have the word limited or private limited after? Section 8 company. The second clause is the registered office clause or the situation clause. Tells us the domicile of the company, that is which state the company is situated in. Right? Which state the company is situated in. And when we say registered office, it does not have the address. It does not have the address of the company. It just states the name of the state. So if it is situated in Bangalore, it won't write Bangalore. It will write what? Karnataka. But within 30 days of incorporation, the company must have a what? Registered office. And whenever you have a registered office, you have to send a verification to whom? To the ROC. Within how many days? Generally, everything is sent to the ROC within how many days? 30 days. You will send a verification with the ROC within how many days? 30 days. The next one is the object clause of the company. Tells us what the company can do. And when it tells us what the company can do, it automatically tells us what the company cannot do. It does not say company cannot do this. But when it says company can do these 10 things, it automatically means company cannot do anything other than these 10 things. And if the company does anything which is against the MOA, it is what? Ultra wires. Then capital clause, it tells us what is the capital of the company. But it cannot just say the capital is 1 crore. It has to give us the division also. It has to give us what? The division also. So when we say division, as in divided into 10 lakh equity shares at the rate of rupees 10 each or whatever is the classification. It has to show that also. The next one is, Ajay, can I say if the company has no share capital, this capital clause will not be there in the MOA of that company? Yes or no? If there is no capital clause, the company shall not have this capital clause. I mean, if there is no capital. Liability. It states the liability of the company. If you remember, in both limited by shares and limited by guarantee, the definition says what? Liability is limited by its what? Memorandum. Having the liability of the members limited by what? Memorandum. So this, where do they limit it? It is limited under which clause? The liability clause. So basically, the liability clause tells us what shall be the liability of the what? Members. What shall be the liability of the members? Whether it is limited by shares, if it is guarantee, it will tell us what is the guarantee given by each member. We don't write composite. It will tell us separately. And if it is unlimited liability, it will tell us that the liability of the member shall be what? Unlimited. Then the last one is what? Association clause. What is association clause? The people who form the company. The people who form the company. The people who form the company, they give a signed declaration that we hereby declare we are forming this company. Right? Now let's just talk about these two words, promoters and subscribers. Let's say A got an idea for a startup, but he did not want it to be an OPC. See, it's very difficult to operate an OPC. Akele kaam karna. He got an idea. So A got an idea for a startup. He took B and C to start this private company. A is the promoter. A, B, C are subscribers. This is the basic difference. Promoter is the person who gets the idea. If I say it in a very layman and basic term, promoter is the person who gets the idea for a particular business. Subscribers are all those people who start the company. In some cases, promoters and subscribers could be exactly the same. In some cases, it could be more subscribers could be there. So when they sign the memorandum, they become the subscribers to the what? Memorandum. And this is what? Association clause. I hope it's clear to everyone. Are you sure? Yes? What is the basic difference between memorandum and articles? Memorandum tells the relation of the company to the what? Outsiders. Articles tells the company's relations internally. Memorandum tells us what the company can do. Articles tells us how the company will do it. Everything. Whether company can issue equity shares, whether company, you know what, when you will go to internal, you will see a lot of things. Can the company allot the shares? Can the company bring bonus issue? Can the company bring rights issue? Can the company issue sweat equity shares? What should be the quorum of the company? Everything. Articles. So companies' articles can contain anything and everything. How many directors the company should have? Everything is given where? In the articles. Articles and memorandum, they can never override the act. Override means going against the act. They can never go against the act. They can only be subordinate to the act. And as far as they go against the act, that clause itself is not valid. In memorandum, we have 6 clauses. We study them. And these clauses are given under section 4. Can they ask you a question? What are the clauses of memorandum? Yes, it has been asked once. Right? But you will never be asked about clauses of the articles. It goes on for pages and pages and pages. They don't even teach you that. Right? So we don't do. Section 5, basically, which talks about articles, talks about an entrenchment clause. It talks about an entrenchment clause. So what is this entrenchment clause? Entrenchment means providing additional safeguards. Okay, providing additional safeguards. You know, whenever can I alter my MOA or AOA? Let's say my company stated that the quorum of the meeting of the company shall be 10. Okay? Now the company now the company wants to change this quorum from 10 to 15. Can the company change its articles to make the quorum from 10 to 15? Yes or no? Yes. You all are the members of my company. We want to change the quorum from 10 to 15. Can I alone do it? Or do I need your consent? Votes have to be taken. Every decision is taken by voting, which is given under section 114 and 115 of the Companies Act, which you will do in CA intro. Generally, voting कैसे होता है? Votes in favor are more than votes against. This is the general way. And we call it as the ordinary resolution. But if this happens, no, the minority is actually what? It's not right on the minority, no, simple 51%. So with that view, Companies Act talks about a more stricter resolution, which is known as special resolution, where the votes in favor must at least be 3 times the votes against, that is 75%. Ordinary resolution is what? More than 50. But special resolution is what? More than 75% or more. Where it is ordinary resolution, where it is special resolution, you don't have to decide now, or nor do you need it now. But in CA Inter, you have to study. You don't decide it. Companies Act has given it for you. Okay? If a company wants to alter its articles, for alteration of articles, we need to pass a special resolution. Right? To alter my articles, I need to pass what is special resolution? 75%. But so let's say there are a lot of clauses in the articles, and if I want to change any of these clauses, I need to pass what? Special resolution. Company wants to make this clause a little strict. Company does not want this clause to be so easily changeable. So company says that for all the other clauses, obviously we will need what? 75% vote. But for this clause, we will need how much? 90% vote. This is an entrenchment clause, providing additional safeguard. It was not there before 2013 Act. It's a special feature of the 2013 Act that is providing additional provisions can be altered. That is, the specific provisions of the articles can be altered only if more restrictive provisions are complied with. Is it clear to everyone? For the rest of the clauses, still it is what? 75%. But we mentioned to alter this clause, we need consent of how many? 90%. So now to alter this clause, what consent we need? 90%. Is it clear to all of you? Yes. This clause, this entrenchment clause can be added either at the time of what? Incorporation. So if a company is being incorporated, at that time they can put this clause in their articles. Or it can be done as an what? Amendment. Right? It can be done as an amendment. When we say amendment, in case of a private company, for this amendment, we need the consent of all. But for this amendment, in case of a public, that what does this mean as an amendment? If I have added it at the time of incorporation, fine. At the time of incorporation, I did not add this clause. Later, Company was incorporated here. I did not add this clause, but here I want to add it. So my articles was already made here. So here what do? I alter my articles. This is what? Amendment. Is it clear? And in case of a public company, we need the consent of at least, that is special ref. Is it clear to everyone? This is an entrenchment clause. I hope it's clear. Can I move forward to the next topic? Now, if the company does any act which is against its MOA, such act is what? Ultra vires. What do I mean by ultra vires? Ultra means beyond, wires means powers. So it means what? Beyond the powers of the company. See, when I say ultra wires, no, it can be ultra wires the act, it can be ultra wires the MOA, it can be ultra wires the AOA. When it is ultra vires the act, that means act is saying you cannot do it, but you are doing it. Obviously, it is what? Can we also call it as illegal? Yeah, because you're going against the act. If it is ultra vires the MOA, is it illegal? No. You're not going against the law. It cannot be illegal, but it is what? Void ab initio. But if it is ultra vires the AOA, it is void, but can be ratified. Ma'am, how can it be ultra vires the AOA? The directors can do it with the consent of the shareholders. Now, directors do, but they don't take the consent of the shareholders. So, in that case, they are allowed to do it. But article says consent of shareholders should be taken. So, they can take the consent afterwards and ratify it. Right? But if MOA says you cannot do it, can you do the act and then ratify it? No. No. That is what? Ultra vires. Is it clear to everyone? So now, when I say ultra vires the MOA, that means MOA says you cannot do it. This whole concept was laid down in the case of what? Ashbury Railway Company versus Ritchie. You have to remember the name of this case. You have to remember the name of this case. I'll just give you a little bit of gist. As per the MOA of this company could not give loan. But this company made a contract with what? Ritchie to give a loan. So when the company was not allowed to give a loan, but the company gives a loan, right? The company was not allowed to give a loan, but the company gives the loan. It is what? Can we say ultra vires? Yes or no? And if it is ultra vires, the MOA, it is what? Void. Void. So the consequences, remember these consequences also because they ask in the exam. What are the consequences? Now listen carefully first. It is what? Void ab initio. Now what the company did was the company made a contract. And this contract was what? Ultra vires. The company called the meeting of the shareholders. You know what? Amazing contract. If we make this contract, company will earn super. You people should say yes. Everyone was like, oh, we will earn. Array, next year, full pakka high dividend you will get. Oh, you high dividend will get. Huh? Oh, then do. Everyone votes in favor. Every single member votes in favor. Tell me, will it become valid? No. No. Even the whole body of shareholders cannot. So, ma'am, I can never give loan. Please alter and then give loan. You cannot give loan and then alter. Right? What you are trying to do is you are trying to give the loan and then trying to alter. You cannot do this. If you want to give the loan, you first alter and then you give the loan. This is allowed. This you can do. Is it clear to everyone? Are you sure? Pakka? So it even the whole body of shareholders cannot ratify it. Now tell me, can a single shareholder sue the company? Yes. Generally, can the shareholders sue the company? Yes. But you will see later on when you do the act, no, somewhere they will say 5% holding, somewhere they will say 1% holding, somewhere they will say minimum holding is required. But here, even if I'm holding one single share of the company, I can still go and sue the company. So even a single shareholder can what? Sue the company. So by ultra wires, there everything is understood. Someone should be liable. Who will be liable? The directors are personally. Is it clear to everyone? Are you sure? Pakka? Yes. So please remember the consequences they ask. And these doctrines are very important. They ask questions from the doctrine in the exams. Okay? In fact, last term only, I think it was doctrine of indoor management. Yes. In second question, the compulsory question, sorry, 1B. What is doctrine of construct? Now tell me. Arey ma'am. Okay, you say company cannot make company made it void ab initio, but what is Richie's fault, ma'am? How will Richie know? Bichara Richie, third party, how will Richie know, ma'am? This is wrong on Richie. Ma'am, should he become what? Should he become Sherlock Holmes? Raat ko open the office, windows, break it, enter. Read the MOA. And bhai, don't. Please, you are watching too much of drama, okay? Nothing like that. What the act says is, you don't have to do all this drama because all these documents, whether it is MOA, whether it is AOA, everything is filed with whom? With ROC. And whenever a document is filed with ROC, it becomes under section 399. And it is what? It becomes a public document. And it is deemed that, right? It is deemed that every person dealing with the company has knowledge of it. I will not ask you, Arey Richie boy, did you read my MOA? Arey, go read first. You have come to contract with me, means you have read. See, what is the difference between real and constructive notice? I tell you, today the class does not get over. Tomorrow I'll take the rest of the chapters. Okay? I'll take the because yes, I can try and finish it off. If you are ready to sit, I will also sit. That is not a problem. Let's see. I'm not any. I'm just saying. So I will not be able to finish the syllabus today. Tomorrow I'll take the class. Okay? I'll take the class from whatever time I say. Let's say I say 2 o'clock. You're like, okay, ma'am. Chalo, done. Khatam. This is what real notice. I say, look, I have a class from morning to night. Yesterday though was so horrific. The day was like, oh my god. So let me go back home and let me understand, do I need to take a break in the afternoon or not? So tomorrow morning, sharp 7 o'clock, I will put a story on my social media. I'm a social media addict. Even you guys are social media addict. Everyone is social media addict. Please see that notice and be on time. And if it is 2 o'clock, if you come at 2:05, also no entry in the classroom. Again, right? I say that. So now tomorrow, if the class is at 2, can I imply that you have read my story in the morning on every social media and have come? Yes or no? And if you don't come, am I responsible? No. Because when I told you that tomorrow I'm going to put up a story, please check. I imply that every one of you has done that. Right? I imply that every one of you has done that. So this is what constructive notice. Constructive means I'm not telling it to you, but I imply that since you are coming to contract with me, you already Since it's a public document, you cannot say, ma'am, where will I get it from? Go to ROC's office, no? ROC's office, you will get every document, and from there you can read it. And before you come to contract with me, I will assume that you have read it. Can we say doctrine of constructive notice gives a protection to the company against the outsiders? Yes or no? It protects the companies against the outsiders. Fine, I agree. External documents, public documents, I should know. But do I need to know the internal documents also? No. So, if a company is allowed to do something, if a company is allowed to do something, but they have to pass some resolutions, will I go inside the company and check whether the resolution was passed or not? No, that is not my duty. You are coming to Yashas Academy. Okay, you want to come take admission. Ma'am is sitting there. Will you go to every person and ask, hey, ma'am has authority, ma'am has authority, who gave her authority? Will you do that? They will throw you out of the building. Get lost. We don't want a CA student, right? Just because you become a CA student, too much of law application you are doing. As an outsider, you just have to know that the ma'am who is sitting there in the office, she has a right to collect the fees or not. But who gave her the right is not your concern. You have to see whether the company, whether the directors can do something or not. How they got the authority to do it is not your concern. Right? This is what? This is doctrine of indoor management. The outsider is not concerned about the indoor management of the company. So let's say the directors can do it, but they must pass a special resolution for it. So what I as an outsider need to check is do the directors have a right to do it or not? Whether the resolution was passed or not is not my concern. And this is doctrine of indoor management. Can I say it protects the outsiders against the company? Yes or no? It protects the outsiders against the company. If there is any discrepancy in the internal management, the outsider is not liable. So let's say the directors can accept money, but only if shareholders' consent is taken. They took the money, but they did not take the consent of the shareholders. Is the outsider liable for it? No. I repeat again for those who did not understand. The AOA of the company says that the director can take a loan. But for the director to take a loan, they must get the consent of what? Shareholders. They must get the consent of the shareholders. Now the directors take the loan, but they don't take the consent of the shareholders. Are they liable to repay that money or not? Can they say indoor management? No. As an outsider, my duty is to check whether the director has a right to take the loan or not. How the director got the consent or the authority to take the loan is not my concern. Is not my concern. Is it clear to everyone? Are you sure? Pakka? So, as an outsider, I only have to check whether the company has a right to do something or not. How they got the right is not my concern. This concept was, in fact, laid down in the case of Royal British Bank versus Turquin. You should remember the name of the case. Like, you know what happened? Because of this, no, many people started misusing it. And because they started misusing it, the court finally declared that there are declared some cases which is a locha to the rule of constructive notice. In these cases, you cannot claim any relief. The name of the case was Royal British Bank versus Turquoise. What happened in this case was this bank was allowed to issue bonds up to a certain limit. I'm just taking an imaginary figure up to 200 pounds. The board of directors could accept it. But if the amount of bonds was more than 200, they needed the approval of the what? Shareholder. Okay. Now what happened? This bank issued bonds of £2,000. In fact, the outsiders asked also, do you have the right to issue? You are issuing so much of bond. They were like, yeah, yeah, don't worry, we have the authority. Don't worry. One person who had taken up the bond becomes insolvent. So when this person becomes insolvent, a liquidator was appointed. The name of the liquidator was what? Turquin. The name of the liquidator was what? Turquin. So this Turquin liquidator was appointed. And what is the work of the liquidator? He will sell off your, realize your assets so that he can pay off your liabilities. So while realizing the assets, he will realize the money on the bonds also. So when he went to the bank to encash the bonds, the board of directors were like, sorry, the bonds will not be repaid because the company was supposed to get the approval of the shareholders and they never got the approval. So can the bank refuse to give the money to Turquoise or is bank liable to give? All of you will answer this. Bank is liable to give or the bank can refuse to give? The bank is liable to give. So it is the duty of the bank to pay the money. Because as an outsider, I only have to see whether the bank has the authority to issue the bonds or not. How the bank got the right to issue the bonds is not my concern. Right? So in this case, it was held that indoor management is not the concern of the outsiders. Lekin, over the years, because of this, a lot of people started misusing it. So they came up with a lot of what? Exceptions. The first one, knowledge of irregularity. Now you know consent was not taken. Can you go and say, oh, I am an outsider, what is my concern? No, you know. When you know, you cannot claim any relief. Negligence. Now, ma'am, can the ma'am sitting in the office take my fees? Okay, you have to say, check whether she can take the fees or not. Okay. Now, there is a security guard. You have those security guards, no, who wear the security, I mean, those who are sent by the companies. Right. There is a security guard standing outside Yashas. You come at 9, 10, 9:30 night, you come. Till 9 o'clock, you will see people here. After that, who will be here? Classes are over, everyone is home. So, 9:30 you come here, there is this security guard standing. You're like, you, I want to take admission at Yashas. Your office is closed. No problem, no problem. Give me the fees. I will take admission. You give the fees to your security guard. Is it Yash's fault or your fault? Why did you give it to him? Why did you give it to him? Right? अरे भाई ऑफिस का भी स्टाफ होता we would have understood. Security guard वो भी किसी कंपनी का. Why did you give him the fees? Can you claim any relief from Yashas? No. You are negligent here. Ayyo, I don't know the MOA. Leave me this time. Next time, pakka I will read and come. Get lost. Read and come. And forgery. Forgery, let's say some officer of the company gives a forged signature. All my students remember Hasina Bano. Yes, my name is Hasina Banu. Remember or not? Huh? Nahi yaad hai? Come on. Yes, remember. So now let's say the officer of the company forged the signature. The officers of the company forged the signature. Now the third party cannot claim any relief. But ma'am, his fault was not there. No, this is forgery. I totally agree with you. But in law, forgery is a nullity. And however innocent you may be, you cannot claim any relief for forgery. You cannot say indoor management, how I would know the signature, nothing. So this is a little wrong to the outsider, but still, forgery is a nullity and you have no remedies at all. Is it clear? But can you, under civil laws or under tort, file a case against the person who has done the forgery? Yes. But under Companies Act, you don't have any relief. And moving on to, can I move to the next part? Are the doctrines, Hari, are the doctrines clear? Sure. Anyone else? Doctrines are clear, all of you? Very important part when it comes to questions in the exam because every term question आएगा ही आएगा. अब आपके time पे नहीं दे तो different thing. But otherwise every term it will be there. What is share? A share is a share in the share capital of the company and includes stock. ठीक है. I'm not going into the definition. You know, obviously, the meaning of the definition. When we say shares, shares can be divided into two parts, equity and preference. What is equity? What is preference? Equity is which is not preference. What preference which is not equity? Preference actually gets preference. Okay? Preference actually gets preference. That is first in the payment of dividend. So what do I mean by they get preference in the payment of dividend? It means before we pay the equity shareholders, we first pay the preference shareholders. And after we pay the preference, then we pay the equity. So they get preference in the payment of dividend. When the company goes into winding up, we first pay the creditors. After the creditors, we first pay the preference shareholders and then we pay the equity shareholders. So they get preference in the repayment in winding up. What is equity? Which is not preference. Equity shares can be equity shares with voting rights and with differential voting rights. What is basically differential voting rights? Generally, one share is equal to what? One vote. But if one share is equal to 10 votes or 10 shares is equal to one vote, this is what? Differential voting rights, DVRs. Right? If they give you a question on this for holding company, be careful. If they give you 50,000 shares or 10 shares, one vote, you have to not consider 50,000. You will take only what? 5,000. Because it is what? Total voting power. Right? So please be careful when it comes. If there is a question, it's not tricky question, dena to nahi chahiye, but still. The last part of Companies Act, capital, can be nominal, issued, subscribed, called up, paid up. Do you really want me to explain this? No, if you want, I can explain it. Huh? You want? Khatam kar do Companies Act ko. We are done. I'm giving you 2 minutes. If you want me to explain anything all over again, I'll do it first. Oh, you did not take notes for Sale of Goods Act and Partnership? Oh, it's a different window. A separate person comes into existence. There is a contract between the company and the member. Whatever is written in the MOA and AOA, they should follow. And it's a separate legal entity. So even if the shares of a company are held entirely by another company, the company will not use it corporate structure. One share, one vote. That is normal. 10 shares, one vote, DVR. One share, 10 votes, DVR. Example करवाया था class में. 50,000 shares and 1,50,000 shares. एक देखो holding company का definition में एक example दिया था मैंने. नहीं example करवाया था holding company का definition में. अगर आपने लिखा है दिखाओ मुझे मैं बताती हूँ. हाँ तो उसमें आप देखना there is one example है X Limited has 2 lakh shares. जिसमें 1,50,000 shares is 1 share 1 vote, whereas 50,000 shares is 10 shares 1 vote. हाँ 1 share 10 हाँ 10 shares 1 vote. हाँ हम लोगों ने डिस्कस किया है. आप देखना फर्स्ट एग्जांपल इनफैक्ट वही है. चलो कैन आई नो डाउट्स. हाँ everyone is ready with their phones for what? हालत देखो मतलब the only time you are interested. Thank you so much. It's okay. Everyone have their own priorities, no? Let it be his. Where do I get the time? Even yesterday, I was so unwell. I had a class, no light. Everyone join. Okay, okay, okay. And all the chocolates are also kept down to give to all the winners. You are the first one, huh? I told him to get 5 star. He got munch. I was like 5 star लेके आता तो कुछ तो अच्छा होता. Yeah, I like 5 star. Better. No, I don't like. I like Bonville best. But still, huh? Huh? I have good only. Do everyone join? Oh, I'm so sorry. My son messaged me something, so. एक minute. Who are these 33 Mahan Insan? Who are these 33 Mahan Insan? If company gets permission from SEBI, they can issue deposits to the public. I mean, accept deposits from the public. Since when? Prohibited hai, prohibited. Since you solved the quiz, since then. Since then only. Laws have changed, I forgot. Hey, this is wrong. Wait, wait, wait. This question is wrong. Leave this quiz. We will do it again. This question is wrong. No, actually, what happened? No, instead of this is the previous option, question option. Instead of the question being pasted here, the option got pasted here. And I picked the right answer, and now you know the right answer. छोड़ दो ये तो गलत हो गया. We'll do it later. Leave it. This to everyone should do right. I will put a story. Like that. What the hell? What the hell? Who are these 22 people? Who are these 22 people? Arey, once give me a right answer so that I can post it somewhere. Huh? I am sure even if I tell the answer, no one will give the right answer. Still, I mean, some people will still go for the wrong answer. Full faith I have. Please, right answer though. I want to put a story. ये क्या हुआ? These are fake. No. I prepared it here without my laptop. That is why gadbad today. What? What? Option? I mean, which one did you go to? Right one, no? The option 5 and 6 कौन है ये? I want to see those. How many of you gave? Hey, option? Oh no, it was correct only. Ayo. हाँ. No. Oh my God, the answer is wrong. Shit. Arey, leave this quiz. Leave this quiz. The answer I gave is wrong. What is the answer? No. It is B. It is B. It's not coming only. I've done it, not some. Excuse me. Who gave the right answer for this one? No, this is the right answer of it. Not every answer is a wrong answer. Acha, listen. Let's say X limited, Y limited. 100% shares of X, Y limited are held by X limited. First of all, this is known as wholly owned subsidiary. Okay, this is known as what? Wholly owned subsidiary. Tell me, tell me, does Y Limited lose its in corporate structure? No. It is a different, please, company and members are different. It is a different structure. It's a different structure. Even if I hold 100% of your shares, you are not, you are still existing and you are different from me. Now my question is, can Y Limited be OPC? Can we say Y Limited is an OPC? Can we call Y Limited as an OPC? How many of you say yes? All the shares of Y Limited are held by X Limited. Can we call Y Limited as OPC? No. How many of you say no? Raise your hands. Let me see those people. How many of you say yes? It's an OPC. No one. It is not an OPC. Why it is not an OPC? Huh? It can only, matlab, in case of OPC, a company cannot be a member of OPC. So here X Limited holding 100% shares of Y Limited means X Limited is the member. And a company cannot be a member of an OPC, only a natural person can be. So that is why Y Limited is not an OPC. I mean, it's not an OPC, it's just a public company. And also it was written public, limited, sorry. Ayo, again problem. And C was actually the right answer. It got over so soon, but 15 seconds was there. Today the quiz is a locha. Okay, for those who have opted B, yeah. How is the answer? See, please understand, in case of a private company, the number and members, the minimum number of members is what? Minimum is what? 2. Maximum is what? 200. Director minimum is what? 2. Maximum is 15. Can I not have more than 15? I can have more than 15 also, but for that I need a special resolution. For a public company, what is the minimum number of members? 7. What is maximum? Unlimited. What is the minimum number of directors? 3. What is the maximum number of directors? 15. Can I have more than 15? Yes. In case of OPC, what is the minimum number of members? Only one. That was what I wanted to hear. Only one. There is no minimum maximum. What about directors? Maximum? Are you sure? In case of OPC, the number of member is only one, but director is can be more than one also. Got it? So it is. What is the answer? I want you to look at the answers, please. Wait, wait, wait. Done, all of you? Who are these 5 and 26? Registered office clause is not a clause of the memorandum. I want to touch all of your feet once. Just thought. Just thought 10 minutes back. Who is the fake winner? Let's see. Who is this? Who is this, Jaladhan? Who is that? अच्छा, you are. कितना आंसर्स करेक्ट वाला करेक्ट था, कितना रॉन्ग वाला करेक्ट था? हाँ? चलो. Can we move to the next topic? Question. Which chapter? Toga Vinsa. Not partnership. You want to partnership? Huh? It will not be completed today. They are saying soga. Acha, listen. Huh? Acha, listen. First of all, I'll take the class tomorrow also. Tomorrow it will not be this long session. Obviously, it will just be a 3 hour session mostly. Okay. So, uh, but tomorrow, what time should I keep the class? Tell me. Acha, how many? 3 o'clock. Why 3 o'clock? Huh? 7:30 is my class. So morning I have. After 1:30 I'm free. You want to spend me to spend the rest of the day with you all here only. Which chapter should we start now? Tell me. Huh? Yes, it's saying to LL. Sure, LL. You confuse me. Huh? Special resolution. How many of you saying soga? Let's do soga. Huh? You people put me in a dilemma. I told. Acha, listen. Let's do soga. Okay? It is 6:50, no? By 8:30 we'll finish off soga. Huh. Partnership and LLP. Huh? Both we cannot finish, that's for sure. They are like, please do soga now. I also was thinking, but they are like, do soga first. Huh? I know so much is there. Oh my god, you have confused me now. I am so confused. Ek cheese bolo na. Why everyone has. Huh? Acha, listen. What about partnership? Why no? Tell me. I told, but it's not about that. If I start partnership, I'll finish it off today. No problem. Then come prepared again 5 hours of huh? You people are confusing me even more. Chalo, let's do vote. This time again voting. How many of you Soga? Raise your hands. Nandini and Meghna count. Meghna, no? Soga, how many of you for Soga? Raise your hands. Only single hand, no double hand, no cheating. I think Soga wins. Okay, how many of you for partnership? Hey, you cannot vote again and again. Is it some cheating? Some cheating is going on. Who is cheating? How many of you for partnership? Raise your hands, please. Like, people raise your hand for Soga also, no? This partnership. Now, Partnership Act 1932 came into force on first came into force. Phones रख दो अंदर हो गया and take out your books, your notes. Partnership Act is again a very important chapter. Shh, because it is for 16 to 18 marks. Partnership Act 1932 came into force on the 1st of October 1932. So what exactly? So basically the act is about Partnership Act. So obviously the act talks about what? Partnership. What is partnership? It is an agreement between two or more. It's an agreement. So obviously it cannot be an agreement with me. I need minimum two persons for the agreement. So it is an agreement between two or more persons to share the profits of the business carried on by all or any one or more acting for all. So if I look at this definition, I also get essentials of partnership. What are the essentials? First of all, partnership can never arise out of status. There should be an agreement. When I say agreement, agreement can be expressed or it can be implied. And when it is expressed, it can be what? Oral or written. It can be what? Oral or written. Again, when we talk about written, the clause where we mention the deed where we mention all the clauses of partnership is known as what? Partnership deed. Then it is an agreement. So obviously I cannot agree with my own self. I need at least what? Two parties. Right? So it's an agreement between what? Minimum two. Maximum is what? Maximum is not given under the Partnership Act, it's given under the Companies Act. If it is more than 50, it is what? It is an illegal association. Right? What is the agreement about? The agreement is to share profits. Why do we only say share profits? Because I can have partners who do not share losses. And if I say share profits and losses, that means I make it mandatory for every partner to share the loss. But I can have partners who do not share the losses. So it is just profits and not losses. In what ratio do I share the profits? Agreed ratio. And if nothing is agreed, then equally. In what ratio do I share the losses? Agreed ratio. If nothing is agreed, in profit sharing ratio. We don't share it equally, we share it in the profit sharing ratio. Now tell me, where will I get profits from? Where will I get profits from? Profits will be from the what? Business. What do I mean by business? Any trade, profession, or occupation, but it has to be what? Recurring in nature. You know, there have been this. Okay, I want to discuss this one question with you. Just hold on a second, please. Can you see this question, Mr. Ram, Mr. Rahim? Yes. I want you to read and answer this question, please. 50,000. Huh? No. Only 1,500. Because they are not partners. Here, just because they have rented the property does not make them partners. Now, on this renting of property, no, a lot of time there has been questions. And renting of property is not partnership. Do I need to read the question? Everyone understood, no? Now, who will carry on this business? The business shall be carried on by all or anyone or more acting for all. Now, what is this? I want everyone's attention here. Acting for all. Obviously, every partner has a right to carry the business. However, if the agreement states that a particular partner will carry the business on behalf of the others, then that particular partner will carry the business. Now, when he carries the business, he carries it for himself or for the firm? For the firm. So, when he carries the business, he alone is not liable, but the whole firm is liable. Acting for all. And when we say acting for all, this person who carries the business, he acquires, let's say A is carrying on the business. He acquires a twofold character. He is the what? Principal as well as the agent of the other partners. When he contracts with the third party, he is their principal. But when he contracts on behalf of his other partners, he is their agent. Now, when he makes a contract, is it A alone who is liable or the whole firm is liable? Whole firm is liable. In the contract of agency, the agent does the work and the principal is liable. Similarly, here, partner does the work and what? Firm is liable. So, on this grounds, we can say that partnership is an extension of what? Law of agency. Okay? And this is the mutual agency. This is the cardinal principle. What do I mean by cardinal principle? The most important element of partnership. What is cardinal principle? The most important element of partnership. Now, if the agreement is express, I know there is a what? Partner. If the agreement is written, I know there is a partnership. But if the agreement is not written or if the agreement is implied, how will I know whether there is a partnership or not? It will be by the real relation of the partners taking all the relevant facts together. How is it? By the real relation of the partners taking all the relevant facts together. So basically, whether two or more persons are partners or not, I will look at the relationship, whatever surrounding factors I get. I will check if there is an agreement to share profits or not, if there is mutual agency or not, if there is business or not. If two or more people share profits, I can say, okay, they can be partners, but it's not conclusive. If I look at the relation of two or more people and I see they share profits, first look, I can say, okay, they can be partners, but that's it. It's not conclusive. I have to actually look into it deeper. And if when I look into it deeper and I see that yes, mutual agency is also there, then I can conclude that there is partnership. So, sharing of profits is the prima facie evidence of partnership, but the true test is what? Mutual agency. Now, before I go into the types of partners, what are the different types of partnerships that we have? Partnership at will, partnership for a fixed period, partnership for a fixed period, particular partnership, and partnership at will. Hmm. What is partnership for a fixed period? What is partnership for a fixed period? This is formed for a specified period. Who decides the period? Do we decide or the partners decide? Obviously, the partners decide. So when we say partnership for a fixed period, what are we talking about? This partnership is formed for a specified period of time. Tell me what happens once the period is over. What happens once the period is over? The firm is dissolved. What happens once the period is over? The firm is dissolved. But can the partners continue? Are you sure? Can the partners continue? Yes. And if they continue, it becomes a partnership at will. What is particular partnership? It is formed for a specified purpose. It is formed for a specified purpose. Once the purpose is over, what happens? The firm is dissolved. But can the partners continue? Yes. If let's say they find that the business is very lucrative and they should not stop the business, they can continue. And if they continue, it becomes a partnership at will. What is partnership at will? Will, Mary Mercy. We will continue as long as we want. That is, no time has been given to determine this partnership. That means there is no period. We will continue as long as we want. Now, the most unique feature of a partnership at will is that any partner can give a written notice and either retire from the firm or dissolve the firm. Otherwise, can I not retire? I can, but I need the consent of all. But here, even without the consent of the others, I can retire from the firm or I can dissolve the firm. Now, when a partnership for a fixed period or a particular partnership converts into a partnership at will, what will be the rights and liabilities of the partners? What will be the rights and liabilities of the partners? Same, same. But now the rules of partnership at will apply. What are the different types of partners? Active partner, sleeping partner, nominal partner. Who is an active partner? Brings in capital, takes part in the business. But you know what? Whatever is given or not given, he brings capital or not. If he takes part, that's the criteria. He brings in capital, takes part in the business, shares profit and losses, known to the outsiders, liable to the outsiders, has to give a notice. When I say notice, which notice am I talking about? Public notice. Notice to other partners, so every partner has to give. Which notice am I talking about? Public notice. Then, what is sleeping partner? They do not take part in the business. Is he supposed to bring in capital? Does he bring in capital? Yes, he brings capital. Does he take part in the business of the firm? No. Does he share profits and the losses? Yes. Is he known to the outsiders? No. Because he does not take part in the business, he is just not the face of the firm. Is he known to the outsiders? No. Is he liable to the outsiders? Is he liable to the outsiders? Yes. Does he have to give a notice of retirement? Does he have to give a notice of retirement? No, I don't know. How does it make a difference? Who is a nominal partner? Who is a nominal, not namesake, rather, he lends his name to the firm. And why would he lend his name to the firm? Because of the goodwill with the name. Does he bring in capital? अरे no, I got my goodwill. सब कुछ मेरे से ही ले लोगे क्या? हाँ? Does he take part in the business of the firm? Please, I'm too high beyond to do all these things. Does he share profits and losses? He actually gets a fixed royalty generally. I'm not saying he cannot share. If the agreement says he can share, but generally he gets a fixed royalty. Is he known to the outsiders? Is he liable to the outsiders? Does he have to give a notice of retirement? Yes. Who is partners in profits only? They share, name is only telling, they share only the profits, not the losses. But are they liable to the outsiders for the act of the firm? Yes. Just because you don't share the loss does not mean you're not liable. What is a sub partner? When a partner agrees to share a part of his profits with another. Acha, tell me, does this person have any rights over the firm? No. It is only over the partner. Ambassadors and nominal partners, they are companies. Here it is partnership. Company and partnership is different. Partnership, you are taking, now let's say firm is a huge firm. You are taking someone for advertisement. Okay. Because of that person's name, the market value comes down. If because of any person we suffer any loss, we have a right to recover it from that person. We have a right to recover it from that person. Now, what exactly is a sub-partner? Let's say ABC are partners of a firm. A agrees to share 20% of his profits with D, right? Can D go and claim the share from B and C? No. Can B and C claim anything from D? No. Rather, can I say D is not a sub-partner of the firm, rather he is a partner of the partner? Yes or no? Yes. Partners by estoppel or holding out. A partner takes B to some third party and says she is my partner. I'm not a partner. What should I have done? Eh? What? Why? How? But no, what I did? Smile. Do I become a partner of that firm? Yes. Not exactly a partner, but I become a partner by estoppel. Now, if the third party contracts with the firm, will I be liable? Yes. And what will be my liability? Severe. Severe means I'm liable for the whole money alone. Another case, I am an outsider, no way connected to Yashas Academy. I go and tell everyone, I'm a partner of Yashas Academy. Huh? Yeah. Now, if Yashas Academy makes, if any third party makes a contract on the faith of this representation with Yashas Academy, am I liable or not? Yes. And my liability is severe. You have to tell me what's the difference between the two situations. In the first case, the partner is representing a person. Whereas in the second case, the person is representing himself. The last topic, in this unit, minor. Don't be happy. अभी तो 7:15 हुआ है sir. Huh? Now I will, huh? My favorite question of the institute, minor. Every alternate term you will see this question. Ek to this, and one topic is there no reconstitution of the firm, admission, retirement, death, insolvency, expulsion, and transfer of share. One question from that pakka. So, minor. Can a minor be a partner? No. No. He can only be a beneficiary. A minor cannot become a partner of the firm. He can only be admitted to the benefits of the firm. Now, tell me one thing. When a minor becomes a beneficiary, what are the rights of a minor? First, he will get his share of profits. And he's become a beneficiary, obviously. He will get his share of profit. Can he check, inspect, and copy the accounts of the firm? Yes. He can check, inspect, and copy the accounts of the firm. Can he sue his other partners for his share? Yes. Provided he severs all his connections with the firm. He can sue the other partners for his share, but if he wants to sue the other partners, he has to cut off all his connections with the firm. What will be the liability of the minor? Obviously, he cannot be personally liable. The liability is only up to his share in partnership. Now, when he becomes a major, can he continue to be a beneficiary? No. So within 6 months, from the day he attains majority or the day he comes to know he was a beneficiary, whichever is later. Everyone clear, or should I explain with this point one? Sure? Okay. Whichever is later. So later date. From the later date, how many months? 6 months. He has to give a notice of whether he wants to become a partner or not. What happens if he fails to give notice? He will automatically become the partner of the firm. When he becomes a partner of the firm, rights will be the same as it was when he was a beneficiary. When is he liable from? From the day he was admitted to the benefits of the firm. From the day he was admitted to the benefits of the firm. Is it clear? Yes. Can we move to the next unit? Yes. Huh? So rights of a partner. What are the rights of a partner? In fact, on one or two of these rights, there were questions also. Partnership is one topic, literally, they have exhausted it. From every topic, there has been a question. From every topic, और कुछ नहीं, partnership property 2 marks. और कुछ नहीं, notice 2 marks. But every topic they have covered. They have not left even a single topic from Partnership Act. And though Partnership Act वैसे देखने में easy लगता है, sometimes while solving the questions of partnership, it's a little tricky. It's actually and one of the reasons we find it is tricky also because we get it a little easier with this chapter. अरे बचपन से पढ़ा है ये chapter तो आता है ना बचपन के दिन, right? 11, 12, that is bachpan only now. So we have done it so many times, correct or not? So we don't feel like studying this chapter also. So because of that also, we end up actually screwing this chapter. So when we get the question, no, we get a little confused about the answer of this chapter. Anyway, what are the rights of the partner? First, there are actually 14 rights where up to 8 we need to understand. From 9 to 14 it is something which is there in details later on. For example, I don't want a partner to join the firm, I can stop him from joining the firm. I want to retire, I can retire. If they are expelling me and the expulsion is not in good faith, I can stop myself from being expelled. I have a right to subsequent share of profits if they don't settle my accounts. I have a right to carry the same business if there is no agreement to the contrary. I also have a right to dissolve the firm. This you already know in admission, retirement, death, these topics are there in detail. Right? I'm sorry. Expulsion is one favorite institute's topic. If you actually look into the previous year questions, whether RTP or whatever, at least 7, 8 questions you'll find on expulsion. Yes, last term it was direct question. It was direct question. Otherwise, case study. Okay, rights of a partner. The first right of a partner is okay, right to take part in the business, right to be consulted, right to share profits, right to remuneration, right to interest on capital, right to interest on advance, right to check, inspect, and copy the books of accounts, right to be indemnified. These are the 8 rights we are going to discuss. Abhi dhyan se sunna. Do I have a right to take part in the business of the firm? Yes, every partner. अरे नहीं मैम वो तो active partner करता है. अरे भाई unless I tell you you are active, we all are active. Right? We all are active. So right to take part in the business of the firm unless agreement to the contrary. If agreement says, okay, if agreement says that only one of us will carry the business, then it's a different thing. Otherwise, everyone has a right to carry the business or not. Yes. If the agreement says that only one of us will carry, then it's a different thing. Otherwise, everyone has a right to take part in the business of the firm. Right to be consulted. You cannot say, "Arey, tu to sleeping partner hai re, ja so ja." Right? You cannot say that. I have a right to be consulted before any decision is taken. If it is a managerial decision, what is managerial decision? Changing the type of business, taking a new partner, a partner leaving, right? Changing PSR, dissolving the firm, expanding the business. These are all what? Managerial decision. I need the consent of all. Unanimous means what? Consent of all. But if it is a day-to-day matter, I need only the consent of majority. Right? I need only the consent of majority. Now, right to check, inspect, and copy the accounts of the firm, but it should be done bona fide. You are not misusing the information. You are checking it in good way. You're not giving it to others, not using it for your personal purpose. Right to remuneration, is it a right? No, no, no. It is actually not a right because remuneration is not payable. Why? They say you are doing business, it is your business, you are getting profit. For what are you asking for remuneration? Right? Like you see in at your home, when you ask your sister to do something, younger sibling, whatever, sister, brother, first, so they will never do it. Right? Why should I do that? They ask for a glass of water. Did you get that water? No, no, get lost. Now you have to beg them. You have to bribe them. Bring 10 rupees for me, 10 rupees for you. I don't need your 10 rupees. They bring 20 rupees for you, 10 rupees for me. Still no. Then you pay him remuneration or her remuneration to do the work. But today, so he or she is not going only. Very adamant, saying, I have 100 rupees to buy chips. I don't need your 20 rupees. Aaj nahi hoga. So now you are going to go and buy. Will you pay yourself money for buying the chips? No. When others do the work, we pay. When we do our own work, do we pay? No. So how can you ask for remuneration? But you know what? Partnership is very flexible, right? Partnership is super flexible. बोलते हैं act है and over the act agreement है. If something is given in the act, but agreement says something else, that will prevail. It should not be unlawful, bus. So agreement. So it is payable if there is an agreement or if it is the custom of the firm. Custom of the firm means what? Tradition. Custom means what? Tradition. We have always been giving remuneration. Sharing of profits, we've already discussed this. Would you tell me, does every partner have a right to share exclusive profits? Does every partner have a right to share exclusive profits? No. If everyone will share exclusive profits, who will bear the losses then? Exclusive profits means only the profits, not the losses. If everyone will share profits, who will bear the loss then? So, but can we have some partners who will not share the profits? Yes. No, sorry, who will not share the losses? You understood, no? No, what you did not understand, I'll explain again. Tell me. No, no, no. I will explain again. No, no, from there only you can say. It doesn't have to come here. Sure. Pukka, na? I'll freeze it. And you told yes, they heard it no. I also heard it no. Okay. Do I have a right of interest on capital? No. You have invested money in the business. Your profit is your return. How can you ask for interest on capital? But again, over the act, what prevails? So if there is an agreement or if there is a custom or if there is a statutory provision, then interest on capital is what? Paid. Interest on capital is paid only out of profits and up to the day the firm is working. So let's say today the firm is dissolved, but after 2 months, I pay. Do I have to pay interest on capital for this 2 months also? No. No. Interest on what is advance? Something that I bring in over and above my capital. अरे लोन है भाई interest pay करना पड़ेगा. At what rate? Agreed rate. No, not 6%. Agreed rate. And if nothing is agreed, then 6%. Can you say, अरे partner loss है भाई, don't take interest. No, he will say मुझे क्या लेना देना है ना? Right. I will take interest. Interest on loan is payable irrespective of profit or loss. Ajay, tell me. Today the firm is dissolved, but by the time I pay the money, it is like 3 months. Do I have to pay the 3 months interest also? Arey haan, advance hai. You pay interest on a loan till the day you don't repay the loan. Is it clear, all of you? Yes. Then right to be indemnified. Indemnify means to make good. Here it means to pay. The firm had to pay the money. Who had to pay the money? Firm. Partner pays. The firm had to pay the money. Partner pays. Can he recover it back from the firm? Can he recover it back from the firm? Yes. Right to be indemnified. Acha, duties of the partner. What are the duties of the partner? Carry the business to the common advantage. Do not ask for remuneration for doing the work. Be diligent with your business. If you have suffered because of your fraud, if the firm has suffered any loss, compensate that loss to the partners. Do not make secret profits from the firm. And if you make secret profits, give it to the other partners. If due to your fraud the firm suffers any loss, compensate it. Bear equally the losses. Now, equally the losses doesn't mean equal ratio. Equally means just like you take profits, also bear the losses. If the partners or the legal heirs of a deceased partner, they ask for details of accounts, provide them with the details of accounts, right? Did I miss out anything? हमें कौन सा पता है miss out or not? हाँ? Did we cover every point? चलो. Personal profits earned by a partner. Partnership property, please, I'm not teaching this. Personal profits earned by a partner. Actually, tell me one thing. How many of you already started like, or kitni day? Today I'll leave you at 8 o'clock. Today I'll leave you at 8 o'clock. See, I'm so generous. Huh? Like, 8:20, no? Yesterday it was till 8 o'clock. I took the class till 8:30, no? So today I'm leaving you early, no? This way. Asha, tell me, can I earn secret profits from my firm? No. If a partner earns any secret profits from any transaction of the firm, what do I mean by transaction of the firm? He sold something to the firm, right? Or from any name or assets of the firm. He uses the assets personally and earns profit from it, right? Or he is earning profit from a personal business which is competing with the firm. First of all, can you carry a competing business as that of the firm? Why no? Why no? I can. I can. Imagine my partnership firm deals in sugar. This is the shop of partnership. And just down the lane, I have my own shop where I sell sugar. Same business. I can do it. Just so happened today, I am all alone in the partnership shop. Someone comes to buy sugar. Yo, this shop sugar, that shop sugar. Why? Here I have to share. They're only care. Can I do this? What? Can I do this? No. I so cannot carry any business which is competing with that the firm. So if a partner earn any personal profits from any transaction of the firm or using the name or assets of the firm or business which is competing with that of the firm, he must give a share of the profits to the other partner. Is it clear to everyone? Are you sure? Yes? Can the agreement stop a partner from carrying a business, personal business? Yes. Let's say you are active partner, we are paying you remuneration also, right? So, so that's so nice. So please pay attention, all of you. So moving on to the next one. Can the agreement stop a partner from carrying a business, personal business? Yes. You are active partner. I'm giving you remuneration. Now, if you start moonlighting, how will it work? है ना? How will it work? You will pay more attention to your personal business. But human nature, tell them not to do something, they will do that only. है ना? Very interesting to do. If my don't go to that area, I must first go to that area to know why I should not go to that area. Right? But then that is human nature actually. हाँ? हाँ, because they don't tell the reason. I want ऐसे मत करो. अरे तो क्यों नहीं करो? Tell me क्यों मत करो? हाँ, I will do. हाँ, what is the don't ask? You tell me why not? I will not do. हाँ? गलती से भी नहीं होना चाहिए touch. So agreement says that a partner cannot carry any personal business, but a partner carries a personal business which is what? Not competing with the firm. What will I do? I will have to give the damages. Right? I will have to give the damages. Everything relating to implied authority. I won't say it is important or anything like that, because one thing I know for the institute, everything is important. But topics relating to implied authority are a little tricky. So, in fact, in the entire Partnership Act, if I say something, questions and topic relating to implied authority is a little confusing. Can a partner act in the name of the firm? Yes. And when a partner acts in the name of the firm, who is bound? Who is bound? The whole firm is bound. Who is liable? The firm is liable. But the firm is liable only when the act is done in the ordinary course. So when my firm deals in what? When my firm deals in sugar and I place an order of rice, is the firm liable? No. Why? Because it is not done in the usual course. But when my firm deals in sugar and I place an order for sugar, is the firm liable? Yes. So firm is liable only for the acts which are done in the usual course. If the act is not done in the usual course but the other partners ratify it, I place an order for rice. Is the firm liable? No. But what T did was T sent the rice to the firm and let's say B accepted the goods or B signed the receipt. Who will be liable? Firm is liable. Because why? He has accepted, ratified the contract. So implied authority binds the partners only if the act is done in the usual course. If the act is not done in the usual course, the firm is not liable. There are certain acts which a partner does not have the authority to do. And if the partner does it, the firm is not liable. These are the acts which a partner does not, firm can do, partner cannot do. And if a partner does these acts, he cannot bind the firm. He cannot bind the firm. But no. For example, can he buy movable goods? Yes. Can he sell movable goods? Yes. But can he buy or sell immovable property? No. No. But let us say my firm deals in immovable property. Then it becomes my usual course or not? Yes. Then can my partner do it or not? Yes. So we can give the authority to the partner if it is done in the what? Usual course. But otherwise, these acts will never bind the what? Partner. These acts will never bind the partner. What? He cannot transfer, that is purchase or sell immovable property. He was asked to open a bank account. He opened a bank account in his own name on behalf of the firm. Can he do that? Whose account was it? Firm's. Whose name should be there? Firm. Why did you open it in your name? Alright? Can he enter into a partnership on behalf of the firm? Let's say XYZ is one partnership firm, ABC is one partnership firm. ABC wants to make a single partnership with XYZ. A approaches XYZ. Sorry, ABC wanted to form a single partnership with XYZ. ABC approaches X and tells X that we want to form a partnership with your firm. Are you okay? X is done, done, done. Can he do this? Who are you? Done, done, done. Hannah, who are you? This is a decision which can be taken by all the partners. Acha, here, one more thing. How many partners are there? 6, 8. If both of the firms join, XYZ and company, ABC and company, if they join, how many partners are there? 6, 8, or 2? 6, 8, or 2? 6. XYZ and company, ABC and company joined together to form a single partnership. How many partners are there now? 6 or 8 or 2? How many of you say 2? How many of you say 6? How many of you say 8? Okay. First of all, when two partnership firms join, partnership firms don't have separate legal existence. It is not the firms who are joining, but the partners who are joining. So it is 6. Right? Agar company hota, let's say X Limited having 15 members, Y Limited having 14 members, and Z Limited having, let's say, 10 members. They form a single partnership. X, Y, Z and company. How many partners are there? 3. Here it is 3. Because companies are joining. But here it is not the firms which are joining, but the partners. So, cannot enter into a partnership on behalf of the firm. Acha, if there is a dispute in the within the partnership, can I hire a lawyer to settle the dispute? Yes. Can I hire an arbitrator to settle the dispute? No. He cannot hire what is arbitrator? Settlement of disputes outside the court. Right? Case is going on against the firm. Yo, sir, you know my firm is bakwas, I'm telling you, sir. Chumma, we are doing all stupid activities. You please pass order cancelling us. Pakka, my firm is waste. Can you do all these things? It was trust, and now you are saying, Pakka, my firm is waste. How can you do that? We cannot admit any liability against the firm. Acha, what is withdrawing case? Sometimes you have seen, no, before the verdict is given, a case is going on. You go and say, Judge Saab, I take the case back. This is what? Withdrawing your case. A partner cannot withdraw any case. Someone has to pay money to the firm. Oh, you are my brother-in-law. What will you pay? You go enjoy money. I will adjust money. Can you do that? Can you do that? No. Can you give a normal cash or trade discount? Yes. But can you completely give up the debts of the other person? No. So we cannot compromise or relinquish the liability of another. Is it clear to everyone? Any point you want me to explain again? We are done with all the 7 points, 8 points. Done? Can I move to the next topic? मैम अब आप खत्म करो हमें कुछ भी नहीं पूछना है कोई डाउट नहीं है हमको extension or restriction. Can a partner be given a little more or a little less authority? Yes. Can a partner be given a little more or a little less authority? Yes or no? Yes. Can I give a partner a little more or a little less authority? Yes. But can we say giving him a little more or a little less authority is something which is internal to us? Yes. Correct or not? Yes, it is something which is internal to us. How does it affect the third party? If the third party knows about it, then he is bound by it. But if the third party does not know about it, he is not bound by it. Is it clear to everyone? One question I want you to please arrange. Oh shit. Why did I close it? Okay, I want you to give me the answer to this question. The last one, transfer of share. What do we mean by transfer of shares? Can I sell a part or whole of my share? Yes. Can I take a loan against a part or whole of my share as a security? Yes. That is what we mean by what? Transfer of shares. When a partner transfers a part or whole of his share by way of sale, pledge, or mortgage. Right? By way of sale, pledge, or mortgage. The person to whom the shares are transferred is called what? Transferee. Actually, tell me, does the transferee have to be a partner of the firm? No. Can he be an outsider? Yes. Another question Institute has asked so many times, transfer of shares to you. Huh? What will the yeah, that is only what is there actually transferring. What is the rights of the transferee? What is the rights of the transferee? He will get his share of profits. Can he take part? Ironically, we say right, but we don't give him any right. Can he take part in the business of the firm? No. He cannot take part in the business of the firm. Can he check, inspect, and copy the accounts of the firm? No. On dissolution, what will happen? He will get his share of profits. And to determine his share of profits, he will be given a statement of affairs as on that day. Till now, you never allowed me to check the books. How do I know what is my share? So to determine his share, is given a statement of affairs as on that day. What is his liability? He's coming in place of whom? The partner. Whatever was the liability of the partner, if the sale is made, he will have the same liability. Is it clear to everyone? This unit is done. Can I move to the next unit? Huh? 10 minutes में finish हो जाएगा ना? We'll complete no partnership chapter. हाँ, we'll complete and go. ठीक है? As you wish. If you say, ma'am, leave, we'll do it tomorrow, I'll do it tomorrow. No problem. If you say, ma'am, do it now, I'll do it now. Finish it. Finish it. Hardly 10 minutes. It will be. Hard. Okay. Now, partnership. Is it mandatory for the partnership to be registered? No. Partnership may be what? Partnership may be oral also, implied also. So registration of partnership deed is not what? Registration of partnership is optional, not mandatory. These are the contents of the partnership deed, and yes, once they have even asked this question also. I told you, no, Institute has not left any topic. Literally covered every topic. Now, registration of partnership firm is optional but desirable. Why do we say it is desirable? Why do we say it is desirable? An unregistered firm faces certain disabilities. What are the disabilities of an unregistered firm? They cannot sue. Can a third party sue the firm? Yes. But the firm cannot sue the third party. Then it cannot claim a set off. What is set off? When we both are indebted to each other, we set off that lower amount. So the maximum set off that they can ask for is how much? 100 rupees. You know what? If I don't get my right in partnership, the partners cannot even sue each other. If the firm is unregistered, partners cannot even sue each other. But if they want to dissolve the firm, then the partners can sue each other. Okay? If a partnership firm wants to sue a third party, what conditions have to be fulfilled? The firm should be registered. And the partners suing should be named as partners of the firm. What do we mean by this? The registrar has a record, no? Right? In that record of the registrar, the partner's name should be registered as a partner. This is what we mean. Right? So let's say ABC is a partnership firm and they take D as a new partner, but they don't go for fresh registration. Is the suit valid? No. Why? D is not named as a partner. But if A alone files the case, is it valid? No. because A is filing the case on behalf of A, B, C, D. Right? D is dead, and without fresh registration, they file a case against the third party. Is it valid? Yes. Because A, B, C are named as partners of the. Is it clear? For this, no, there was this one question. Abhi, I know if I show you the question, you'll kill me. So I'll not go into that. But that was a very interesting question. One of the previous year question only, I think. Are you sure? I thought you guys will kill me if I try to show it. This was RTP May 22 question paper. Question, sorry. Finished. Done. So tell me, can L, M, N, and company file a case against XYZ? Why no? Because he is filing a case and the firm is unregistered, so how can he file the case? Chalo, next wala. Why no? Because the firm suing should be registered. Third one, are you sure? Yes, third one is yes. Because LMN is filing the case and LMN is registered. If a partnership firm wants to sue a third party, the firm has to be registered. But a third party can sue even an unregistered firm. Now, dissolution means what? The firm comes to an end. Dissolution can take place, when it is a please, when it is a company, no, court will pass an order only then the company is dissolved. Only when the tribunal passes an order, the company is dissolved. But in case of partnership, it is not necessary for the court to pass an order. So even without the order of the court, a partnership firm can be dissolved. How? By agreement, all the partners decide to dissolve the firm. There are 10 partners, all of them agree, let's dissolve the firm. Or happening of certain contingencies. Firm is formed for a period of time, the period is over. Firm is formed for a purpose, the purpose is over. A partner is dead, a partner is insolvent. Except one, all are dead, except one, all are insolvent. Out of these six cases, which is compulsory? Out of these six cases, which is compulsory? Huh? Death and insolvency are four cases I gave. Which one? Except one, all are dead, except one, all are insolvent. This is compulsory. In rest, I can still continue, but here I have to dissolve the firm. Then, by notice. In case of partnership at will, any partner can give a written notice and dissolve the firm. Now let's see, when does the court order for the dissolution? First of all, when will the court order for the dissolution? When someone applies to the court. Who can apply to the court? Who can apply to the court? Any partner or even a third party. Anyone can apply to the court. What are the cases? Permanent incapacity of an active partner. If an application is made that a active partner is permanently incapacitated. Sleeping partner, not necessary. Active partner, yes. But ma'am, I have 5 active partners. One is incapacitated. Why should I dissolve the firm? Arey bhai, I am not saying you have to dissolve. But if someone applies to the court, then the court will dissolve the firm. Perpetual losses. Firm is undergoing losses. No way of turning it into profit. Consistent breach of contract by the partner. Partnership becoming illegal association. What is that? More than 50. Misconduct of a partner. Business becoming illegal. Once there was a question. A partnership has two business. One of this becomes illegal. Should it close down the firm? No. You close down this business and continue with the other. One business and that is illegal. Should I close down the firm? Yes. Yes. Except one, all are dead or all are insolvent. In all of these cases, the court may order for the dissolution of the firm. Is it clear to everyone? Yes. Now, once the firm is dissolved, we will now what? First of all, till when are the partners liable? Partners remain liable. Till when? Till public notice is not given. Till public notice is not given. So the partners remain liable till when? Till public notice is not given. So let us say we decided on the first to dissolve, but we gave the notice on 10th. Firm is dissolved when? 10th. If on the 8th the partner contracts in the name of the firm, who is liable? Firm is liable. Now, once we have closed down, we will pay. We will first pay outside liability. Then we will pay partners loan. Then partners capital. And if there is any surplus, it is distributed amongst the partners. Unlimited liability in case of deficit. What is deficit? When my liabilities are more than my assets. Liability means what? See, now listen something. The concept of partnership is I should take back whatever I gave. So if my asset is not sufficient to pay up to the capital, it is a deficit. And in case of deficit, who will contribute to this deficit? Partners. In what ratio? PSR. Right? We will contribute in our. The concept is in partnership, when the firm is dissolved, whatever I bought in, I should take back. And if the firm's asset is not sufficient to pay my capital, then in that case, what will happen? The partners will contribute. In what ratio? Profit sharing ratio. If a partner has both partnership debts and personal debts, and his personal property is used, we first use the property for which debt? Personal debts, and then his partnership debts. When this partnership act is done, and Acha, now tell me, when I ask how many of you have written, no one raised their hands other than 6, 7. When I ask how many of you have not even attempted, no one is raising. So which one should I consider? And what is that? Acha, I tried. No. Ma'am, I opened the book. I saw the question. I was thinking, should I write? Then I started writing as per the provisions or to that I couldn't understand anything. I closed the book and clicked off. How many of you? How many of you? Very good. Huh? Some question. How many I gave, by the way? 5, 6. How many of you attempted at least 2 to 3 questions? How many attempted all the questions? All? That's good. I have a doubt. You. What's your name? Huh? Kushal. Kushal, you never raise hand for anything. Like, I have never seen your hand going up, like for anything ever. So, like, really, I have a doubt. Matlab, did you write the answer? You tried. How many? You wrote 2, 3. You just tried. You watched the question. How do you watch the question? I mean, you read the question and then you slept. On a very serious note, we just have another a month to go before the exam, and we already decided and accepted and established the facts why we need to what? Why we need to? Yes, we already understood and accepted and established this fact. So, if you don't do it, how will you manage? How will you manage that? Can you just close the windows for just 10 minutes? Maybe the room will get a little cooler then. If there was a power cut because of that, Acha, tell me, which one should I start first? Ek bola, please don't start with two. Soga or LLP? Huh? I'm thinking LLP is chotu sa chiller sa. We'll keep it to the end. Let's start with Soga. Okay? So we'll have more energy in the beginning. After 2 hours, so you will literally want to kill me. We'll start. So before I start with the chapter, we all know this chapter is a how many marks chapter? 16 marks chapter. Oops. It is a, you know what? This chapter is not tough, but it's tricky. More of application of brain. And that is why many students actually find this chapter the most toughest. How many of you actually find this chapter very tough? You find it very tough. Very tough. But still, the questions are a difficult part for this thing. How many of you are super chilled with this chapter? Super easy तो कुछ भी नहीं होता है ना. You are super chilled with this chapter. Huh? Manageable. मतलब it's better than the others or worse than the others? Better than? हाँ. Indian Contract Act से भी. हाँ. मैम ऐसे थोड़ी ना. I cannot weigh it out, right? हाँ. चलो anyway. So I repeat again. As you know, I am going to go at a particular speed. However, I've already told you that if you have any doubts in any of the topics you ask me, I will explain it in details. Okay? So, Sale of Goods Act 1930 came into force on the 1st of July 1930. It's a contract of sale. When we talk about a contract of sale, it is obviously a what? Contract. A contract of sale is obviously what? It is a contract. It is a contract for what? Obviously for selling of goods. Right? It is obviously a contract of sale. So it's contract for selling of goods. Now tell me, the selling of goods can happen immediately or it can happen on a future date? It can happen immediately or on a future date. It can be both. So when we talk about contract of sale, immediate transfer of ownership is sale, future transfer of ownership is agreement to sell. So it can be any one of them. So it can be contract of sale can either be immediate transfer of ownership or future transfer of ownership. Now, so basically the seller transfers. When I say transfers, ownership is transferred what? Immediately. It's a sale. When we say agrees to transfer, ownership is transferred on a why future date? After the after because there are certain most of the times there are certain conditions which needs to be fulfilled. And only when these conditions are fulfilled, the ownership will be transferred. So that's the reason it is transferred on a what? Future date. After the fulfillment of certain conditions. And this is known as what? Agreement to sell. So if I say sale, if I only say sale, it is transfer of ownership immediately. If I say agreement to sell, it is a transfer of future ownership on a future date. But if I say contract of sale, if I say contract of sale, it is ownership is transferred what? Immediately or on a future date. Right? Now, What is transferred immediately or on a future date? Property in the goods. The phrase property in the goods means what? Ownership. The phrase property in the goods means what? Ownership. To whom is the transfer taking place? Buyer. And what does the transfer take place? The transfer takes place for a price. So if I look at this, do I also get the essentials of a valid contract of sale? Yes. So what are the essentials of a valid contract of sale? Transportation for a price. Now, if I look at this definition, do I also get the essentials of a valid contract of sale? Yes. What are the essentials? First of all, there has to be two parties. Who are the two parties? Buyer and seller. Who is the buyer? Who buys or please understand, it is sells or agrees to sell. So buyer is a person who buys or agrees to buy. Who is a seller? Who sells or agrees to sell. What will the buyer buy or seller will sell? Goods. So the subject matter must always be what? Goods. When we say goods, goods means any movable goods, and it does not include services, right? It does not include what? Services. Then transfer must take place for what? Price. Acha, tell me, can the transfer take place for money's worth? Can it take place for money's worth? It's not even working. Can it take place for money's worth? No, money's worth. I just said money's worth. No. Money's worth means anything which can't be converted into terms of money. That could be in kind also. But in contract of sale, it cannot be kind. If it is kind, it is what? Barter. Right? So there has to be a transfer for a price. It can be partly in cash and partly in goods. Abhi, please understand, partly ka matlab there is a certain percentage. 1 lakh ka value, 1 rupee I give you cash and 99,999 ka value goods. Please don't ask me all those things, right? Partly means what? Obviously a specific, there is no specific percentage given, but a certain percentage, obviously, which makes it partly. Then, since it's a contract, the Indian Contract Act, all the essentials of a valid contract must be present. Then what is, so let's talk about these essentials in details. What do I mean by goods? Goods means any movable goods, but it does not include money and actionable claims. So money is not goods. What is actionable claims? Any unsecured debts which can be enforced in the court of law, like unsecured debentures. Though under the Companies Act, shares and debentures are goods. But if we talk about actionable claim, unsecured debentures are actionable claims. Then anything which is a part of land, is it goods? That is anything which is attached to the land. Well, if it is severable, like I say building, it is attached to land, it cannot be goods because I cannot sever the building. But if anything is attached to the land, if it is severed, yes, it is good provided we sever them from the land. That is, we detach them from the land. Goodwill, patent, trademark, water, electricity, gas, old rare coin, shares and stocks, everything is considered as goods. But ship is not goods. Okay? When we talk about goods, goods can be classified under three heads: existing, future, and contingent. Name is only telling me existing, I have the goods. when I contract to sell them. Future, I don't have the goods. But after the contract is made, if I am a producer, I'll produce them. If I'm a manufacturer, I'll manufacture them. Or if I have to get it from someone, I'll procure them and sell them. Contingent, I don't have the goods. I don't even know I'll get the goods or not. If I get the goods, I'll sell. If I don't get the goods, I will not sell. Right? Do you want examples for any topic? You tell me. Okay? Otherwise, I'll just move on. If you want examples for anything, just let me know. Goods which are in the possession of the seller at the time of contract. What is future goods? Goods which are not in the possession of the seller but will be produced or procured or manufactured by him. What is contingent? Acquisition of which by the seller depends upon an event which may or may not happen. Ajay, tell me, in future goods, if I don't sell the goods, can I claim the damages? Hmm? In future goods, if I don't sell the goods, can I claim the damages? How many of you say yes? How many of you say no? No. In contingent goods, can I claim the damages? How many of you say yes? How many of you say no? In contingent goods, I've already provided a condition. If I get only then I will sell. So if I don't get, I'm not liable to sell. So I cannot claim any damages. But when I say I will sell you the goods which I get from C, which type of goods are these? I will sell you the goods which I get from C. Which type of goods are these? Future goods? No, no, it's not contingent. I said A says to B, I will sell you the goods which I get from C. This is not contingent. Which I get from C, I'm just describing the goods I will sell you. If I say, if I'm able to get it from C, provided I get it from C, then it is contingent. Here, I've just described the goods that I'll sell you. If I don't get the goods from C, am I liable to give damages to B? Yes. So, in future goods, I can claim the damages, right? Now, existing goods can further be classified into specific, ascertained, and unascertained. The basic difference between specific and unascertained goods is specific goods are those goods which are identified. When I say identify means point out. This is what I want. This is what I want. When I go to the shop and I say I want this pen. When I go to the shop and I say I want this pen, what type of goods are these? Specific goods. What is unascertained goods? They are not identified, but they are what? Described. I go to the shop and I say, I want a red color metal body surface pen. I want a red color metal body surface pen. What type of goods are these? Ascertained or unascertained? It is unascertained. When as per my description, the shopkeeper brings out the goods that I've asked for. What has he done? He has ascertained the goods, right? Can we move to the next one? Yes. Now, price. What is price? We have already discussed the monetary consideration. If I give you the old, before monetization, before 2017 monetization happened, right? We had this different, what you say, 500 rupees note. Can I give you that as consideration? No. When we say consideration money, it means the money that is then used in the country. Right? It is the legal tender of the country, the money which is then used in the country. So, if I give you the old note, that is not considered as money. Monetary consideration, that is the legal tender of the country. इसके ज़्यादा explanation, you have it in your wallet, all the different denominations. You don't need to know. But what we need to know here is fixing of price. How do we fix the price in a contract of sale? I am the seller, you are the buyer. I make an offer to you that I want to sell you my goods at this price if you are willing to purchase. Can we say we have, and you agree, can we say we have fixed the price? And how have we fixed the price? AC is not working and it's literally, there is something wrong with this. Just give me a minute, please. Huh? कुछ आ ही नहीं रहा है इसमें से. Okay, so tell me, I am the seller. I tell you, I want to sell my goods to you at this price if you are willing to purchase. So tell me, in this case, how is the price fixed? Price is fixed by agreement. You are the buyer, you offer me that I am willing to purchase your goods at this price. I agree to sell at that price. How is the contract? How is the price fixed in the contract? How is the price fixed? By agreement. So what is by agreement? The parties mutually fix the price of the goods. It may so happen that we do not fix the price of the goods, but we deal with each other on a regular basis. And because we deal with each other on a regular basis, we have terms using which you can fix the price of the goods. Like, I always sell the goods to you at 10% below market price. Now, if the price is not fixed, at what price will I sell the goods to you? 10% below the market price. So, this is what mutual dealings. That is, we have not fixed the price in the contract. But in the contract, we have certain terms using which we can fix the price of the goods. Can a third party be appointed to fix a price? Yes, you would be thinking, ये ऐसा कौन सा 30 मार खा है? Generally, a third party is what? A valuer. A third party is what? A valuer. You will, in Companies Act, when you will do no next level, you will come across registered valuer a lot of time. So price is fixed by a third party. A will sell goods to B, price to be fixed by C. Ajay, tell me, can we say this is a contingent contract? Yes or no? Dependent on a third party? Yes or no? Yes, this is a contingent contract. Let's say C refuses to fix the price of the goods. What happens now? Huh? Contingent contract. Third party does not behave accordingly. What happens? It is void. If the third party, if C refuses, it's a contingent contract. If C refuses to fix the price of the goods, what will happen? It becomes void. But ma'am, I want to sell, he wants to buy. No problem. We are not stopping you. But this contract is void. Right? Let's say A delivered the goods to B and C refuses to fix the price. What now? Huh? Now it will be, if the goods have been delivered and the third party refuses, the goods have already been delivered. Now it will be what? Reasonable. Let's say part of the goods have been delivered. Now what? For the part which has been delivered, it is valid and we have to pay a reasonable price. For the rest of the part, it is what? Is it clear to everyone? Anything I should repeat again in goods or price? Are you sure? Yes. Delivery. Delivery generally means what? Transfer of possession of the goods. What is the difference between ownership and possession? What is this? Here we were talking about ownership. Property in the goods means what? Ownership. Delivery means what? Possession. Yes, possession means the physical goods. Something relating to the physical goods. Right? What is possession? Physical goods. See, I don't use Yash's pen. I carry my own pen for the laptop. Okay? Who has the ownership? I. It's not Yash's ownership. Let's say I give this pen to Madhu Bhaiya that please Madhu Bhaiya go and keep it in the office. Who has the possession of the pen? So what is the difference? Ownership means who has the ownership over the goods, whereas possession means who has the physical goods. Right? Who has the physical goods. I always thought that if I talk about delivery, delivery is only one. I give you the goods, that's delivery. But actually, there are three types of delivery. The first one being actual, which obviously means I give the goods to you and that's it. Right? What is actual physical possession of the goods are transferred, right? What is actual delivery? Physical possession of the goods are transferred. I give the goods to you, right? I hand over the goods to you. This is what? Actual delivery. So I sold this pen to you. Okay? I sold this pen to you. I come and hand over this pen to you. What type of delivery is it? Actual. This pen is kept in the cupboard in the office. Okay? The office has a cupboard and it is kept in that cupboard. I give you the keys of the cupboard and I tell you whenever you go down, please take the pen from that cupboard. What type of delivery is it? Are you sure? Are you sure that this is what? Symbol. What is symbolic? I don't give you the goods, but I give you certain what? Symbols. I give you what? I give you certain symbols. What could be these symbols, keys, or document of title? I give you these symbols using which you can take the delivery of the goods. Is it clear? Pen is with Madhu Bhaiya. You know Madhu Bhaiya? He just came. Yes, you all know Madhu Bhaiya, right? The person who was like, I was telling him for the water. That is Madhu Bhaiya. Okay. My pen is kept with him. Okay. My pen is kept with him. I sell off this pen to you. I tell you, please take the delivery from Madhu Bhaiya. You are like, no, ma'am, please let it be with him only. For the next 5, 6 days, I'm very busy. I don't want to take the pen. So what I do is I go to Madhu Bhaiya and I tell him, Madhu Bhaiya, I have sold this pen to my student. Now you are holding the pen not for me but for that student. What type of delivery is it? Constructor. Did I physically deliver you the goods? No. Did I give you symbols from which you can take the goods? No. I just spoke, acknowledged. And just by this acknowledgement, the delivery was what? Over. Right? Just by this acknowledgement, the delivery was what? The delivery was over. So this is delivery without any physical delivery. Right? This is what? This is delivery without any physical delivery. Is it clear to everyone? Yes. This is what? Delivery without any physical delivery. समझ में आया? Did you understand the tree? Any doubt? Receipt is a symbolic delivery. No. Receipt is no. So that is just an acknowledgement of payment, not acknowledgement of goods. No, but if let's say you will show that receipt, then you will get the goods, then it becomes symbolic. Right? If you will show that receipt, you will get the goods, then it becomes symbolic. So if that is the condition with the receipt, then it becomes symbolic. Okay? But otherwise, receipt of goods and acknowledgement of receiving of goods is not considered as a document of title. Okay? Some examples of document of title: bill of lading, wharfinger certificate, warehouse keeper certificate, multimodal transport certificate, railway receipt. Everything is a document of title. But remember, mate's receipt is not a document of title. Actually, what happens though? When you give the goods to the ship, so the master of the ship, he will give you an acknowledgement that he has received the goods. So this acknowledgement is known as what? Mate's receipt. It just shows that the goods have been received by the ship, but you cannot show this document to get the goods. So that is not considered as a document of title. Is it clear to everyone? Yes. Any other doubt you have in this? No? How Okay, I'll do one thing. I will, when I come to this, right, I will talk about implied warranty. Anything else, Nate? Ajay, there is one topic which is not here, but I want to discuss that. Destruction of subject matter. What is destruction of subject matter? First of all, subject matter means the goods which are being sold. Right? Subject matter means what? The goods which are being sold. Now, Let's say I already sold my phone to you. Okay? I already sold my phone to you. You were walking down the stairs, you slipped. You slipped so badly that phone some 20 twists and turns lands up on the middle of the road, some 20 pieces. I have a record. Oh, I cannot say it on. Shouldn't say it. So, uh, huh? So, you pick up all those 20 pieces. Literally, you pick up all those 20 pieces. Come to me, ma'am, your phone. My phone or your phone? Your phone. You only keep it. Once the sale is made, anything happens to the goods, you cannot claim anything from the seller. The sale is already done. You are the owner of the goods. But the question is, what happens if to the contract, if the goods are destroyed before agreement or after agreement before sale? Right? Here we have a little bit of supervening impossibility and impossibility existing at the time of contract. Okay? Try to connect those here. Okay? Um, I wanted to sell you my pen. You agreed to purchase. We both did not know that this pen was already stolen from me. Okay? I had kept it in the office downstairs, my pen. I was happy. I will sell my pen because I have some 4 or 5 of these pens. I was like, why to keep it? I will sell it off. So I come and tell you, I want to sell you my phone. You agree to purchase. We both don't know that already someone has flicked off that pen from my bag downstairs. What is this? Can we say the goods were destroyed? Destroyed doesn't have to be destroyed in the literal sense destroyed. Even if it is stolen, it is not there. Can we say this is the goods are gone even before the agreement? Yes or no? What is this? Are you sure? Fakka. A wants to sell his horse to B. B agrees to purchase. Both A and B do not know that the horse is already dead. Void ab initio. बताओ कहाँ पे पढ़ा था? Bilateral mistake. One more place where we did it. One more place I taught you in contract act. No. Impossibility existing at the time of contract, unknown to both the parties. Remember, huh? Unknown, known to both. Girlfriend, divorce, shadi ke pehle, if you don't get me a start from the sky. Unknown to both, it was what? Both of us do not know that the contract is impossible to perform. After agreement before sale. Now listen carefully. I tell you, I will sell this pen to you. You agreed to purchase. But our contract says the ownership of this pen will transfer to you after 10 days. Is it a valid contract? Please think and tell me, is it a valid contract? Everyone, please, ye मान के चलो, today this marathon is over. अच्छा, next, when do you have next marathon? Economics? You don't have marathon for economics? By this, आज कौन सा day है? वो आज Friday. Weekend कैसे बोल सकती हूँ? By the middle of the next week, Wednesday, everyone should be done with the entire syllabus of law once. I should get message from everyone that I'm done. ठीक है? By Wednesday or max Thursday ले लो. ठीक है? By Thursday, everyone should be done. तो अभी से start कर देते हैं ना आंसर जल्दी से. ठीक है? Tell me, is it a valid contract? When I have the goods today, but I agree to sell it to you on a future date, is this a valid contract? Yes. Meri marzi. I sell it now or on a future date. Is it a valid contract? Yes. Is the contract valid? Yes. 4 days after the contract was made, I had got the pen to the office. Someone flipped off the pen. What happens? Void ab initio. This is what? Void. Achha, by the way, I tell you I want to sell this pen to you. What type of goods are these? Sure. Specific goods. The contract was made, but before the contract could be performed, the pen is what? Stolen. How does this pen stolen and the previous pen stolen differ? In the previous case, it was before the agreement was made. Here it was after the agreement is made. It is what? Void ab initio? Void contract. Is it clear to everyone? Are you sure, Pakka? On the other hand, I tell you, I have, let's say you go to the shop and you tell the shopkeeper, I want to purchase a red color metal body surface pro pen. What type of goods are these? Are you sure? Uncertain? He tells to you, no problem, sir. I will sell the pen to you. But please, sir, the ownership will only transfer to you after 10 days. Is it a valid contract? Yes. If I have the goods and I agree to sell them on a future date, it's absolutely valid. Goods are what? Uncertain. Sale will take place on a future date. However, before he could sell on the fifth day, there was a robbery in his shop and his entire pen was stolen. All of his pens were stolen. Tell me what will happen. Huh? It's still valid? Why is it still valid? Sorry? When I say this pen, when I say I want this pen, can any other pen be this pen? No. I repeat again, when I say this pen, can any other pen be this pen? No. And if this pen is stolen, the contract is what? Void. But when I say a Surface Pro pen, have I identified the goods? Have I identified the goods? No. I have just described the goods. And for me, every Surface pen is the same. If this is stolen, If this is stolen, can you buy another Surface pen and give it to me? Yes. So the contract is what? Did you understand it? Yes, Pakka. With this, we are done with Unit 1. Before I go to Unit 2, I'm giving you 2 minutes. If you have any doubt in any topic, you ask me. Huh? I'm sorry? अरे नहीं वो unit I actually did not have so much of time, so I did not make it for both the units, Unit 1, Unit 2 together. ये नहीं बोला डिस्कस कर लो आगे क्या करना है, ये बोला any doubt you ask me. Oh, are you discussing your doubts only? अच्छा चलो, she had asked me this doubt. So A had a piano which he pledged to B. What does this mean? A had a piano which he pledged to B. What does this mean? What does this mean? It means A got a loan from B against the security of the piano. See, when I give a human as a security for a loan, no, it's guarantee. When I give some things as a security for a loan, no, it's either mortgage or pledge. If it is immovable property, it is what? Mortgage. And if it is movable property, it is what? Pledge. A gave his piano as a security for a loan. This is what? Pledge. Right? When A gave the piano, who is the owner of the piano, by the way? It is still A only. So A has what? General rights. But when he pledged the piano to B, B acquires what? Special rights. B acquires what? Special rights. Okay? Now what happens is, now A goes and sells off the piano to C. Acha, when he sells the piano to C, can we say he should have paid off B? But he did not pay B. Right? He did not pay B. So now who is the owner of the piano? C. But who still has the special rights? B. Because of the special rights, can B come and claim the goods back from C? Yes. That means what? When the seller transfers the ownership of the goods, he can only transfer the general rights. He cannot transfer the special rights. And if he wants to completely transfer the ownership of the goods to the buyer, he must remove the special rights. How can he remove the special rights? By paying off government, right? I hope it's clear to all of you. Yes? Any other doubt you have? Vaishnavi, any topic, any doubts? Sure. Chalo, moving on to the next unit. The next unit is all about conditions and warranties. The next unit is all about conditions and warranties. What do we mean by conditions? Conditions are terms in the contract which are essential for the main purpose of the contract. They are the very foundation of the contract, the basis on which the contract is made. And in fact, if there is a breach of condition, you can what? Cancel the contract, right? Let's say you go to the seller and you tell him, I want a car which is suitable for traveling for long hours in hilly areas. Can we say this is a condition? Yes or no? This is what? Condition. Because it is the basis on which the contract is made. But let's say you go to a car dealer to buy a car. You tell him, look, I've become a CA. So according to my standard, please give me a car. Right? It should suit my status, I'm a CA after all. He says, sir, best thing is you take this car. The best thing about this car is the company is giving you a 1 year warranty. If any part is damaged, we'll either repair that part or replace the part. 6 months using the car, the horn is in your hands. Don't know why, what you did, how much you honked that horn, but in 6 months it's in your hand. You go to the car dealer and you tell him, keep your damn car with you. The horn is not even working. Can you, can you return the car back? No. Can you ask him to repair? Yes. This is what? Warranty. Now, warranties are subordinate terms in the contract. Conditions are the basis of the contract. Warranties are not the basis of the contract, they are subordinate. And if there is a breach of warranty, you can claim the damages. You cannot cancel the contract. Acha, tell me, in this car one, the car was not at all suitable to you. It was the worst car that you have ever, driven. Can you return the car back? Yes. But you are like, this car was not a good car for you, but the car is an amazing car. You want to keep it for your mom because 6 days in a week she goes out shopping and you are tired of paying the Uber bills, right? So you decided to keep this car for your mom. So instead of returning the car, you just go to the car dealer and you tell him that this car did not suit my purpose at all. So I'm going to claim damages from you. Can you do that? So you have treated a breach of condition as a, but can you ever treat a breach of warranty as a breach of condition? No. Is it clear to everyone? Yes. Now, when we talk about conditions and warranties, no, conditions and warranties can either be what? Express or in. What is express conditions and warranties? Huh? Which is agreed between the parties. Now, what the buyer and seller will agree, can I ever tell you that? No. Because what they would agree could be anything under the sun and the moon. How would I know what they are going to do? So I can never tell you that this is implied condition, sorry, this is express condition or express warranty. So we can never pinpoint that this is express condition because it could be anything. But when we say implied warranties or implied conditions, it is what? By law. Law says that when the seller sells the goods to the buyer, he must fulfill these conditions. And if these conditions are not fulfilled, the buyer can cancel the contract or claim the damages as the case may. There are 8 conditions, 4 warranties. Very easy. The problem only comes when I have to solve the questions because I get so confused. What is the provision for that answer? That is the only place where it is too much of confusion. I don't know what is the provision for that case. Because लगता है description भी हो सकता है, specific purpose भी हो सकता है. So make sure you do a lot of questions of this, topic. Okay? Anyway, so moving on to the implied conditions. The first one, what do I mean by title? Ownership. Acha, tell me, when you go to buy the goods, do you ask, "Arey, oh seller bhaiya, your goods or chori ka goods?" Do you ask? Do you ask? Arey, I'm seriously asking you, do you ask? Why you don't ask? Because you assume that he is selling, that means he has the right to sell, right? When the seller agrees to sell the goods, it is implied that he has the right to sell. And if he agrees to sell the goods on a future date, then it is implied that on that future date, he will have the rights to sell. If the seller does not have the rights to sell and the buyer is deprived of the goods by the true owner, what will the buyer claim from the seller? He will claim the price of the goods. He will claim what? The price of the goods. A sold stolen goods to B. C, the real owner, claims the goods. Can he claim the goods? What will B do? B has to return the goods or not? Yes. What will B claim from A? Price. ये अलग बात है कि after selling stolen goods, I am not going to be there available. आजा, come claim price, obviously. So that's a different scenario. ठीक है? Is it clear to everyone? हाँ, बोलिए. Market price कहाँ से आया, मैडम? अयो, this is tight. It's right. Shit. हाँ, हाँ, sorry. When we asking for the price that he paid. The price that he paid, he correct. हाँ, that only. It's something like doesn't make a difference. The price you paid. Though you can claim the damages also. Chalo, can I go to the next one? What is sale by sample? What is sale by sample? हाँ. अरे बोलो, it's okay, हाँ. I show you the sample. If you like the goods, you can purchase the goods, right? I will show you the sample of the goods. If you like the goods, you can purchase the goods. Tell me, what is the condition for sale by sample? Teen condition. You know what? This topic, if you remember this page, there is nothing extra to learn in this. So, itna points yaad rakh lena, you have covered this whole topic. Right? So, what is sale by sample? The bulk of the goods must correspond to the sample. That is, the bulk and the sample must be same, not similar. Same. The buyer must be given an opportunity to examine the goods. See, I am not going to trust you. Before I accept the goods, I must be given a chance to examine, sorry. If I am not given the chance to examine, can I refuse? I told the seller, give me 150 kgs of rice. I saw the sample and I told him I want 150 kgs packed in 2 sacks. 170, 180. When the goods reach, I open the sack. He says, ma'am, 70 kgs you can open, 80 kgs I will not let you open. I'm like, I will not buy, I will check. He says, no, ma'am, whatever. I say, okay, fine, take your goods. I don't want. Can I do that? Yes. I say, okay, you will let me check 70, no? Keep the 70, take the 80. Can I do that? Yes. I'm like, अरे भाई कोई बात नहीं है. I always buy from you only. It's okay. I know you will be okay. Give me whole. Can I do that also? Can I say, in case of implied condition, basically the contract is what? Void. Right? Contract is what? Void. Now, the buyer must be given. Acha, tell me. The seller showed this sample of pen to me. I told him send the pen to my house. He sent the pen to my house. He sent the pen parcel packed. I was like, अरे उधर से आयो, ठीक है दे दो. I keep it. After 5 days, I'm coming to Bangalore. I open the pen. The pen was something else only. Can I return the pen now? Can I return the pen now? Tell me. And we can return the pen, but if there is any commenting statement regarding the date of the should I repeat the case again? Sure. I went to the shopkeeper. I saw this pen sample he showed me. I say, yes, I like this pen. It's very smooth. You send this pen to me. He says, I will send it to you, ma'am, by tomorrow. I say, no problem. Please send it to me. Okay. Next day, he sends me that pen ka parcel. His staff comes. I'm like, okay, okay. Thank you so much. I keep it. I forget. I have a problem of forgetting. Gajani ki mummy hu main ekdam. So I forget. Now today, I'm going to travel to Bangalore. I'm checking. Are mera pen. Pen open kiya. The pen is something different. This was an expensive pen. It was one of the most cheapest quality pen. Can I return it back? How many of you say yes, I can return it back? How many of you say no? Why no? Huh? He should have checked this. He checked without checking, he kept the goods. Silence is not fraud. No? I mean, sorry, it is your negligence. I'm so sorry. It is your negligence. This is you cannot, you don't have any remedies. You are bound to keep the pen. So when the goods reach you, you have a right to examine. If you examine and then you reject, fine. If you don't examine, you keep it. Later you cannot reject it. Is it clear to everyone? And the goods must not have any hidden defects. See, there are some defects which are visible to the eye. Okay? Abhi, the tip of the pen is broken. It is something which is visible to the eye. I know it is broken, right? I know it is broken. So this is something which is visible to the eye. But is the idhar mein, andar mein, something is wrong. Is it visible to the eye? No. So the goods must not have any hidden defect which makes the goods what? Unmerchantable. Unmerchantable means what? Not saleable or usable. Okay? What is sale by description? The goods are described to you. If you like, you can purchase. If you don't like, don't purchase. All sweets sold in my shop are fresh, absolutely. Can we say this is description of the goods? Yes or no? If the goods do not suit the if the goods are not as per the description, can the buyer return the goods back? Yes. So what is the condition? The bulk must correspond to the description. And then can the seller give you a description of the packing? Like I will sell you 10 cartons of juices, each containing 12 tins. Yes. But when the goods are given, it is 12 cartons, 10 tins. Am I bound to accept that? But it's the same quantity. I description was 10 cartons, 12 tins. Received was 12 cartons, 10 tins. Can I reject the goods? Are you sure? Yes, because it's not as per the description. So description of packing also forms a part of description. Sale by sample and description. ये sample होगा. Sale by sample and description. I also show you the sample, also describe the goods. Two conditions. So when I'm showing you the sample and when I'm describing the goods, they should match. I should not give a different description to the sample. So the sample must be described as it is known in the market. And the bulk of the goods must match with both the sample and description. Is it clear to everyone? Yes? I tell you, I will sell you grape oil. Okay? But the goods, I show you the sample and I tell you this is grape oil and I will sell you grape oil. But when I send the goods to you, it is grape oil mixed with olive oil. Can you reject the goods? What is specific purpose of the bio? For example, a lot of questions are asked from this part actually. What is specific purpose of the bio? You specify the reason of the purchase of the goods. You specify to the seller why you are buying the goods. Now, when you have told the seller why you are buying the goods and the seller selects the goods for you, you let him select the goods. Right? You let him select the goods. You don't interfere with the selection. So you depend on the seller's skill and judgment, and the seller is a dealer in those goods. Why it is important, dealer in those goods? Law ka doubt you ask me. I'm eligible to answer. Economics ka doubt you ask me. हो गया Okay. Yeah. So seller deals in those goods. Then if the goods do not suit the buyer's purpose, goods do not suit the buyer's purpose, can he return the goods back? Yes, he can return the goods. Usage of trade. Actually, tell me, do I need to tell you that I want an umbrella which protects me from the rain? हाँ नहीं हो सकता है ना. I want a fridge which makes ice. एक ऐसा एसी देना जिससे ठंडी हवा आए. Do I have to tell you? हाँ 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 एक ऐसा कैमरा देना where I can record है ना. Give me a phone which can make a call. Right? Do I need to tell all these things? I bought a phone and there is no option of putting a SIM. The shopkeeper is like, मैम आपने बोला ही नहीं you want a camera which आजकल वैसे तो camera has other purpose. Now we don't make calls. We only message. We only what? Well, ironically, honestly, I've been teaching since 2006. So ये जो internet and all no, it became more prevalent after 2012, 13, 14. WhatsApp came around somewhere in 2012, 13. WhatsApp was there. So before that, when calls were charged, and at that time, no, we did not have calls, free calls, yeah, packages. However much you call, you have to pay for that. So, उस समय students used to call us to ask their doubts. It was chargeable. They used to call us to ask their doubts. Today it is free, so students they message us to ask their doubts. Seriously, and that's the most important change that has happened. And मजे की बात ये है, they will message, please explain this. एक दो बार तो it happened that I am like कि इसको टाइप करके I cannot explain it. Everything cannot be typed and explained. No problem, ma'am. Please send me a voice note. मन तो किया. So anyway, you purchase an umbrella and you go for a walk with your girlfriend, a romantic walk, and both of you are completely drenched. You go to the shopkeeper and you tell him you gave me an umbrella. It did not even protect me from the rain, sir. You should have told me you want an umbrella which protects you from the rain. Can you claim any relief? Huh? Can you claim any relief? Yes. I don't have to say, right? I want coal which will be suitable for lighting. तो क्या कोल का शोपीस बना के रखोगे घर पे मतलब कुछ भी, right? So there are purpose for which a product is used. If the product is not suitable for that purpose, the goods can be returned back. Okay? Next is merchantability. What do I mean by merchantability? Huh? What is merchantability? Merchantability means the goods should be either saleable or a usable. See, whatever the purpose of the goods is, it should be usable for that purpose. Then we call them merchantable goods. If it is not suitable for that purpose, the goods are not merchantable. Now, tell me one thing. If the packing of the goods are defective, okay, many times you'll go to the shop to buy chips. You will see chips has no vacuum in it, right? Are you bound to buy those chips? No. Can you refuse? Yes, because the goods are not merchantable. So even if the packing is defective, that also makes the goods what? Unmerchantable. Okay? But sometimes, person may be having allergy. Like you guys have watched Big Bang Theory? You have not watched Big Bang Theory? क्या कर रहे हो हाँ? Little bit you have watched. I binge watched 8 seasons. I binge watched and then I was like, after that, so I watched it as the seasons were coming. You guys watch TV shows, movies? Which is the recent favorite or the one you're watching? Huh? Which one? The Office. I have to watch that. I'm not. My daughter was telling me you should watch that. Huh? That is why she told me you should watch that one. It's good, no? It's been a long time I've not watched. Anyway, chalo. So let's say in this character, actually, there was this one character who was allergic to peanuts. Anyway, you are allergic to peanuts and you buy something which has peanuts in it and you eat it and then you are suddenly double your size. Now you want to return the goods saying that the goods are unmerchantable. Are the goods unmerchantable? No. So personal ailment of a person does not make the goods unmerchantable. And the last one, wholesomeness, this is only in case of eatables. Okay. In case of eatable, the goods should be in a consumable state. Like you must have this, everyone has seen Cadbury may say worms. Right? Why would there be worms in the Cadbury, right? Especially वो dairy milk वाला Cadbury होता है ना उसमें. I mean, I've heard people saying that. So, huh? You've seen it seriously? Oh my god! There was this one real case where there were many cases. Like one case was a person had got flavored milk and there were typhoid germs in the flavored milk. So his wife was what? His wife was after हाँ हाँ bread. I mean exactly बिल्कुल मिलेगा उसको. So can we say the goods were not wholesome? Yes or no? There was this one case, David's son's case. There was a decomposed snake in the beer. These people, they had gone to the club and they ordered beer. Next time having. So can we say the goods are not in a consumable state? Yes or no? Is it clear to everyone? Before I go to warranties part, any implied condition you want me to explain again? No. Vaishnavi, Papa, which part of this chapter is a little tricky for you? Okay. Then can we move forward? Huh? Implied warranties. Warranty is what? Stipulations which run collateral to the main contract and a breach of which gives the buyer a right to claim damages, but no right to claim what? Price. No right to cancel the contract. Okay? The first one, undisturbed. एक चीज याद रखना, of this four warranties, no, two are conditions only. You remember we saw in the beginning, a breach of condition may be treated as a breach of warranty, right? So out of the four warranties that we have, two warranties are actually conditions which are treated as warranties. Now, what is this undisturbed possession? X stole goods from Y. Okay. X stole goods from Y and sold it to Z. First of all, will Z get the ownership of the goods? Will Z get the ownership of the goods? No. Will Z get the ownership of the goods? No. So can Y claim the goods back from Z? Can Z claim the price from X? He should have claimed the price. I don't know why he claimed the damages. Maybe he thought he can only claim the damages. Maybe he thought the goods were with me for so many days. How can I claim the price? So he should have claimed the whole price. But instead of claiming the price, he claimed the damages. This is undisturbed possession. Undisturbed possession is nothing but condition as to title treated as a breach of warranty. Right? What is it? Breach of condition as to title treated as a breach of warranty. You should have claimed the whole price. Now, ma'am, in exam, how do I know what answer should I write? If only they give till here, what are the rights of Z? You will write damages or price? You will write about price. If they say he wants to claim damages from X, then he has treated a breach of condition as a breach of warranty. Is it clear to everyone? Yes. The next one, freedom from encumbrance. Encumbrance means charge of a third party. Encumbrance means charge of a third party. Remember the special right case we had discussed? Yes. Here, who had a charge over who had a charge over the goods? B had a charge over the goods. When A sells the goods to B, I'm so sorry. I'm so sorry. I'll just repeat again. A pledged his goods to B. Later, he sold the goods to C but did not pay to B. Can we say A has sold the goods to C on which B has a charge? Yes. A has sold goods to C on which B has a charge. And can I say because of this charge, C is suffering damages because B can claim the goods from C. So what will he claim from A? When the seller sells the goods to the buyer on which a third party has a charge, and owing to this charge, the buyer suffers any damages, he can claim those damages from the seller. Is it clear to everyone? I just wanted to discuss this example. So I've given you the first two conditions. Now you will tell me what will happen. Listen carefully. X had a watch. Okay? X had a watch, and the problem was that he needed some money. So he goes and pledges the watch to Y. He goes and pledges the watch to Y. Now, when he pledges the watch to Y, after a few days, he somehow gets this watch and he goes and sells off the watch to Z. My question is, can Y claim the watch from Z? Can Y claim the watch from Z? Abhi, this is not the end. On what grounds? Because of breach of warranty as to quiet or undisturbed possession, or warranty as to freedom from encumbrances. Which one? Huh? How many of you say A? A. How many of you say B? In A, that is warranty as to undisturbed or quiet possession, the seller does not have a right to sell at all. Here, what had happened was the goods were what? Stolen goods. So, did X have the right to sell? No. So, the seller actually has no rights to sell. But in undisturbed or quiet possession, the seller has a right to sell, but it is subject to the special rights of a third party. So, this is what? Freedom from. Did you understand why, or should I explain it again? Are you sure? Dangerous nature of the goods. You will see sometimes the goods are of a dangerous nature, and the seller's duty it is to disclose the dangerous nature. For example, no Starbucks case. For example, you have seen on tobacco packets also, right? Tobacco causes cancer, smoking kills. Have you seen? Why did you have to see? No, why did you have to see? No, why did you have to see? Because in movies they show. अच्छा. First thing they show is that. वो तो अभी बहुत recent में start हुआ है. अच्छा स्मोकिंग वाला नहीं तो they just say smoking is injurious to health. वो डब्बे पे थोड़ा ही ना दिखाते हैं. डब्बे पे ही दिखाते हैं क्या? ओ मतलब आप the worst scene is like seriously मतलब मतलब आप वो बैठ के देखते हो इतना ध्यान से बट आप हाँ तो मतलब नजर चली जाती है. आई होप दैट्स द ओनली रीजन है ना. हाँ हाँ हाँ. You're addicted to cigarettes? Okay. So we don't like the movie. मतलब आदत हो गई है. हाँ. वो क्या मुझे आदत है ऐसे ना हम oh my god this Mukesh seriously has given us many nightmares. Huh? And the worst when you see Mukesh, every smoker with you will be like, see, तू भी Mukesh, तू भी Mukesh है, right? Have you done that also? Yes. I hope you are not मैं भी Mukesh, huh? So anyway, disclosure of dangerous. So why do you think they actually write it on the cigarette boxes or alcohol is alcohol is injurious to health? They write it on the bottle. तो ये कहाँ देखो? हाँ इतना दिख जाता है. हाँ उतना दिख जाता है कुछ भी. So and I was born yesterday. So tell me, why do they write? Is it their soul or conscious questioning them कि भाई इतना गंदा काम कर रहे हो तो कुछ अच्छा भी लिख दो? No, because it is their obligation. Right? Government makes it mandatory for them. So whenever the seller is selling goods which are of a dangerous nature, it is his duty to inform the buyer about it. And if he does not do that, and if the buyer suffers any damage, the buyer can claim the damages from the seller. Is it clear to everyone? Are you sure? So, the Starbucks case was there where she had bought a hot coffee, and there was this disinfectant powder case was there where it was not written on the box open with care, and the husband gave it to the wife. The wife happily opened it, everything gone, eyes gone. Can we say it was not mentioned on the box that open with care? Can we say we can claim the damages from the seller? Yes. The last one, you remember this umbrella? Remember where you should have returned the goods, but instead of returning the goods, you claim the damages. Can we say you have treated a breach of condition as a breach of warranty? Right? So these are the two conditions which are treated as a breach of warranty. Is it clear to everyone? Yes? Caveat emptor. Just because girlfriend की बात की है, everyone don't get excited and start thinking. Pay attention to the class. CA है तभी girlfriend है. हाँ. Tell me, what is caveat emptor? Let the buyer beware. Can the buyer hold the seller responsible for the wrong selection of the goods that the buyer made? No. I go to the shop. Monica is in a very singing mode. You want to sing, Monica? Huh? Mm. So you go to the shop, you see this pen, okay, and you feel this will work on your HP laptop also, and you purchase it. घर लाके you use it on the HP laptop, it's not working. Can you claim it back? Can you claim anything from the seller? Can you return it back? No. Should have been careful. So when the buyer purchases the goods, it is his duty to check whether the goods suit his purpose or not. If the goods do not suit the buyer's purpose, he has no remedies. He cannot return the goods back. लेकिन law में क्या होता है? Solution. So there are cases where the rule of caveat emptor does not apply. I'm not going into the details. I'll just give you in a gist. What? In all the implied condition, the goods are not as per sample. Can you return? Caveat emptor says you cannot return the goods back. Goods are not as per the sample. Can you return the goods back? Yes. Goods are not as per the description. Can you return the goods back? Yes. Goods are not marketable. Goods are not wholesome. Goods are not suitable for the purpose they are used. Can you return the goods back? Yes. And in case of purchase of goods under a trade name, branded goods, right? You purchase a phone and they said the phone 12 megapixel camera, front camera, you're super excited. Aaj to everywhere only my selfie. From Instagram to Snapchat, I freaking hate it. Freaks me out. Snapchat is crazy. And for freaks, people will do literally anything. Like seriously, literally anything. मतलब और कुछ नहीं. I actually once one of my friends for 15 continuous days. Finally, I messaged. I have seen, I think, every clock in your house. Thank you so much for updating me. Like, how can you be so? Oh my god. Anyway, don't get me talking. I can actually. So, what happened was, तो 12 मेगा यू आर तो लाइक आज तो स्नैपचैट से लेके व्हाट्सएप डीपी से लेके टेलीग्राम डीपी से लेके इंस्टाग्राम एवरीवेयर मेरी ही सेल्फ unboxing. You make a video for that also. Take out. It's not 12, it's just 3.2 megapixel. Can you return the phone back? Because it's not. Now the seller says, Keep it empty. Buyer should be aware. Can he do that? No. Can you return the goods back? Yes. With this, we are done. Any doubt, पूछो before we move to the next one. What? You have a doubt? For what? As if you're doing some very hard labor. Relaxing. Mentimeter? I'll start. Sorry, it's taking too long. Don't worry. Ready, everyone? Huh? What happened? Should we discuss this or you got why it is wrong? Huh? It was, I will transfer the goods on a future date. When you fulfill certain condition. What condition? When the payment is fully made. Oh my God. Only one person has voted. 5% have voted. I think there is an internet problem. अब क्या हुआ? Huh? The questions are not coming. Why? It's come. Huh? You want me to explain this? Huh? Then why did you do it wrong? Why did you do it wrong? Just A and C could be cash or kind, whereas it cannot be cash or kind. It has to be in cash. It's not actually the internet is not working, I guess. Did you get the question? B is right. Now also. How? Now I cannot correct. B. Oh, today is too much. Mhm. I think there is some issue my end on that. Oh, ma'am. Only four people go to. I don't know what's wrong. I restarted. अरे बाप रे इतना patience नहीं है मेरे में. Actually not. Just do one thing, no. Go to the office and tell him there is a Wi-Fi issue. I want to connect to directly connect it. And he will come and connect it. Tell him that also. Let's do one thing. Let's leave the quiz for the time being. Unless the internet is connected, we won't be able to do it. So that everyone can at least solve it. Let's go back to our studies. And I will make that correction also. Huh? The net is not working. Oh, yes, it can be corrected even after. No, I got it first. You go to the shop and you purchase a ready painting. It is what? Sale. You hire a painter to paint a picture for you, and he uses his skill and materials to do it for you. It is not sale. It is service. It's contract of work and material. You go to a jewelry store and you buy a piece of jewelry. It is what? Sale. You go to the goldsmith and you ask him to make a piece of jewelry for you. He uses his skill and material to do it. It is what? Contract of work and material. Who was there? Madhu Bhaiya was there. Then who did you tell? So we'll start with the next unit. Second. Now, transfer of property. Now, when we say transfer of property, there are three stages in which transfer of property takes place. Property in the goods, possession of the goods, and passing of risk. When we talk about transfer of property takes place in three stages. Property in the goods, possession of the goods, and passing of risk. Now, property in the goods means what? Ownership of the goods. Achha, one more thing. Just because I've written it in this sequence does not mean this is the sequence. In fact, there is no sequence only. Anything can happen after the other. All the three can happen together. Any one can happen after the other. It could be anything. So there is no such sequence for the transfer. First of all, when we talk about property in the goods means ownership, whereas possession means what? Physical goods. Passing of risk. Acha, tell me, risk is something which is associated with the physical goods, or risk is something which is associated with money? Loss will happen to the goods, right? So loss is associated with the physical goods. Acha, tell me, you are the owner of the goods. I have the possession of the goods. If anything happens to the goods, am I liable? No. Owner will bear the loss. So risk is borne by the owner, whether delivery or risk passes with ownership, whether delivery is made or not. So that means, can I, irrespective, let's say seller sold the goods to the buyer, but the goods are still with the seller and something happens to the goods. Who is responsible for that? Buyer, not the seller. Who is responsible for that? Buyer, not the seller. Risk passes with ownership whether delivery is made or not. Till the time seller is the owner, risk is with the seller. But once the ownership passes to the buyer, risk passes to the buyer. But tell me, I give you my phone to keep. Okay. The phone was kept. Suddenly earthquake and the phone fell down from the bench and the phone was broken. Are you liable to bear the loss? No. My phone, I will bear the loss. But ma'am, you gave it to me to keep it in the custody, but you did not do anything. But you start juggling with my phone. And suddenly, who will bear the loss? Why? Because it is your fault. So, if any party is at fault, the defaulting party shall bear the risk. So, always remember, when we talk about risk, if anyone is at fault, yes, that party. If no one is at fault, who will bear the loss? Owner. Right? Always remember, when we talk about risk, if there is any party at fault, yes, there is a party at fault, that party will bear the risk. No, there is no party at fault, owner will bear the risk. Is it clear to everyone? Are you sure? Yes. When does the ownership transfer? If the contract says, ownership will transfer after 5 days, when will the ownership transfer? If contract says ownership will transfer after payment, when will it transfer? Where the intention of the parties is known, ownership is transferred as per the intention. But when the intention of the parties is not known, depending on the type of goods, the ownership is transferred. Clear? Now, till this point, did you understand? Are you sure? If, first of all, when is the ownership transferred in case of specific goods? If the specific goods are in a what? Deliverable state. What do I mean by deliverable state? It is not the seller must give or buyer must take. It is buyer is bound to take delivery. What is deliverable state? Buyer is bound to take the delivery. It is not buyer may take or seller may give. It is buyer is bound to take the delivery. If the specific goods are in a deliverable state, when will the ownership transfer? Immediately. I go to the shop, I say to the shopkeeper, I want to buy this pen. He says, okay. When is the ownership transfer? When he says, okay. If the goods are not in a deliverable state, I go to the shopkeeper, I tell him, I want this pen. He says, okay. I tell him, look, I want, it to be packed in this particular way. He says, give me 2 days, I'll get it packed for you. When will the ownership transfer? After 2 weeks. Right? After the goods are bought to what? The buyer should be informed. So just getting the goods into a deliverable state does not transfer the ownership. The goods should be brought to a deliverable state and the buyer is in. If the seller has to conduct tests over the goods, we wait for the test. Ownership is transferred after such test. If the buyer has to conduct the test, the ownership is transferred immediately. Is it clear to everyone? Are you sure? Pakka? In case of unascertain goods, in case of unascertain goods, when is the ownership transferred? In case of unascertain goods, when is the ownership transferred? After they are ascertained and appropriated. I don't want to look into this. I just want you to understand a very simple example. I go to the shop and I say to the shopkeeper, I want to purchase a surface red color metal body pen. What type of goods are these? What type of goods are these? Are you sure? Pakka? What will the shopkeeper do? Immediately he will go to his total stock of pen and take out that pen. What has he done? Ascertain the goods. He will come and ask me, ma'am, this is the pen you want. I'll be like, this is the pen I want. Appropriate. This is appropriation. After he has taken out the goods are what? Ascertain. When he confirms the goods with me, ma'am, this is the pen. I'm like, yes, I acknowledge. Then it is what? Appropriation. Is it clear to everyone? Yes. What is ascertain? Goods answering the description are identified and set apart. What is appropriation? Selection of the goods with the consent of both the parties for the performance of the trial. Is it clear? Actually, ना वो internet नहीं चल रहा है. So yesterday he connected with a USB connector. He connected. So I want that. Huh. It was here yesterday. I don't know. It's not there. That connector is not here anywhere. This here anyway. It's not needed. So I just want it connected with this one. हाँ. but आपको USB लेके आना पड़ेगा. It was here yesterday. It's not there today.
एक मिनट फोन करता हूँ तो मैं बात करता हूँ मुझे
नो प्रॉब्लम. आप आराम से देख लो. तो मुझे इसका ये चाहिए. ठीक है.
अरे चाहिए था
नहीं अब नहीं चाहिए. हाँ नो प्रॉब्लम. हाँ here. Is it? Because morning it works. Afternoon only the problem. Morning में I don't connect it. It still works. एकदम आराम से. Maybe this vastu problem is there. From asking problem. Tell me anything you want me to explain again. Sale on approval. I give you the goods. If you like, you purchase it. If you don't, you return the goods back. When does sale on approval become a sale? Three cases. First, when I accept the goods. Second, when I retain the goods beyond the time specified. Third, when I do an act which an owner can do, like pledging the goods, selling of the goods. So this makes me the owner of the goods. But if the goods are sale on approval on cash basis, then when is the ownership transferred? Only when the cash is paid. Before I move forward, you want me to explain anything again? This part is a little, actually, in the entire chapter, if we say, this is the only part which is a little difficult. Right? Before I move on, let me tell you, I'm not going to give you a break today. We will finish off in one session. No, I'm not going to waste 30 minutes to carry on for another 30 minutes. No. So if you want a break anytime in between, I'll give you a 5 minutes break. But I'm not giving a break and then after 30 minutes break, you will go eat, come back in 1 hour. I don't want that. Okay? So anytime you want a 5 minutes break, that we will take. 5 or 10 minutes, whatever.
5 minute break
Yeah. चलो नेमो डैट क्वाड नॉन हैबिट. ठीक है. What is acha? Can you get a question like what is caveat enter? What are the lochas to caveat enter? Yes. Can you get a question like what is nemodat for non-habit? Are there any lochas to nemodat for non-habit? Yes. What are the cases where a non-owner can sell the goods? Yes. Very favorite questions of the institute if they are asking direct questions. So you have to write all of this. 4 marks. Should I write all the 8? 5 is okay. 4 mat likhna. Write 1 extra. That's okay. Minors agreement. Write a note on minors agreement. 4 marks. Will you write all the 14 rules? Khatam. Zindagi tabah. Paper wahi pe khatam. 4 marks ke liye they have given you. You write 6 rules. Abhi 6 rules bola to he is liable for tort. His acts cannot be what? He can be a partner. He cannot be a partner. What? Write all these rules. Write the first 5, 6 rules which are very important. The agreement with the minor is void. He can be a beneficiary, he can plead minority, ratification, guardian, necessaries. Those are important points right there. एक एक liner वाला मत लिखना, one liner. हाँ? Paper is over. Why they need 3 hours? Why तो paper done in 2 hours only? Obviously it will be done in 2 hours only. Memo that for non-habit. Acha, tell me, here X stole goods from Y and sold it to Z. Will Z get the ownership of the goods? Will Z get the ownership of the goods? Just a second. Huh? Okay. So can can tell me X stole goods from Y and sold it to Z. So tell me, will Z get the ownership of the goods? Why not? X himself does not have the ownership. How can Z get? So when the seller sells the goods to the buyer, if the seller does not have the rights to sell the goods, how can the buyer get the ownership of the goods? Nemo that for non-habit. लेकिन law में क्या होता है? ये चला. Right? So there are 8 cases where a non-owner can sell the goods. First, sale by a mercantile agent. Who is a mercantile agent? Basically, a middleman. Okay? He can buy the goods, he can sell the goods, he can consign the goods for sale, he can even pledge the goods. So, what are the rights of a mercantile agent? Sell the goods, buy the goods, consign the goods for sale, or even pledge the goods. So, these are the rights of a mercantile agent. Now, just because a mercantile agent is selling the goods doesn't mean it's valid. Has the possession is acting in the ordinary course of the business. That means he is not a mercantile agent for this contract alone. His general work is that of a mercantile agent. The one in black there, glasses, both of you, please kindly pay attention to me. He is not acting as a mercantile agent only for this contract. It is his ordinary course of business. It is his normal work to act as a mercantile agent. That is his business. Acting in the ordinary course of the business has the possession of the goods with the consent of the owner. That is why he has the goods because the owner gave him the goods. and he sells them to a bona fide. One thing remember, in all the 8 cases, bona fide purchaser is mandatory. In all the cases, if the purchaser is bona fide, only then he gets the ownership. If all the three conditions are fulfilled, the sale is what? Valid. The sale is what? Valid. Sale by one of the joint owners. What is joint owners? When a property is owned by more than one person, two or more persons together own the property. In RTP, I guess, there was this question about some house of memo that for non-habit. Have you read? I read this question. I don't remember whether it was RTP. I think it was RTP. The question is actually wrong because Sale of Goods Act talks only about movable property, not immovable. But don't use your brains. Write about sale by one of the joint. Sale by one of the joint owners when one of the joint owners has the possession of the goods with the consent of the other joint owners. That means the goods are in the possession of one of the joint owners with the consent of the others. And he goes and sells it. The sale is what? Valid. Ma'am, usko to consent possession ka tha. Yes, that is why it is memo that for non-habit ka lucha. If he sells it, the sale is what? Valid. The third one, sale by a person in possession under a voidable contract. A person has the possession of the goods under a voidable contract. And before the contract is cancelled, he sells it off to a bona fide purchaser. The sale is what? Valid. Please understand, it is under a voidable contract. So, before the contract is cancelled, if the contract is cancelled, it is no longer a voidable contract. So has to be only when the goods are possessed under a voidable contract. Any point you want to give me an example, please let me know. I will do it. Okay? Sale by estoppel. Yesterday, remember I explained it to you. This is whose pen? My pen. Not your pen. It's my pen. Okay? Okay? This is my pen. You pick up the pen and you turn to one of your friends and say, "This is my pen. I want to sell it to you." And I'm looking. Can I later claim the pen back from your friend? No. When the owner of the goods let buyer believe that the person who is selling him the goods has the right to sell, the sale is what? Wrong. Is it clear? Sale by a person in possession after sale. S sold his goods to B, but the goods are still with whom? S. He goes and resells the goods to C. Who will get the ownership? Who will get the ownership? C. Ma'am, B का क्या होगा? You sit and cry. Goods gone, money gone. No, no, money not gone. Money he will claim from S. Goods are gone because the new buyer gets a good title. Is it clear? That is why it is locha. Right? If you still have the possession and you go and resell them to a new buyer, the new buyer gets a good title. Okay? Can we move forward again? Yes. Then the next one, sale by a person in possession before sale. S gave his goods to B on sale on approval. B sold the goods to C. Is it valid? Yes. Yes. Automatically, as between S and D, it becomes what? Sale. Sale by an unpaid seller. When the unpaid seller, has exercised his rights of lien and stoppage and still has not received the money of the goods, he can go and resell the goods. Now, till this point, no, all these lochas were given under the Sale of Goods Act. But under the Indian Contract Act, can the finder of the goods sell the goods? Yes. And the sale is valid? Yes. If I have pledged my goods to someone and if I don't pay him the money, can he sell the goods? Yes. And is it valid? Yes. Sale by a pawnee or pledgee. Then, under the Insolvency and Bankruptcy Code, if a person becomes insolvent, liquidators are appointed, and these liquidators will what? Sell off the property. Is the sale valid? Yes. Please tell me if you have any doubts in any of the points we'll discuss before we move forward. Third point. So let's say S sold his goods to B. Okay? So when S sold goods to B, can we say B must pay? Yes. And B pays by a check which B knows is going to bounce. This is what? This is fraud. And in fraud, what will happen? The contract is voidable. I choose option. Why S? Because we cheated S. Now, before S cancels the contract, I'm writing it here. It should have been written here actually. Before S cancels the contract, B sells it to is the same value. Yes, is the same value. Provided P does not know about this. Right? Listen, when a person has the possession of the goods under a voidable contract, and before the contract is cancelled, sells it to a bona fide purchaser. The sale is what? Okay. Anything else? Acha, if it was cancelled, then would it be valid? If S would have cancelled, then it would not have been. Any other doubts? As per that, sale of goods have got really like over really quickly. Any topic you want me to explain again, please let me know. Bona fide means good faith. That is, he doesn't know that the seller has maybe not the rights to sell the goods. So he is buying it believing that the seller has a right to sell. Even this is not working. Finished. Done. So you want a break? Be back in 5 minutes. Chalo. Chalo, can we move to the, she was also in your batch. What is your name? I think. Shreya. She was also, I think, November batch, you were in an academy. Huh? Maybe she was less talkative and you guys were more talkative. Seriously, in no other classes you were the next topic. Acha, chalo, all of you, back. So, tell me, what are the rules of delivery? What are the rules? Do I need to teach the rules of delivery by the way? हाँ नहीं मैं पढ़ा ही नहीं तुझे सब कुछ ही पढ़ाया तो फिर एक को क्यों छोड़ना so tell me what will be considered as delivery whatever the parties agree will be treated as delivery shall be considered as what delivery then tell me what is the difference between part delivery and installment delivery what is the difference between part and installment delivery what is the difference between part delivery and installment delivery listen carefully I had to send you 600 kgs of goods. We agreed it will be sent in 200 kgs of 3 installments. This is what? Installment delivery. It's agreed between us beforehand that I will send the goods to you in installments. Now, if you send me this 200, is it deemed that 200 have been delivered? Or is it deemed that 600 has been delivered? It is deemed 200 has been delivered. 600 kgs I had to deliver you. 600 kgs I had to deliver you. I stocked up the. I don't care whoever. I stocked up the carrier, but the carrier was small and could only hold 450. Two options. Take out all, take a bigger carrier. But expensive, time waste. I was like, let me send it here and the rest 150 I will send later. This is what? Part delivery. Right? Will part delivery of 450 be deemed to be delivery of 600? Yes. But if later we don't send the rest of the 150, then it's a different case. Otherwise, it is deemed that the whole of the 600 has been delivered. Right? Is it clear to everyone? Yes. Then, then tell me, uh, delivery should be, let's say, you have to ask for the delivery. So you call the other person at morning 4 o'clock. Hey, hi, were you sleeping? No, no. I was waiting for your call only. You will call me, no? I want to deliver the goods today. I want you to deliver the goods today. Is it valid? No. If you have to ask for the delivery of the goods, it should be done at a reasonable hour. We both agreed that you will sell the goods to me. After 6 months, you are delivering the goods. Is it valid? 6 months क्या कर रहे थे? सो रहे थे? It should be done what? Within a reasonable time. It should be done what? Within a reasonable time. Reasonable hour and reasonable time. Is it clear to everyone? Yes. Now, if the goods are with the third party, when the third party acknowledges that the goods, he is holding the goods on behalf of the seller, the delivery takes place. If there is no place fixed for the delivery of the goods, where will you deliver the goods? At the place at which they were at the time of sale, or at the place at which they were at the time of agreement to sell. What it actually means. Whose duty is it to deliver the goods? Is the buyer's duty to take the delivery. It is not seller's duty to deliver unless the contract says so. So if the contract says that the seller will deliver, then it's a different thing. But otherwise, it is the duty of the buyer to what? Take the delivery. The seller only has to keep the goods ready at the buyer's disposal. That means whenever I made a contract with you, at the time of contract, wherever the goods were, I just have to get them ready and keep them there. I don't have to even change the position of the goods. Is it clear to everyone? Yes. Now, delivery of the goods to the carrier, it is deemed that the goods have been delivered to the buyer. It's not delivery done. It's deemed that the goods have been delivered to the buyer. Okay. Now tell me, I had asked for 600 kgs. You give me 400. Can I accept the 400? Can I reject the 400? Reject. Yes. Yes. I asked for 600. You gave me 800. Can I accept the whole 800? Accept the whole 800. Yes. Yes. Can I reject the whole 800? Whole 800. Yes. Why, ma'am? You should take 600 and reject 200. Kyun, mere ko, I'm so jobless. I will sit and do your work. Why did you send me? Take it. Can I accept? But I was actually jobless. So I accept. Can I accept 400 and reject 200? Yes. If I accept the whole of the 800, I have to pay for 600 or 800? 800 at the contract price. Is it clear? Now, deterioration during transit. Sometimes, no, like spirits. Let's say I'm sending spirits. Do you get the exact same quantity or it reduces? Some, yes. The seller sends me 100 liters of spirits and he says that whatever you receive, you only pay for that. So the seller agrees to bear the loss. When I receive, it is only 99 liters. How much should I pay for? 100. Even if the seller agrees to bear the loss of deterioration during transit, it is the seller's duty to bear that loss. Is it clear? So even if the seller agrees to bear, the law says that it is the buyer who will bear. That means the buyer has to pay for the 100 liters. Okay, this is a rule. So deterioration during transit, which are incidental to the course of transit, and the goods are sent to distant place, shall be borne by the buyer, even if the seller agrees to bear it. Is it clear to everyone? If I have never seen the goods before I accept the goods, do I have a right to examine the goods or not? Yes. Just a minute. Check anything you want me to explain, otherwise we'll go to the next one. Acha, who bears the expenses of bringing the goods to a deliverable stage? Seller. Who bears the expenses of delivery of goods? Buyer. If you have ever seen, delivery charges कौन pay करता है? Swiggy, Zomato, right? You order some goods at the neighboring shop, right? And he will say you have to give 30 rupees for delivery. That 30 rupees is borne by whom? You. Right? So who bears that loss? It is borne by the buyer. Is it clear, all of you? समझ में आया? आया या गया? Like it is here or yeah. Is it clear, all of you? Can I move to the next one or should I just wait for a minute if you want to see? Can I move to the next unit? Yes, this is the last unit of the sale of goods. What are you so excited about? Huh? I'm not leaving you after that also. LLP. ठीक है चलो unpaid seller. Who is an unpaid seller? Who has not received the whole price of the goods? Acha, tell me. I say who has not received the whole price of the goods. That means is a partly paid seller an unpaid seller? Is a partly paid seller an unpaid seller? Yes. A partly paid seller is also an unpaid seller. Why has he not received the price of the goods? Because the buyer was not supposed to pay. Or the buyer was supposed to pay but he did not pay. Supposed to pay but he did not pay. So tell me, I give you 1 month credit. In this 1 month, can I be an unpaid seller? I give you. Why did the seller buyer not pay? Because he was not supposed to pay or he was supposed to pay but he did not pay. Supposed to pay but he did not pay. So let's say I give you 1 month credit period. During this 1 month, am I an unpaid seller? During this 1 month, am I an unpaid seller? No. But after 1 month, if you don't pay, am I an unpaid seller? Yes. Yes. So, who is an unpaid seller who has not received the whole price of the goods? Now, why has he not received the whole price? Because the buyer did not pay. In what cases? First, there was no credit period. Now, when there is no credit period, the buyer should have paid off immediately, but the buyer did not pay. There was a credit period which has expired. So, when the credit period expires, he should have paid me, but he did not pay me. Again, payment was made by a negotiable instrument. What is negotiable instrument? Check, promissory note, or bill of exchange, which has been what? Dishonored. Or the buyer has become. So, if any of these four cases, the seller does not get the money, the seller is an unpaid seller. Now, this seller has rights both against the goods and against the buyer. This unpaid seller has rights both against the goods against the buyer. Rights against the goods, please understand. Rights against the goods are available when the ownership is with whom? Buyer. Who is the owner of the goods? The buyer. But who has the possession of the goods? Not with buyer. Once the goods reach the buyer, the rights against the goods will come to an end. And now if the buyer gets the, if the seller gets the goods also again, he will have no rights over the goods. Once the seller has handed over the goods to the buyer, once the seller has handed over the goods to the buyer, the rights are over. And now if the buyer gives the goods back also, the seller will have no rights over the goods. He can have rights over the buyer, but not over the goods. What are the rights against the goods? The first one, the right of lien. What is lien? Retain the possession of another. That means the goods do not belong to me, but I am keeping the goods with me to get some favor from you, to get something from you. Retain the possession of the goods of another for a purpose. Right? Retain the goods of another for a purpose. Your friend, you want a party from him because he cleared foundation with 344 marks. You take his key. Party de, fir key dunga. So you have exercised what? A lien over the goods. So what is lien? It is retain the possession. Now listen carefully. The seller has sold the goods. What has the seller done? Sold the goods. But the goods are still with whom? But goods are still with whom? S. He sold the goods, but the goods are still with S. They have not been delivered. Ma'am, how can it be that delivery is not done? Only when delivery happens, ownership is transferred. No. Ownership, even if you may not have the possession, you can still be the owner of the goods. So delivery is not the criteria for ownership. If the contract says you are the owner, you are the owner, irrespective of whoever has the possession of the goods. So S sold the goods to B, but the goods are still with whom? S. And S becomes unpaid. Why S becomes unpaid? Why S becomes unpaid? Any of the four reasons. There was no credit period expired, negotiable instrument dishonored, buyer has become insolvent. He can keep the goods with himself and not deliver them to the buyer. This is right of lien. Is it clear to everyone? This is what? Right of lien. When does lien come to an end? Come to an end means what? It's exercised and it's come to an end, or it is no longer exercisable. It is no longer exercisable. Aja, tell me, why am I exercising lien? Because you did not pay me. Now, if you pay me, can I exercise lien? No. So when the buyer tenders the payment means what? The buyer either pays or offers to pay. Or or the buyer or his agent lawfully acquired the goods. Let's say from court order. He has become insolvent. The court declares his property should be sold. So from that court order, you come and you take the goods. Right? So the buyer or his agent lawfully acquired the goods. Acha, tell me, lien means to retain. That means to exercise lien, I must have the goods and I will keep the goods. If I gave the goods to the carrier, does lien still happen? No. Lien happens only when this bottle is with me. When I give the bottle to you, where is the lien? The right of possession is gone, no? How can you retain the possession when you have them? When you don't have them, how can you retain it? So the goods are delivered to the carrier for delivery to the buyer or by estoppel or waiver. What is estoppel or waiver? The seller says to the buyer, whenever you ask for the goods, I will hand it over to you. I will never stop them. By saying this, can we say he is saying, I will not exercise rights of lien? He says to this buyer in front of everyone, he says, I will never stop the goods. Whenever you ask, whenever you demand, I will deliver the goods. Can we say by saying this, he has made the buyer believe that he will not exercise the rights of lien? Yes or no? The rights of lien comes to an end. What is waiver? To give up. Okay. You are supposed to pay me the money today. If you don't pay me the money today, from tomorrow, can I exercise lien? Yes. You are supposed to pay me the money today. If you don't pay me the money today, from tomorrow, can I exercise the lien? Yes. You come to me and you say, ma'am, please, ma'am, I will get one payment after 20 days, ma'am. Please give me some extension. And you know, no, I'm just so generous. I gave you 10 minutes break also. Right? How generous? I say, no problem. Give me after 1 month. Can I say for this 1 month, I gave up my right of lien? Yes. This is what? Waiver. Is it clear? Now I send the goods to the carrier for delivery to the buyer. What ends? Lien. But what starts? Stoppage in transit. You had, Priyanka, you had asked me for lien. Did you understand? This is what we were talking about. Okay? So, what happened was that he sent the goods to the carrier for delivery to the buyer. The moment the goods are sent to the carrier for delivery to the buyer, what ends? What ends? Lien. But what starts? Stoppage in transit. But you know what? See, stoppage in transit is when the goods are sent to the carrier for delivery to the buyer. We have already started the process of delivery. Now you are stopping the goods. You are bringing the goods back. That is a very grave thing you are doing. So you cannot do it in all the cases. You can only do it in the case of, see, in all the other cases, I still know money is recoverable. But only in the case of insolvency, the money is no longer recoverable. So it is only in the case of what? Insolvency. It is only in the case of insolvency. Is it clear to everyone? So you can only exercise it in the case of insolvency. When the seller has sent the goods to the carrier for delivery to the buyer and becomes unpaid. Why? Because of buyer's insolvency. He can stop the goods from being delivered to the buyer. How can he stop the goods? He can give a notice to the carrier, keep the goods wherever they are or bring the goods back to me. He can give a notice to the carrier, keep the goods wherever they are or bring the goods back to me. This is what rights of stoppage in transit. Is it clear to everyone? Yes? After all this, still I'm not getting my money. What should I do? Sit and cry? No, I'll just go and sell off the goods. But tell me, who is the owner of the goods? Buyer. So before I sell the goods, should I tell him or not? Dekho, bhai, ab I'm going to sell your goods. Yes, because he's the owner. So before resale, he must give a what? Notice. I send the notice, I sell the goods. Is it okay? No, then why did I even give the notice? The purpose of notice is so that we can what? We can recover the money. After giving the notice, we will wait. If he pays, fine. If he doesn't pay, I will now sell off the goods. Tell me if the goods are perishable, will you give notice? तो हो गया तब तक नोटिस जाएगा गुड्स कहीं और ही जाएगा राइट लेट्स से we gave notice and I sold the goods. Is it mandatory that you will sell it at the same price? No. I gave the notice and I sold the goods at a loss. Can I recover the loss from the buyer? Yes. Because it is because of him I suffer the what? Loss. If there is a profit, who will keep the profit? Seller. On the other hand, if I don't give any notice, whose fault is it? Seller's fault. You should have given notice. So, if there is a loss, who will bear it? Seller. But if there is a profit, who will keep it? Is it clear to everyone? Are you sure? Yes? So, these are the rights against the goods. Vaishnavi, you understood everything? Any doubt you have? Sure? Now, rights against the buyer. Rights against the buyer is available irrespective of who has the possession of the goods. Buyer has the possession, seller has the possession, makes no difference. Whoever has the possession of the goods, rights against the buyer is always available. Why am I unpaid? Because you did not pay me. Right? So what is my first right? Sue for price. Delayed payment. Interest. I gave the goods, proper time, proper place, as you wanted everything. You refused to take the goods. What now? Damage is for non-acceptance of. Is it clear to everyone? Anything you want to ask me before I move to the next slide? So, rights of the buyer. अभी इतना देर से we were talking about rights of seller, buyer also will have some rights, no? Yes. Buyer wants to take the delivery. Seller is like, yes, I will give you. Buyer is like, please, they do. I'm giving you. Please give. I'm giving you. When? I'm giving you. Why are you getting so agitated? अरे तो भाई दे दो ना. I'm giving you. But no goods. What will I sue him for? Damages for non-delivery of. If the goods have no substitute, will I sue for damages or will I sue for performance? Performance. So the next one is what? Sue for specific performance. Remember, yesterday we had done sue for specific performance. When the goods have no substitute. The Ming dynasty king Kapan. Remember that, yeah? So there I will not sue you for damages. I will sue you for the performance of the contract. If there is a breach of warranty, what will I sue you for? Damages. If there is a breach of condition treated as a breach of warranty, what will I sue you for? Yeah. So, sue for what? Damages. When will I sue you for damages? When there is a breach of warranty, a breach of condition treated as a breach of warranty. If there is a breach of condition, what will I sue you for? This is actually, if you will see, it's nothing but a summation of whatever we have done so far, right? If there is a breach of condition, what will I sue you for? I have paid you the advance money, but you did not give me the goods only. Can I sue you for restitution? Yes. So sue for refund of the advance. Is it clear to everyone? Any topic you want me to explain again? No. Auction sale. Is it an offer or an invitation to offer? Invitation to offer. Sale is complete on the fall of the hammer. In some places, they will be like, going, gone. Gone bola to gone. Gone मतलब not gone. The sale is complete. Okay? Then tell me, can the seller bid at the auction? Can the seller bid at the auction? Yes. The seller or his agent can bid at the auction, but they have to reserve the rights to bid. That is, they have to specify beforehand. Keep the right that I will also bid. If he does not reserve the rights, it is fraud. And in fraud, what happens? Contract is voidable. Acha, I can bid or I can send an agent to bid. Can I send 10 people to bid? I send her to bid for me. ये तो समझ में आया. You bid because I will be conducting the auction. I send all these 4 people to bid. Do I need 4 people? No. That means I'm trying to do what? Pretend the bidding. If only one person keeps raising the price, तो शक होगा ना. But if someone or the other people all scattered here and there bidding, will you think that it is the seller who is doing it? No. So when I appoint more than one bidder, my only motive is to fake bid. And when it is fake bidding, it is what? Fraud. And when it is fraud, again, the contract is what? Voidable. Can you get a question like what are the rules of auction? Yes, you have to write this. Is it clear to everyone? Is it clear to everyone? Yes. So if the seller appoints more than one bidder for pretended bidding, the sale is voidable at the option of the buyer. Correct? Can we have sale of goods in lots? Like instead of a single goods, we say, okay, this projector, this duster, and this camera will be one lot. Can we have this? Yes. And every lot will be a separate contract. Let's say I say first is this projector, this duster, and this camera. Second, I say this board, this green screen, and that camera stand. So they are different lots, and every different lot is a separate. Okay. Is it clear? I was trying to bid. Imagine this is a glass pen, a unique pen, one of its kind. You were the highest bidder, and while I was trying to, knock the hammer, I did not touch the bottle. I mean, the pen, but the pen fell down. Con loss better. It's a glass pen, shattered to pieces. Why should I bear the loss? See, this is the pen, it was here, and while I was knocking the hammer, it fell down. I did not throw it, it fell down. Who will bear the loss? Why should seller bear the loss? Everything seller only. Huh? Everything seller only. Who will bear the loss? Seller. Because the sale is complete after the fall of the hammer, and this happened during the fall of the hammer. Who will bear the loss? Seller. Is it clear? And with this, done. Sale of goods are done. For you all, for me, for everyone. But LLP में चले? LLP में चले? More interest in Menti than anything. You all would have been logged in only. Let's see how many of you give right answer. Seriously? After giving the right answer also. Remember when we used to do on unacademy quizzes, people used to do it on purpose. I have a question. आप कैसे कर लेते हो? आंसर जान के भी wrong answer कैसे कर लेते हो? Everyone should possess that. Huh? Wrong. After knowing the answers, also wrong answers. What is 8 people I want to see? 8 people have given wrong answer. Option B. Ah. Who is that one? Who is that one who opted for D? Constructive delivery? Huh? None of these. Who is that one? None of these. Who is that Mahan Insan? What did I tell you when the words used are contract of sale? What is it? Both. Why? It's fine only. I don't know. I cannot change like this now. I cannot. Cannot. All those, the first 10 who voted, the moment the question opened, you have given wrong answers, I'm very sure. You have given the wrong answer. You must have clicked A. See, I was so right. I taught you also, a maid's receipt is not a document of title, but it is an acknowledgement of receipt of goods. Unenforceable. Like seriously? Who is Guru? Guru Vignesh, your chocolate is also due. Yesterday you came also, no? Then why did you go? Huh? Not for the chocolate. Then for doubt. Then why did you go? Chalo, done? We'll move to the next chapter. Pehle, we will study. Last May, we will do one quiz. Okay? After LLP. Please go through the questions of Sale of Goods Act. Confusing and tricky. Hurry. Okay, limited liability partnership. The lawmakers, the motive of LLP Act was okay. Please now let's okay. The motive of LLP Act was the lawmakers wanted a business structure which had both the characteristics of a company as well as partnership. And with that motive, they came up with LLP. So basically, LLP is what? It is a hybrid of company and partnership. And that is why some point you will see common to LLP, some point you will see common to partnership. First of all, here we don't have members. What do we have? Partners. Okay, here I'm not going to teach you the characteristics or the differences we will not discuss, but LLP ka one of the most commonly asked question is actually characteristics and differences. So please do go through them. Okay. One, there is a question LLP offers a flexibility of what do you say of partnership and so that is also a very common question of LLP. But maybe this time institute will get a little innovative about their questions. Now, who are partners in an LLP? Um, can an individual be a partner of an LLP? Yes. Can a body corporate be a partner of an LLP? Yes. Individual is you and me. What is a body corporate? What is a body corporate? Body corporate means company, including foreign company, LLP incorporated in or outside India, but does not include a cooperative society, A corporation soul. Corporation soul is a single person office, like a bishop's office or a cooperative society. We have these societies, they are not considered as body corporates. Or government has been given a power that government can notify any body corporate, that from today we will not consider this body as a body corporate. But the government can never declare a company as it's not a body corporate. Company is always a body corporate. Okay? Now, when we talk about LLP, there are certain restrictions on an individual. An individual cannot become a member or a partner of an LLP if he has been declared to be of an unsound mind by a competent court and the finding is in force. Competent court means the court has the power to declare him. The court has declared him unsound mind. So till the time, let's say the court declares that for the next 5 years he is unsound and after that he will be checked. What is this settled? So for this 5 years he cannot become a partner. He has second, he has applied to the court to be declared insolvent. In partnership, only when the court declares a partner insolvent, he stops being a partner. Here, the moment he applies to the court to be declared insolvent, he is no longer qualified to be a partner. Or he is an undischarged insolvent. What is basically undischarged insolvent? The period between the court declaring him insolvent and his account being set off. His account being settled rather. So when the court declares him insolvent, a liquidator is appointed. Liquidator will realize his assets and pay off his liability. So till the day the liquidators don't settle his account. So from the date of order to the date the liquidators don't settle his account, that period is an undischarged insolvent. Okay? And in these three cases, he is disqualified to become a what? Partner of an LLP. I repeat again, if at any given point of time you feel you're not able to understand any point, please ask me again, I'll explain it again. Okay? What is the minimum and maximum number of partners? Two. Maximum is unlimited. Let's say we have three partners, A, B, C. Okay? On 15th of Jan, B was like, मतलब क्या he retired ना ना जिंदा है he retired ठीक है on 20th of Jan C was driving and while driving what देश गए ठीक है he was gone अभी let's do A and he's like friends your memories and I will continue the business continue. Can he alone continue the business? No. Minimum is what? 2. He has to bring it back to 2. But we don't tell him do it today. We don't tell him do it tomorrow. 6 months. Within 6 months, he should bring back the number to 2. If he does not bring back the number to 2 within 6 months, then after 6 months, whatever contract the LLP will make, who will be liable? A will be personally liable. I hope it's clear to all of you. Yes? I hope it's clear to everyone. So, if the number of the LLP is reduced below 2 and the LLP carries its business for more than 6 months with the reduced number, then the partner who was having knowledge of this reduction will be personally liable for obligations incurred that period. Okay? Now, we also have a concept of designated partners. See, what happens is unlimited partners. On that, even a body corporate can be a partner. So we need to have some person who will be accountable for everything. In companies, an LLP is what? LLP is a body corporate. Company is managed by directors. The same concept is designated partners. We will have two individuals who will take care of the day-to-day management of the partnership for LLP. They are known as what? Designated partners. So, can an artificial person be a designated partner? LLP is an artificial person. Then, To run the business of LLP, I appoint an artificial person. Huh? Then to run that artificial person, I will appoint someone. है ना? So designated partners have to be what? Individual. Has to be what? Individual. And when I say designated partner, how many should I have? At least two. Can I have more than two? Huh, Baba? At least bola na. Can I have more than two? Yes. Of which at least one should be what? Resident of India. What is resident of India who has stayed in India for at least 120 days in the preceding financial year? Sorry, this is during the financial year, not preceding. Now, can I just name anyone or should I get his consent? We should get his consent. And obviously, whenever we take any consent, we have to file it with whom? Registrar. This is also registrar of companies. LLP is also accountable to registrar of companies. Within 30 days of appointment, this consent will have to be filed with whom? The registrar. Is it clear to everyone? Yes. There were a lot of amendments in LLP. There were a lot of amendments in LLP, so make sure you read everything which has been amended. And then, how will I know who is the designated partner? My incorporation document will specify. And when it specifies whoever's name is given, that person will be my designated partner. And if it says that each partner will be from time to time designated partner, that is, will go for rotation, then all the partners are what? Designated. To be appointed as a designated partner, you should hold a DPIN. You remember director के लिए director identification number? Here we have DPIN. What is the DPIN? Designated partner identification number. Right? Small LLP, a new concept introduced. Small company था ना, वैसे small income LLP enjoys privileges. Right? Enjoys what? Privileges. मोबाइल अंदर रख दो प्लीज. ठीक है. अच्छा, एक बार we'll just compare it. Okay, we'll just compare it with our what? Small company. In small company, what we had? We had what? Paid up capital and what? Turnover as per PL. Now tell me, in LLP, do we have paid up capital? No. LLP does not issue shares. But the partners will bring contribution or not. Yes. So instead of paid up capital, what do we have here? We have contribution. Contribution should not exceed how much? 25 lakhs. Or such higher amount not exceeding 5 crores. Here we don't have PL. But instead of PL, they have what? Statement of accounts and solvency. So turnover as per statement of accounts and solvency should not exceed how much? 40 lakhs or such higher amount not exceeding 50 crores. You either fulfill these two conditions or if any other condition is prescribed, you fulfill that. As of today, nothing else has been prescribed. So what is small LLP? Contribution is 25 lakhs or less. Turnover is 40 lakhs or less, or it meets such other requirements as may be prescribed. Till now, no such requirement has been prescribed. Is it clear to everyone? Yes. Incorporation of LLP. Small company is a new concept. I'm not saying it is, they will ask this only, but it's a new concept. They may ask you. Incorporation of LLP. The procedure is same, but a little less as compared to company. First of all, we will need how many people? 2 or more persons. These persons will sign what? The incorporation document. These persons will sign what? The incorporation document. We will file a statement, a declaration. You remember yesterday we had done this declaration. We will file this declaration. We will actually, whenever we incorporate a company, LLP, again, we hire a professional to guide us. He could be an advocate or a CA or a CS or a CMA in practice. So this person will give a declaration, and one out of these person will give a declaration. What declaration? That all requirements of the acts have been what? Fulfilled. Right? Along with the incorporation document, along with this, we will file this what statement? What statement? That we have fulfilled the requirements of the act. This incorporation document will also state. Do you remember MOA? Yes. What were the clauses? No class. Remember, we don't have a MOA here, but the incorporation document will have these informations. Right? It will have these information. So it will state the name of the LLP, the address of the LLP, the proposed business of the LLP, name and address of partners, name and address of what? Designated partners, and other information as may be spread. If you remember incorporation of company, you will automatically remember this. All of these are already there in incorporation of company. Registrar will issue a what? Within 14 days. He will register the documents and he will issue a certificate of incorporation. The certificate of incorporation is in a company, certificate of incorporation is an evidence. But for LLP, it is what? Conclusive evidence. That no one can now question it. Right? If the LLP is incorporated by giving false or incorrect information, imprisonment which can extend up to 2 years, and fine not less than 10,000 can go up to 5 lakhs. Is it clear to everyone? Is it clear? Yes? Can we say every LLP must have a registered office? Yes. Yes. Every document will be sent where? To this registered office. Can the LLP change its registered office? Yes. And if the LLP changes its registered office, who should it inform? Registrar. If it fails to inform, the change is not valid. Is it clear to everyone? Are you sure? Yes. Name. There is a lot of amendment to this. Please be careful with amendment. Jahan amendment hai, I don't know institute will give you or not, but wherever there is an amendment, that becomes the favorite topic of the institute then. Can we say the name of the LLP should end with the word LLP or limited liability partnership? Yes. The name should not be undesirable. Right? Undesirable, using the word central, government, exchange, ban Hindus, ban Muslims, right? These are all what? Not desirable names. Or identical to the name of any LLP company or registered trademark. Earlier, no, this was like any LLP, partnership, body corporate, registered trademark or trademark to be registered. Now this is amended. It is only company, LLP and registered trademark. Okay. Ajay, what happens if by any reason the name is identical? They will order for the change of name. If name is identical, ma'am, how can name be identical? I am asking the ROC if the name is available. He is giving the name. How can it be identical? Array, to her is human, no? Maybe he thought it's not identical. He gave you the name, but it turned out to be identical, right? So, if the name is identical, let us say there is a company by the name of Okay? You started an LLP. Jokes the parts. Oh, sorry. अभी jokes apart is देखें is seeing कि देखो because of this name all my people are going to this company. Correct? Can they go and apply to the central government? Please ask them to change their name. Yes or no? Yes. The LLP or the company or the proprietor of registered trademark. You know what is registered trademark? Huh? Huh? See, I have my own classes and it goes by the name of Nitika Bachhawat classes. I've become very famous. Now the problem is, it's not a company, it's not an LLP. Anyone can use the name. And if they use my name, my goodwill will be used by them. So I go and get this registered. It becomes what? Trademark. And I'm the proprietor of the registered trademark. Within 3 years of incorporation of LLP. So please understand, they can go anytime. But proprietor can go only within what? 3 years. If you are a proprietor, there is a time ban. So let's say the trademark was registered here. Here an LLP was incorporated. So what is the time period within which I can apply? 3 years. From when? Incorporation. From trademark or LLP? अरे भाई ट्रेडमार्क के 5 साल बाद बना तो क्या करेंगे? From incorporation, here 3 years. 3 years from here, I can go and apply to the central government. Please order them to change the name. Now, if the central government feels that yes, you should change your name, the central government will order the LLP to what? And within what period you should change your name? Within 3 months, LLP must change its name. Once the name change is done, within 15 days, it has to file it with whom? Registrar. And along with the notice of change, it will also send the order of the central government. Registrar will make a record. Is it clear to everyone? What if the LLP does not change its name? What if the LLP does not change its name? The central government will themselves allot a name. The central government was like, oh, I told you to change the name and you did not change the name. Fine. Now your name is joke is on you. LLP. Okay? And now central government will change the name, registrar will make the changes. So if default is made, the central government shall allot a new name and the registrar will register the LLP in the new name. अभी बोलो किसको क्या समझ में नहीं आया मैं वापस एक्सप्लेन करती हूँ I'll just be back in a minute. You just check if you want me to explain something. Yes, there is no doubt. Huh? Okay, tell me. Another 10 minutes, 15 minutes, this chapter will be done. Let's finish this chapter. Okay? What will be the rights of the partners? How will we know what are the rights of the partners? Can we say as per the agreement? If there is no agreement, can we say as per whatever is model agreement? Can we say the rights and liabilities of the partners will be decided by the agreement? If there is no agreement, there is a model agreement given in the act. So whatever that agreement says, as per that. Now tell me, can we change this agreement or not? Yes. Any change in the agreement will be valid only when it is filed with the registrar. Now, the last point, agreement before incorporation. A, B, C are going to incorporate an LLP. They are before the incorporation of LLP, they enter into a contract on behalf of LLP. Now, LLP is incorporated. Is the LLP liable for this contract? Huh? ABC, they want to start an LLP, okay? Before incorporation of LLP, they make a contract. Let's say they purchase some goods or property on behalf of the LLP. Now, LLP is incorporated. Can we say it's kind of a pre-incorporation contract? Yes. LLP is incorporated. Tell me, is LLP liable? Hmm? If after incorporation, ABC ratify it, then they are liable. See what it says. Agreement before incorporation between persons who have subscribed their name to the incorporation document will impose obligations on LLP if it is ratified by all the partners after. So if all of them ratify it, if all of them ratify it, then the LLP will be what? Will be live. But the ratification has to be done before incorporation or after? After incorporation. Ratification has to be done after incorporation. Clear? Termination of partnership. Can I leave the firm? Can I leave the partner LLP? I was a partner of LLP. Now I want to leave the LLP. Can I leave the LLP? Yes. आप थोड़ी ना मेरा हाथ पकड़ के रोक लोगे मुझे. But I have to give what? A notice. Right? If there is an agreement between us that I will leave, then I can leave by an agreement. Otherwise, I have to give a 30 days notice. But let's say a partner is dead, a partner has applied for insolvency, then automatic termination happens or not? Yes. So it happens by default when the person is dead or when the LLP only dissolved. If my LLP dissolved ho gaya, what will you do now? LLP is dissolved or the partner is declared unsound or he has applied to be declared insolvent. In all of these cases, what will happen? He will what? He will no longer be a partner of the firm. Logically, tell me, when he leaves the firm, what will be his rights and liabilities? Huh? What will before leaving the firm? What? I mean, I'm not getting. What are you talking? Rights, liabilities. क्या बात कर रहे हो? Okay, huh? Exactly. Now you cannot say, but वही तो पूछ रही थी किस बात के लिए? So can we say that just because you've left the firm, if you have done anything while you were a partner, you are not liable? No. You will be liable for whatever you have done while you were a partner. Now the partner leaves the firm. What will he get? His capital contribution and accumulated profits after deducting accumulated losses. So he will be liable for the acts of the LLP. He is entitled to receive capital contribution and accumulated profits after deducting accumulated losses. If you just remember these charts also, no, exam में कुछ भी आएगा, you will be able to answer. Don't even focus on learning everything. Just remember this chart, khatam, story end. Tell me, can he take part in the business of the firm? Can he take part in the business of the firm? Arey bhai, you are not a partner. For what joy? For what joy are you taking part, huh? Actually, tell me. When a partner leaves the firm, a notice should be given of his leaving or not? Yes. A notice should be given for his leaving or not? Yes. If you don't give a notice to the registrar, can we say he is a deemed partner? If you don't give a notice to the registrar, or the third party does not know that you are no longer a partner, you are what? Deemed to be a partner. And whatever you do in the name of the LLP, who will be liable? LLP. Is it clear to everyone? So फिर से I am repeating, any point you want me to repeat before I move forward, फिर से बोल दो. Tell me, I repeat it again. नहीं, पक्का. Okay. A partner, his name was Gulab. Okay. And he was like, I want to change my name from Gulab to Gulab Jamun. Okay. Can he do that? Yes. But he was registered as what? Gulab. Now his name should be changed from Gulab to Gulab Jamun. Should we inform this to the LLP or not? Yes. So, if there is a change in the name or address of the partner, he should within 15 days inform the LLP. Is it clear to everyone? LLP will within 30 days of change. Within 30 days of change, LLP will inform whom? Registrar. Any person, the LLP shall, if there is any change in any person joins or leaves the firm, or if there is any change in the name or address, within 30 days, the LLP will inform whom? The registrar. Please understand, within 30 days from here, within 30 days in this case from change. What am I trying to tell is, it's not that 15 days plus 30 days. No. Yes, including the 15 days. 30 days is from the date of change only. Okay? Please, huh? Within 30 days from the date of change. If, Acha, tell me, what happens if you don't inform the registrar? I am a partner, I leave. What happens if you don't inform the registrar? In future, if they do any fraud, I will also be liable or not? Yes. So I am sure LLP is not going to inform. Can I myself go and inform? Yes. I can myself go and inform. If the partner has reasonable cause to believe that the LLP will not inform, it can file itself with the registrar that I am no longer a partner of the firm or I have become the partner. Will the registrar just record the change? No. हो सकता है you are still a partner, but you are trying to cheat your other partners. Yes or no? So the registrar will confirm with the LLP, and if within 15 days LLP does not object, they will make the changes. Is it clear to everyone? Are you sure? Should I repeat this again? Should I repeat this again? Sure. Can I move forward? Okay. If the partner of the LLP or the LLP is doing some fraudulent activity, why? To defraud the creditors or to defraud any other person or just for fraud, what will be the liability? Unlimited. What will be the liability? Unlimited. But tell me, if the LLP proves that it was done without my authority, then what will be the liability? If the LLP proves that the act was done without my authority, then what will be the liability? Ajay, listen, how many of you are using the material, right? Yash's material, right? How many of you are using the Yash's material? You all have the old material which does not have the LLP amendments. Correct? So please, I have already uploaded the amendments. Please go through. Don't read from that. Please check the amendments. Please check the amendments. In the last term, the material that was provided did not have the amendments. So please follow the amendment. Those who are following the Yashas material for this chapter, please follow up the amendments. Okay? Now, if the LLP proves, okay, if the LLP proves that it was not done with the authority, the fraudulent act was done without the authority of the LLP. If the LLP proves that the fraudulent act was done without the authority of the LLP, will the LLP be liable? No. So the LLP is not liable if it proves that the act was done without its knowledge. Is it clear to everyone? Mainly, the name clause, there is a huge change, and most of the changes are in the penalties. Okay, small LLP is a new topic. See, I'll tell you what are the changes that have taken place also, but you will not understand like this. Please get the document of amendment. This is newly added, newly inserted. Okay, this portion of designated partner, this portion and this portion of designated partner newly added. Okay, this was already there. Wherever Companies Act 1956 has been used, it will be replaced by Companies Act 2013. Okay. Then there is a change in this penalty. This is the new penalty. If you are reading the book, there is a change in this penalty. This whole name thing, this also name thing has been completely amended. Okay, then registration of change, this fine has been amended. Now this is new. Whoever is having this sheet, it is new, it is totally amended. Whoever is using this sheet, it is totally amended. Whoever is using the old material, these are the changes that have happened. Please make sure you follow the amendment. This, there is just one change. This was 2 years. Now it has been changed to 5 years. So now it is what? 5 years. This is the only change here in fraud. So please make sure you are doing the new. You did the class for November. I have taught the amendments. But the material does not have the amendment. If you have attended my class for November, I've already taught you the amendment. Look into the material, please. I mean, into the notes. Can I move to the next part? Yes. Any part you want me to explain again? Tired. Very tired. But please, you have put in so much of hard work. Literally, I think you have sat for the marathon for like 15, 16 hours total, May. Please, by next Thursday, finish off law. Sit and take up law, finish it off. After finish it in such a way that after that you just have to open, just a little before the exams, like that. Finish it off completely. And when I say finish it off, I mean including writing practice also. Whistle blowing. I mean, this whistle blowing is that I'm such a waste person, I cannot even whistle. You can whistle? I cannot. Oh. But I am such a waste person, I cannot even whistle. Huh? Everything is taken here. For us, everything is taken, huh? But 8 minutes. Here, whistle blowing is not this whistle blowing. Whistle blowing actually means the person who brings to the notice of others any fraud which takes place in the management. Okay? Whistleblowing here, whistleblowing here means any person who brings to the knowledge of everyone any wrong which is happening. Acha, I'll just tell you with an example, okay? This whole provision. Let's say ABCD are partners of a firm, LLP, and they are doing something wrong. Authorities come to know, they order investigation. ABC were like, dekh lenge. B started like, oh my god, what will happen to my family? Without telling the other partners, he goes to the authority and tells them, I will give you all the information you need. Please give me what? Relief. Don't punish me. So the investigating authorities were like, okay, we will not punish you, but you will help us in all the ways possible. I will give you all proofs, don't worry. Okay, I'll give you all proofs, don't worry. So D carries on, goes to the investigating authority and helps them to carry on the investigation and punish these people. And what did D get in return? His punishment was waived off. Or let's say he would have been imprisoned for 2 years, but he was only imprisoned for 2 months. Right? It was reduced. This is what the section is saying. The court or tribunal may reduce or waive the penalty which is leviable against any partner or employee if he has provided us useful information or the information he has given us led to the punishment of the LLP or partner or employee. So I repeat again, D goes to the investigating authorities and says, don't worry, I will give you all the information that you need for your investigation. Just please leave me. They say, okay, we will not punish you or we will give you a very less punishment. This is whistleblowing. Is it clear to everyone? Are you sure? Yes? Now, books of accounts. LLP must maintain proper books of accounts. The books of accounts can be on cash or accrual. See, otherwise, it has to be only on accrual basis. But here it can be cash or accrual on double entry system and shall be kept at the registered office. And they have to be audited also. Statement of accounts and solvency. In case of companies, we have PL. No, it's similar in nature to that. Statement of accounts and solvency within 6 months from the end of the financial year, we should prepare it. It shall be signed by the designated partners and it shall be filed with the what? Registrar. These penalties, everything has been changed. Everything is new. Okay? The penalty part. If you have attended my LLP original class for November, you have already studied all the amendments. If you have not, if you had attended May, previous year May, amendment was not there then. So then you have not attended the amendment. Account shall be audited as per the rules. Then we also have an annual return. Within 60 days from the end of the financial year, this annual return has to be filed with whom? The registrar. And it has to be authenticated. Is it clear to everyone? Are you sure? Last, winding up. Winding up can be voluntary or by the tribunal. What are the grounds when the tribunal can order for the winding up of the LLP? LLP has decided we want to wind up, but we want the tribunal to pass the order. If the number is reduced below 2 for more than 6 months, can the LLP be ordered to be wound up? Yes. The LLP is unable to pay its debts. Ma'am, why will we wind up? Arey bhai, you are taking more and more loans and you're not paying anything. Tomorrow you will declare insolvency. Paisa to gaya logon ka. You better be wound up. Okay? See, you remember books of accounts, annual returns, statement of solvency has to be filed with ROC. If you don't file it for 5 years, consecutive years, you will be wound up. Abhi 2013, 14, 15, 16, 16, 17, they did not file. 2017, 18, they filed. Again, 2019, 20, 21, 20, 23, 24, they did not file. Can they be wound up? No. It has to be 5 consecutive years. Acts against the interest of sovereignty and integrity of India and security of the state. That is that any act which puts a question mark on the security of the state or the country. I always tell you there is always one open-ended grounds. Apart from this, any other justified ground. खत्म हो गया है, we are done with the marathon session.